Good morning, everyone, and welcome to today's hearing. I'll ask Mr. Stark to read the docket.
Thank you, Mr. Chairman. Mr. Chairman, other commissioners, we're here for the proceeding in docket numbers 2019-185-E and docket number 2019-186-E. These matters concern the South Carolina Energy Freedom Act, proceeding to establish Duke Energy Carolinas LLC and Duke Energy Progress LLC's standard offer, avoided cost methodology, form contract power purchase agreements, commitment to sell forms, and any other terms and conditions necessary pursuant to South Carolina Code Annotated Section 584120A. Mr. Chairman, the hearing has been scheduled for today, October 21st, 2019 at 9 a.m. in the offices of the Commission at 101 Executive Center Drive, Columbia, South Carolina, 29210. Mr. Chairman, the dockets are in order.
Thank you. Before we take appearances, I just want to remind everyone to please do that at a microphone. We have got microphones set up everywhere, so everybody ought to be close to one. And if you're not, and you got to take 3 or 4 steps, sorry. Okay, we'll just go down the roll here. Duke Energy Carolinas in progress.
Good morning, Mr. Chairman, Mr. Vice Chairman, members of the Commission. I'm Rebecca Doolin. I'm Corporate Counsel for Duke Energy Carolinas and Duke Energy Progress. With me today, I have Brett Breischwart, who's been admitted pro hoc in this proceeding. He's with the law firm of McGuire Woods. I also have Frank Ellerby, the law firm of Robinson Gray. Lynn Anthony, who is hiding in the back, is with us as well. And I just mentioned that Heather Shirley Smith, who is our Deputy General Counsel, is here also. It's a pleasure to be before you this morning.
Thank you. Welcome. Energy users.
Mr. Chairman, I'm Scott Elliott. I represent the energy users.
Welcome. Solar Business Alliance.
Yes, sir. Mr. Chairman, Weston Adams with Nelson Mullins. I represent Johnson Development, along with Trey Gowdy, Jeremy Hodges, and Jamie Golden of my firm. Also, we represent the Solar Business Alliance. That would be me and Jeremy Hodges, along with Ben Snowden of Kilpatrick, who's been admitted pro hoc, and along with Richard Witt of the Witt Law Firm. Thank you, Mr. Chairman.
Thank you. Welcome. All right, Mr. Golden, you want to stand up again since y'all have already been?
No, sir.
Thank you. I want to give everybody their moment in the sun. Echoplexus.
Good morning, Mr. Chairman, members of the Commission. I'm Richard Witt from Witt Law Firm for Ecoplexus.
Southern Alliance for Clean Energy and South Carolina Coastal Conservation League.
Good morning, Mr. Chairman, members of the Commission. I'm Bland Hallman with the Southern Environmental Law Center, representing the Coastal Conservation League and Southern Alliance for Clean Energy. With me is Lauren Bowen, also Maya Hutt and Stinson Ferguson, also from the Southern Environmental Law Center.
Welcome. Thank you. Okay, as I understand it, Nucor Steel, Mr. Smith, Rob Smith has been excused due to a military obligation. So, Office of Regulatory Staff.
Good morning, Mr. Chairman, members of the Commission. Representing ORS is myself, Andrew Bateman. Along with me this morning is Ms. Nanette Edwards and Mr. Alex Knowles. Thank you.
Thank you. Welcome. Okay. Preliminary matters. Well, Ms. Grunman, did I not call your name?
You did not, but I'm happy to stand up. Carrie Grunman, law firm of Spillman, Thomas & Battle. I'm joined today by Lisa Perry. She is the new Senior Manager, Energy Services for Walmart. As you know, we did not file testimony in this case, don't intend to cross-examine witnesses, and would ask to be excused towards the end of today. Thank you.
Granted. Thank you, Ms. Grunman. Okay, now preliminary matters.
Mr. Chairman, just a few preliminary matters. There is an outstanding motion to compel in this docket, and we have submitted a letter this morning or an email, I'm sorry, but wanted to state for the record that that motion to compel from Duke Energy Carolinas and Duke Energy Progress to, pardon me, Johnson Development has been withdrawn at this point. So that's not a matter that the Commission needs to take up this morning.
Okay, thank you.
move on to the next item is a partial settlement that certain parties have entered into, and we realize we're bringing this to you at a rather late hour, but that is because the North Carolina Utilities Commission issued an order late Thursday addressing the solar integration services charge. As I believe this commission is aware, the North Carolina Utilities Commission was taking up similar issues in a proceeding before that commission that you will be hearing today from the parties. The settling parties are Duke Energy Carolinas, Duke Energy Progress, Johnson Development, SACE and CCL, and the Solar Business Alliance. Mr. Witt has asked me to say that Ecoplexus supports the settlement, but they are not a signatory. We have sent the settlement around to all the parties in this case, but given the late nature of the developments associated with this settlement, I think some parties are still reviewing it, but in the interest of time and in the interest of moving this proceeding forward, the parties wanted to go ahead and put that partial settlement before you. I'm happy to answer any questions about it. I understand there are copies available for you, and I can give you a very brief overview, or I can answer any questions, Mr. Chairman.
Let's do that.
Okay, great. So the settlement is specific to the solar integration services charge, and I would implore any of my opposing counsel that's been a part of working through this with me to pipe up or chime in if there's anything that I've missed here or they would like to state differently. So the terms of the settlement, again, have strictly to do with the solar integration services charge, and it adopts the charge that Duke has proposed, which is $1.10 a megawatt hour for DEC and $2.39 a megawatt hour for DEP. And those were the charges that were put forward in the company's case. And they fix that charge for the duration of the PPAs to be entered into. And that's consistent with the decision that came out from the North Carolina Commission on Thursday. Commissioner?
You said it fixes the charge for the duration of the contract. That's different than what was in the pre-file testimony. Is that correct?
Yes, Commissioner, that's correct.
Okay, thank you.
It also addresses this term that you will have read about in testimony called a controlled solar generator, and it requires the Commission to submit guidelines around what actually constitutes a controlled solar generator, and we would submit those to you by November 18th. That's set forward in the actual paragraph 3 of the substantive portion of the settlement. And in paragraph 4, that sets out the independent review process that the settling parties have agreed to, and it also describes or takes notice that the integration study that's contemplated under Act 62, that process will interrelate with the review process of the study that underlies the charges in this case. So that's provided for in paragraph 4, and I think this is about the end of it. In paragraph 5, we've just stated that the companies will make a compliance filing 15 days after the final order, unless you direct us to do it otherwise, to do it earlier or later than that. That is the gist of the substantive portions. And I'll also just offer from a procedural standpoint, the settling parties have agreed to waive cross on all witnesses that speak to the integration charge. So that's the entire portion of Mr. Wintermantle's testimony from the company, Mr. Holman's testimony from the company, Mr. Kirby's testimony from SACE and CCL. So the parties agree to waive cross of those 3 witnesses entirely, and then portions of other witnesses, Mr. Glenn Snyder from the company, Mr. Steve Wheeler from the company, Mr. Ed Burgess from SBA, and Mr. Horry, who is ORS's witness. Essentially, if your witness testifies to the integration charge, cross is waived as it relates to the settling parties. We believe that this is an expeditious way to move this case forward and will reduce the amount of time that we're here this week. And of course, the witnesses will be here and be available to answer any questions with regard to the settlement or with regard to the study or the integration charge in general. Mr. Chairman, that's what I wanted to mention with regard to the settlement. I also wanted to mention that if it's without objection from opposing counsel, we would like the commission to take judicial notice of the decisions, the notices of decision from the North Carolina Utilities Commission that have been issued. There's a notice of decision and a supplemental notice of decision, and I have copies of those if you would like them, and request that the commission take judicial notice of those two decisions. Any objection?
Mr. Golden.
Not rising to object, but what I would say is from Johnson Development's perspective, certainly we would ask that you all look at the decision that came out of North Carolina, but we recognize that you are on your own to determine what is appropriate for South Carolina and are not bound by North Carolina Commission. So just to that point, I wanted to put that on the record.
Thank you. Mr. Snowden.
Thank you, Mr. Chairman. If I may, for the Solar Business Alliance, with regard to we have no objection to the Commission taking judicial notice or of the decisions of the North Carolina Commission. I would note that the proposed that settlement relates only to the issues that are addressed in the supplemental notice of decision. There is no agreement or stipulation or anything with regard to the first notice of decision that the North Carolina Commission issued.
And that's accurate, I agree.
And I would agree with Ms. Doolin's characterization of the settlement, and note in regard to what Mr. Golden had to say is that the issuance of the decision from North Carolina Commission got the parties talking. We agreed that that what the North Carolina Commission had ordered would be a reasonable resolution of those issues in this case. But I agree with Mr. Golden that we're not proposing to adopt the decision of the North Carolina Commission.
Agree with that characterization. Thank you very much.
Yes, sir.
ORS has no objection to the commission taking judicial notice.
Thank you. Okay, and you said you have copies of that. Why don't we get one to everybody, and then we'll take judicial notice.
Okay, great, thank you. And I would just lastly add that the settling parties believe that this is a fair and reasonable solution to the issues addressed in this case with regard to the charge. We believe this will move the proceeding along quickly, and again, we apologize for bringing this the day of the hearing, but I can promise you we worked all weekend to try to get this to a resolution. So thank you for your understanding as far as that's concerned.
Okay, thank you. Anything else preliminarily?
Would council have copies of the decisions for the parties? I'm not seeing them.
Yes.
We'll get that.
Thank
you. Okay, Mr. Bateman.
ORS does not oppose the introduction of the partial settlement agreement. ORS wanted to communicate that it is currently reviewing the partial settlement agreement. Its expert witness, from my understanding, received the hard copy when I think the commissioners themselves received the hard copy. So we are currently reviewing and hope to have sort of our position back to y'all by the end of the day, but just wanted to give you a heads up. Thank you.
Thank you. Thank you, Mr. Bateman.
Mr. Chairman, I apologize. I should have, most importantly.
Get over there.
Magic. Mr. Chairman, I apologize for the interruption, but I forgot a very important point, which is that we would request that this partial settlement be entered into the record and be marked as, I believe, the first hearing exhibit.
The partial settlement will be entered as hearing exhibit number 1.
Thank you very much.
Yes, ma'am. Okay, anything else of a preliminary nature that we need to do? Yes, sir.
Mr. Chairman, SBA also filed a motion in limine, and it's my understanding that that has been resolved by agreement of the parties and does not need to be taken up by the commission. And that motion concerned an exhibit to Mr. Winter-Mantle's rebuttal testimony. And so I just wanted to make you aware of that.
Great, thank you. Okay, thank you. Anything else before we start with our first panel? As I understand that everybody's in agreement, we're going to do this a little differently today than we did last week or have done in other times. So I'll ask Duke Energy, Carolinas in Progress, to call your first panel.
Mr. Chairman, would you like to hear opening statements? We can skip that if you would like, but.
Well, I didn't know anybody wanted it.
I'm so sorry.
I was including that in my preliminary. Okay, we will entertain opening statements. Last week, we kind of got opening arguments, and I'd like to have a brief opening statement if you folks would like to do one. Who's going first? Okay. Okay.
Thank you, Mr. Chairman. I'm sorry, I should have raised that in my parade of preliminary matters.
I was just glad I could see where you were.
Duke Energy Carolinas and Duke Energy Progress come before you today supporting a comprehensive, detailed proposal for their compliance with Act 62's implementation of PURPA. Duke was an active participant in the development of Act 62 and supported its adoption by the General Assembly. In this proceeding, the company's robust and transparent application, testimony, pre-filed briefings, discovery responses were all provided in a transparent and robust manner to allow the commission's expert, interveners, and the ORS the opportunity to fully examine the company's case. The purpose of this case, on its face, is actually pretty simple: to set avoided cost rates for purchases of QF power and to set commercially reasonable terms and conditions for those contracts between the QF developer and the Duke's utilities. However, some of this simplicity has been clouded by a lot of testimony from the solar community that's really rhetoric about policy issues that are not at issue in front of this commission in this case. For instance, does Act 62 require or promote competition between QFs and utility generation? What is the economic impact of QF solar development? And does utility generation carry more risk than QF contracts? And while this has provided for some really interesting debate between the witnesses, it also creates a lot of commotion that distracts from the actual issues that are before the commission. You're going to hear a lot of testimony this week about Act 62's mandate to encourage renewable energy. And Duke agrees that Act 62 certainly encourages renewable energy. It lifts the net metering cap that was in place from Act 236. It requires a voluntary energy renewable program. It encourages further community solar, which began in Act 236. You're going to look again at the interconnection procedures to facilitate more efficient interconnection of solar. Certainly, Act 62 encourages the development of solar energy and renewable energy. But this purpose section of Act 62, for you lawyers, Section 584120, it's unique. And this is important because it's the only portion of Act 62 that is explicitly governed by federal law that Congress and FERC tasked you with implementing over 40 years ago. And in doing that, PURPA and FERC have been clear that avoided cost cannot be inflated to support a statutory goal of encouraging renewable energy. This calculation of avoided cost, which is required by FERC and governed by FERC, is not about whether the state wants to promote renewable energy. FERC has been very clear about this. States have authority to promote renewable energy in many ways, through resource selection and planning, through tax credits, but it cannot be done through the calculation of avoided cost. And the rates paid to QFs from our customers cannot exceed the real and actual costs of the energy and capacity that Duke will avoid by the QF purchase under federal law. And this isn't new. These rules have been in place for 40 years, and Act 62 cannot change that and does not change that. You'll also likely hear some testimony this week that Duke is biased against solar or anti-solar, and I just want to touch on that for just a minute because Duke's commitment to solar is unquestionable. Duke's utilities, DEC and DEP, have 4,000 megawatts of solar under contract today. And we are planning for an additional 1,700 megawatts in the next 3 years. And as we've reported in our 2019 IRPs, by the end of that planning horizon, the companies are planning for 8,300 megawatts of solar. And so there's no question about whether Duke is committed to solar. The question is, what will that cost be to our customers? And finally, I just want to mention the unique situation or position that Duke is in coming to you in this proceeding. Duke has had a long experience of implementing PURPA in North Carolina, and you'll hear our witnesses talk about their concern about stale avoided cost rates. And that's because this isn't a hypothetical issue, this is a real issue for the company, and more importantly for the company's customers. Because we've projected that over the next 15 years, our customers will overpay for QF solar by $2.26 billion. And that's because we have a lot of contracts that are set at an avoided cost rate that it no longer reflects what actual avoided cost is. And so you might ask, why wouldn't the North Carolina Utilities Commission just open up those contracts and take a look and reset the terms of them? And the reason is because legally they cannot do that. And so that's why your job here today is so important. So in summary, the companies appreciate the opportunity to be here. Our witnesses look forward to talking to you about their testimony and supporting our case. We have been pleased to work with the parties on reaching the stipulation that we did and also doing the best that we could to reach consensus in other areas to limit the scope of what you'll hear today. Thank you very much.
Thank you. Mr. Adams.
Yes, sir. Mr. Chairman, thank you for letting us be here today. I would note as an initial matter that the Energy Freedom Act does, in fact, have a very explicit mandate to promote renewable energy. The plain language of the statute, and I'm not going to read you the whole provision, I'll just read you the key piece of it. 584020 that states as follows, the intent, and I'm paraphrasing here, is quote unquote, to continue enabling market-driven private investment in distributed energy resources across the state. So effectively, that is one of the reasons we're sitting here today, is that the statute does mandate and suggest and dictate that renewable energy be pushed along in this state and build upon Act 236. With that intent in mind, it is more than a little bit surprising that the proposal that Duke has put forward, the evidence will show that it does not promote renewable energy. And every key aspect of this that we're going to be looking at today, the evidence will show that, in fact, the proposal that Duke has put forward will actually retard renewable energy development and will set us back prior to what we had before the act was passed, which would be an ironic outcome. Mr. Chairman, if you look at the various provisions of their proposal, number one, the avoided cost for energy, they make erroneous assumptions there that produce unreasonably low avoided cost for energy. Number two, their capacity valuation likewise makes erroneous assumptions on, among other points, seasonal allocation that produces an unreasonably low valuation for capacity. Number three, Mr. Chairman, power purchase agreements, both as to the large QF and as to the standard offer. The provisions that they've got, many of these provisions are unreasonable and are violative of the intent of the Energy Freedom Act. Number 4, Mr. Chairman, the legally enforceable obligation, the evidence will show that the form that they put forward to determine whether or not there is a legally enforceable obligation, that form puts obstacles in front of solar developers that are not permitted obstacles under the Energy Freedom Act. Finally, Mr. Chairman, the risk question is, you're going to hear a fair amount about that over the next 2 days, about what the risk to the ratepayers, what is the risk? And effectively, the evidence that we will put forward on the risk question will point to the risk of IOU generation in a variety of things. This needs to be considered. It's critical here. The risk that natural gas prices will go up, the risk that more IOU traditional generation that we've seen numerous failings of in the last 10 years, where you've had cost overruns, delays, and cancellations, and the millions of dollars in the case of the Duke's Lee nuclear facility, and billions of dollars in the case of VC Summer, and the risk, the environmental risk posed by coal ash, for example. Those risks need to be taken into account when we're looking at what ratepayer risk is. That's really what the Act is contemplating, is look at those IOU generation risks. So in sum, Mr. Chairman, if you take this constellation of the Duke proposal, look at all the different elements of that, I would propose, Mr. Chairman, number 1, that their proposal is not reasonable as to LEO, as to PPAs, as to avoided costs. Number 2, it thwarts the legislative intent. And number 3, it would ironically set us back to a status, regress us back in the renewable sector to a status worse than we were before the Act was passed. That certainly was not the intent of the General Assembly. I think you're going to hear some comments about subsidies and inflation. I think Rebecca's term was inflation. We're not seeking, just to be clear, we're not seeking any kind of subsidy here for the solar industry. We effectively are looking for a just and fair and reasonable calculation of avoided cost. We don't want anything more than that. That's all we want. Mr. Chairman, I will close with the words of Senator Tom Davis, who is the Senate sponsor of this bill and basically the godfather of the bill and got it done in the Senate. And this goes to legislative intent, and I think we need to keep this in mind as we consider the evidence here today. Senator Davis wrote as follows, this is in the Charleston Post and Courier, quote unquote, "It has been widely reported that this new law is about promoting clean energy, and that's partially true. But it's really about something more fundamental. It is a first and important step away from the energy production monopolies that have saddled South Carolinians with some of the highest electricity bills in the nation." Thank you, Mr. Chairman.
Thank you. Anyone? Mr. Golden.
Mr. Chairman, Jamie Golden on behalf of Johnson Development Associates. I'll save you from rehashing a lot of what you've already heard, which are vote tallies, support from wide-ranging coalitions. What I would like to say to you is this bill was supported by the South Carolina business community, these companies right here. They support our position. It was supported by the consumer advocates like AARP and like the League of Women Voters. It was supported by independent power producers. And in fact, we are here because of that coalition of support. South Carolina needs to lead on renewable energy, and it needs to set terms for independent power producers to be able to compete and operate in our state as they have in other states. Again, not here to rehash, no opposition votes. There was one lone opposition opponent to this bill, and that was Duke Energy. They opposed it at most every turn. Despite of their lobbying, it was signed into law, and we're here today. You've heard numerous times in allowable ex parte briefings and in various hearings under the Act from parties and from Secretary Bobby Hitt about the need to encourage renewable energy and the role that plays in economic development. Again, I go back, as an example, these 36 businesses signed on to this letter to Senator Rankin and the entire Senate affirming our position. We are so proud of South Carolina being open for business. That's a motto that we like to use. Our position as JDA, Solar Business Alliance, is consistent with that open for business motto. We're going to create jobs. We're going to create opportunities for companies to locate here, and we're going to drive down power prices for their employees when they come here. The South Carolina Energy Freedom Act gives this commission the power to decide avoided cost from a range of rates and inputs. The utility has come with their ranges, albeit somewhat confusing to a layman like myself. I don't confess to be an expert. We've put forth our proposals. Other parties have done the same, including ORS. And you've got to pick from that range. You know all of that. And you also know that this act sets a floor, a term of PPA contract at 10 years. Anything longer than that needs additional terms and conditions, and that's up to a 20% nameplate capacity. The other thing this does is it allows you or requires you to approve their chosen methodology for avoided cost. And I'm not asking you to deny their methodology for avoided cost. But what I do ask you to do is consider it at least. Consider if their chosen windows for winter versus summer allocation are correct. Consider the hours in which they are showing value for solar versus not value for solar. Have some of these witnesses ever visited their service territory? Because I assure you, in the summertime when you're cutting hay, there's a lot of value in South Carolina heat. There's a lot of value in those summertime power bills. To say that there's not capacity value in the summer like there is winter in a state like this, it's a fallacy. I do want to talk about one key component of the act that I believe y'all have utilized very well, and that's the independent third-party consultant. In working up this act, we worked with Chairman Mike Forrester to amend the bill to put that in there. It was extremely important to him, and he's proud of how it's been implemented. I talked to him this weekend. It gives you an amazing tool because he knows, like we all know as former public servants, we're overworked, we're underpaid, and nobody more than you seven and your staff are under more scrutiny for less time than anybody in state government. We all acknowledge that. That is a tool that you have in your toolbox, and I appreciate your use of it thus far. Again, there was one dissenting voice who didn't want the third party. That was the utility. One point you're going to hear from the witnesses is that they oppose administratively set rates for contracts over 10 years. I find that a bit troubling because they have no trouble coming to ask you for administratively set rates to charge their ratepayers. Thus is the duality of Duke Energy. I think it's an affront to you all. I think it's an affront to the citizens of the state and to the General Assembly to say that they know better how to set rates in a competitive market than you all know as well-qualified administrative panelists. I end with this, Mr. Chairman and members of this commission. I'm pleased to be back with you this week. I really am. Y'all may differ on that. Like you, I'm ready to work through this week of hearings and get through it. Like you, though, we have all put in an extraordinary amount of time. You and your staff have been through the ringer, and we appreciate the work of the staff and the work of you seven. I believe that one thing, though, I will be most proud of when we get done with these proceedings is through the fruit that comes from all of this labor, an order you issue in November that allows South Carolinians to enjoy all the benefits of independent solar power that other states have already adopted. That is the legacy that all of this work, all of this back and forth, all of the hours that we're going to spend here will bear. You have the opportunity to leave that legacy, and I thank you for that.
Thank you. Mr. Holman.
Thank you, Mr. Chairman, members of the commission. I'll be brief. You've been presented, I think, with two views of how to approach this case and last week. And one is, excuse me, that we got the status quo. Nothing has changed. And the power development system supports large centralized power plants, excuse me, going forward. The other view is that a lot changed with the Energy Freedom Act. I counted the words. There are 9,888 words in this bill. The General Assembly went on for pages to change something. They have various sections, as you've heard from Duke Energy. Net metering, integrated resource plans, avoided costs, everything. A very comprehensive bill, and those provisions fit together. Now, that's the view I think is the correct view. One is that nothing happened. The other is that a lot happened, including in the world of avoided costs. And if you look at that section of the bill, there are almost 2,000 words. Duke would have you believe that the General Assembly spent 2,000 words to say one word, PURPA, and nothing else. They could have done that. They didn't. They spent 2,000 words on avoided costs informing this process. And I think the takeaway is the General Assembly wanted you to look behind the numbers. That this avoided cost provision, the utility shows up with numbers and says, status quo, these are avoided costs, it's science, that's it, end of the story. That's not what I take away from this bill. They need you, they're depending on you, and it's a lot of work to look behind the numbers, look at the assumptions. And I think in exercising your thorough review, the focus, as Mr. Adams mentioned, is on risk. I think that's a key factor here, and that it helps to understand where the Energy Freedom Act came from, because overhanging this whole bill is VC Summer. I think we have to be honest about that. One of the big reasons this bill passed was not just because the General Assembly wanted more solar. It did. Duke admits that. Not just because they wanted competition. They wanted that too. But I think we got stung. The state of South Carolina got stung by a centralized power plant that is a $9 billion gold-plated hole in the road. So what the General Assembly said was, we need the commission to be thoroughgoing and looking for ways to reduce risk for ratepayers. And I believe that as we get into this avoided cost this week, that that's something that the commission should focus on, and that more solar helps reduce that risk. Thank you.
Thank you. Anyone else? Okay. Then let's call the first panel.
Thank you, Mr. Chairman. Duke Energy calls George Brown and Glenn Snyder to the stand.
Okay, and in this first round, we're doing just direct testimony, correct? Everybody's good.
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
And before we get going, I just wanted one friendly reminder that when we're doing any sort of testimony, cross-examination, please don't talk over each other. Ms. Tackett cannot say two words at the same time. So we want to make sure we get everything in the record. You guys will need to cut your microphones on when you get ready to speak. So.
Thank you, Mr. Chairman. We will. I'm going to start with Mr. Brown. Mr. Brown, can you please state your name for the record?
Yes, my name is George V. Brown.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy, and I am General Manager of Strategy, Policy, and Strategic Investment for Distributed Energy Technologies.
And did you cause to be pre-filed in this docket direct testimony consisting of 18 pages?
Yes, I did.
Do you have any changes to your direct testimony at this time?
I have no changes.
And so if I were to ask you those same questions contained in your direct testimony today, would your answers be the same?
Yes, they would.
Mr. Chairman, we would ask that the direct testimony of George Brown be entered into the record as if given orally from the stand.
Mr. Brown's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Brown, I would like to walk through your direct testimony with you to provide an overview of that testimony for the Commission. And Mr. Chairman, in lieu of doing the traditional summary, we thought this might be a more effective way to give the Commission an overview of our witness's testimony. So, Mr. Brown, you've said that you're the General Manager of Strategy, Policy, and Strategic Investment in the Distributed Energy Technologies Group at Duke. But could you tell the Commission a little bit more about your background and how that relates to this proceeding?
Sure. I've been with Duke for a little over 21 years in a variety of capacities. Back in February of 2014, I moved into my current position, and I've been involved in setting sort of overall business strategy for the regulated electric utilities. This is all the regulated electric utilities in all of the states that we operate in, as well as any related policy efforts that the company would be part of, and that could be regulatory policy or legislative policy related to distributed energy technology. I was involved in Act 236. That was sort of my baptism to the South Carolina legislative process back in 2014. And I've also been heavily involved in Act 62, helping the company formulate its position on the proposed legislation and helping negotiate legislation that we could ultimately support.
Could you describe the general purpose of your direct testimony?
My direct testimony discusses the requirements of PURPA and specifically the mandatory purchase obligation. I also discuss the requirements of Act 62 as they relate to PURPA.
Can you give the Commission an overview of how PURPA and Act 62 interrelate as you've described in your direct testimony?
PURPA is a federal law that was passed in 1978, and I think it's important to recall back in 1978, we had just come through some energy crisis, and there were very high oil and gas prices at the time. And one of the key goals of PURPA was to try to move away from oil and natural gas-fired generation to dampen the price effect, the potential pull on energy prices from relying on oil and gas. So the law was passed, and it requires that utilities purchase certain renewable energy at the utility's avoided cost. FERC was given the rules to develop regulations to implement PURPA, and both Congress and FERC delegated quite a bit of the details of the implementation to each individual state. And you see actually a wide variety of implementations of PURPA across the United States. Act 62 is a very comprehensive piece of legislation that addresses a number of new programs related to renewable energy as well as net metering. There is only one portion of Act 62 that is at issue in this proceeding, and that is Section 584120. That section addresses South Carolina's implementation of PURPA. Again, as I state in my direct testimony, PURPA and Act 62 require that South Carolina's implementation of PURPA should comply with FERC's regulations. You will hear things, I think, about changes to the status quo and so on and so forth, but really Act 62, in my opinion, did not expand the authority of the Commission per se. I think the Commission had the authority to do what it's doing today all along. It did require a certain volume of 10-year contracts, that each utility enter into a certain amount of 10-year contracts. And it also created a procedural cycle for the commission to follow. So those were new attributes of PURPA implementation due to Act 62.
And page 5 of your direct testimony talks about the mandatory purchase obligation. Can you tell the commission what that means?
Under PURPA, we're required to purchase power from any QF that can deliver it to us at our avoided cost. There is no limit on the amount of power that we have to purchase under the mandate, and we have to take everything that is put to us at our avoided cost.
And please describe for the commission the current financial obligation from customers, from Duke's customers, as you've described in your direct testimony.
The current approximate financial obligation of our executed contracts for QF power over the next 15 years is $4.66 billion. And we estimate that if those contracts were valued at today's avoided cost rates, the obligation to customers would be roughly cut in half, about $2.3 billion-ish dollars. I mean, it varies from day to day.
And could you describe how North Carolina has revised its PURPA implementation to address this issue as you set forth in your direct testimony?
In my direct testimony, I explained that in 2017, North Carolina adopted House Bill 589, which transitioned most of the PURPA framework to a competitive procurement framework. And I refer to CPRE in certain circumstances, or competitive procurement of renewable energy in my testimony, and that's the part that I'm referring to, 589. CPRE offers QFs in both states the opportunity to compete for 20-year PPAs at a price that is at or below the avoided cost rate.
Finally, your direct testimony describes customer protections that you think the commission should consider in implementing PURPA. Could you describe those for the commission?
Yes, I think what's important, based on our experience, is that once a utility enters into a PPA, we obviously cannot modify the contract, even if the avoided cost rates change from when we entered into that contract. This makes it very important that the commission set accurate avoided cost rates, because they will be paid by customers for many more years in the future.
Thank you, Mr. Brown.
Good morning, Mr. Snyder.
Good morning.
Could you please state your full name for the record?
Glenn A. Snyder.
And by whom are you employed in what capacity?
Duke Energy. I'm Director of Integrated Resource Planning and Analytics for the Carolinas.
Did you cause to be pre-filed in this docket direct testimony consisting of 41 pages?
Yes, I did.
And do you have any changes to your direct testimony today?
No, I do not.
If I were to ask you those same questions presented in your direct testimony today, would your answers remain the same?
Yes, they would.
Mr. Chairman, at this time I would ask that the direct testimony of Glenn Snyder be entered into the record as if given orally from the stand.
Mr. Schneider's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you, sir. Mr. Snyder, did you also cause to be prepared 2 exhibits to your direct testimony that were pre-filed with the commission?
Yes, I did.
And Exhibit 1 was a confidential exhibit which was pre-filed under seal. Is that correct?
Yes.
And Exhibit 1 was also revised and refiled with the commission on September 24th in response to the commission's order number 2019-604. Do you recall that?
Yes, I do. We reviewed the exhibit, removed some of the information that was originally designated to be confidential, and refiled.
Thank you. And do you have any further revisions to those 2 exhibits at this time?
No, I do not.
Mr. Chairman, I would ask that Mr. Snyder's revised confidential Exhibit 1 and his Exhibit 2 be marked as the next hearing exhibit, and that confidential Exhibit 1 remain under seal.
Okay, Mr. Schneider's exhibits, including pre-filed Exhibit 1 that's revised and confidential and will be held under seal, and Exhibit number 2 will be entered as hearing Exhibit number 2.
Thank you, sir. Mr. Snyder, I'd now like to walk you through a brief summary of your direct testimony to inform the Commission of the issues you've addressed in support of Duke Energy's case. On page 4 of your direct testimony, you state that the purpose of your testimony is to support the company's methodology and the calculations of avoided costs. Can you please provide the Commission with an overview of PURPA and Act 62's requirements as they relate to the company's calculation of avoided costs specifically?
Yes. Act 62 requires the Public Service Commission to approve the methodology Duke uses to calculate avoided cost rates and to fully and accurately quantify Duke's avoided capacity and energy costs. Act 62 also defines avoided cost in the exact same manner as PURPA, which should be equal to the utility's incremental cost of alternative energy, either generated by the utility or purchased from another generating resource. The requirements for the Public Service Commission oversight of PURPA implementation set out in Act 62 do not change the well-established legal standards and requirements for quantifying utility avoided cost. The foundational principle of PURPA requires the Commission to set just and reasonable avoided cost rates that make the utility's customers indifferent between purchasing QF power and utility-owned generation. PURPA, importantly, does not allow, and Act 62 certainly does not support, subsidization of QFs through higher avoided cost rates.
Thank you. So turning from that policy discussion in your testimony, on page 8, you introduced a peaker methodology that Duke used to calculate your avoided cost. Can you please describe how Duke uses methodology to calculate avoided costs?
Yes. As I explained in my testimony, the peaker methodology is a widely accepted industry standard approach to quantifying avoided cost. The peaker methodology is recognized by NARUC and state utility commissions, such as the North Carolina Utility Commission, and has been previously approved by this commission. I describe how the peaker method calculates avoided capacity and avoided energy costs using the same models and nearly identical inputs as used in the 2019 IRP. I also explain how the peaker methodology calculates avoided marginal capacity by examining the annual fixed costs associated with constructing, financing, and operating a simple cycle combustion turbine, often referred to as a CT or a peaker. I go on to explain how the calculation takes into consideration the utility's actual need for capacity. Specifically, I explain how the avoided cost calculation considers at what point in time in the future does the utility's most recent IRP project a need for capacity. For DEP, this occurs almost immediately in 2020. For DEC, their next avoidable capacity need starts in 2026, which is 2 years earlier than the first year of need identified in the 2018 IRP. With respect to energy, I explain how the calculation of avoided marginal energy is determined using IRP production cost models to project marginal costs into the future. Marginal energy value is determined by first looking at the total production cost that go into the next 10 years of operating the system. That base case is then given 100 megawatts of no-cost baseload generation. And what we do then is we take the base case relative to that change case that gets the 100 megawatts of no-cost baseload generation, and we see how much production cost savings are a result of that no-cost generation. We then take those and put it into the 9 energy buckets described in our rates. I explain how natural gas prices are a significant input into the avoided energy cost calculation, and I illustrate how gas prices have been in decline for many years, with the average cost of 10-year forward natural gas declining 25% between 2015 and 2019.
So after you explain how you've calculated the avoided energy and avoided capacity costs, you then proceed in your testimony to explain the rate design that Duke Energy used to take those calculated costs and provide them to customers. Can you please provide the Commission with an overview of the company's rate design and explain how it accurately values the energy and capacity payments that are being made to QFs in this proceeding?
As it relates to capacity, I explain the seasonal and hourly allocation of the capacity rate as determined using a loss of load expectation, LOLE, approach that was utilized in the solar capacity value study conducted for the companies by Astrape Consulting. I highlight the results of the study showing DEP to have a capacity need exclusively in the winter during early morning and late afternoon, while DEC has 90% of its capacity need in the winter and 10% of its need in the summer during late afternoon hours. With respect to energy, I describe how an economically dispatched generation fleet has varying marginal costs by season and by time of day. I explain the company's avoided energy rate design and how it aligns the value of QF energy with the season and time of day in which the QF energy is delivered. On page 27 of my direct testimony, I present figure 3 that shows the 9 distinct energy price periods spanning summer, winter, and shoulder seasons.
Thank you. And in addition to describing how you've set the rate design for the standard offer qualifying facilities, your testimony also explains how Duke plans to apply the peaker methodology and then calculate avoided cost rates for large QFs that are above 2 megawatts. You start that discussion at page 29 of your testimony. Can you please explain what the differences are between how you calculate avoided costs for the smaller QFs under the standard offer versus the large QFs, 2 megawatts up to 80 megawatts in size?
My testimony explains as it relates to larger, non-standard offer QFs, the company plans to use the same peaker methodology as described previously with appropriate and transparent updates to the inputs of avoided cost required to accurately reflect the cost avoided by a specific large QF. In particular, I explain how the company will update projected fuel costs in the model to reflect the then prevailing value of avoided fuel. I go on to explain how Duke will also use the actual load shape of the large QF in the determination of the avoided energy value as opposed to the generic baseload 100 megawatt generator used in the development of the standard offer rate. I describe how these adjustments are consistent with PURPA and Act 62, both of which envision taking into account the actual attributes of the QF when calculating the avoided costs created for consumers.
Thank you. And then the last section of your testimony, beginning on page 30, you introduced the company's solar integration services charge. Would you please briefly summarize your testimony explaining why Duke has requested approval of this charge in this proceeding?
My testimony summarizes how Act 62 requires Duke to account for costs avoided or incurred by the utility, including ancillary service costs provided by or consumed by small power producers such as solar QFs. It explains how the companies require additional ancillary services due to the integration of intermittent solar QF power, and as such have proposed a solar integration service charge to appropriately assign costs to solar generators. My testimony also introduces the Astrape study relied upon to calculate the level of additional ancillary requirements and the cost of these additional ancillaries.
And Mr. Schneider, based on your testimony, if the increased operating costs of running the system are not assigned to the solar QFs through the solar integration charge, who pays these costs?
My testimony points out two important considerations that relates to the cost of additional ancillaries. First, if the cost of additional ancillary requirements are not ascribed to the QF, then customers would unfairly be obligated to pay these increased costs through the fuel clause. Second, the companies will directly pass through savings from QFs paying the integration charge to customers in future fuel proceedings.
Thank you. And you were in the room this morning when Ms. Doolin introduced the stipulation to the Commission on the integration services charge?
Yes, I was.
And would you please summarize Duke Energy's position on that stipulation?
Duke supports the terms of the stipulation, and I believe the stipulation represents a fair, reasonable, and full resolution of all the issues in this proceeding regarding the integration services charge. Moreover, my testimony should not be construed as advocating any position that is contrary to the terms of the stipulation.
Mr. Chairman, at this time, Mr. Brown and Mr. Snyder are available for cross-examination from the parties and questions from the commission.
Thank you. Energy users. Thank you. SBA. Mr. Snowden.
Thank you, Mr. Chairman. Mr. Snyder, Mr. Brown, good morning. I'm Ben Snowden, I represent the South Carolina Solar Business Alliance matter. Mr. Snyder, just at the outset, I'd like to clarify an issue about avoided cost general issue. As you stated in your direct testimony and in your summary, when you calculate avoided cost, you were looking at the incremental value of the next 100 megawatts of QF power on the system. Is that right?
Yeah, to be clear, the next 100 megawatts is for any QF. I know today we're largely talking about solar, but it's really important to recognize that this standard rate that's being approved here is for any qualifying facility. So that could include biomass, small hydro, wind, any small generator that is a qualifying facility. But yes, okay. that is.
Okay, but those avoided cost calculations are specific to the next 100 megawatts of power and don't say anything about the previous 100 megawatts of power. Is that right?
It's the value of an incremental 100 megawatts of no-cost generation.
Okay, so when you say incremental, though, that means the next 100 megawatts, is that right?
Actually, it's a decrement. So what we do is we take the IRP, which is, here's our plan, and we say, if that IRP were to be given 100 megawatts of no-cost generation, how much would that reduce our production cost value? So we have existing plants, future plants in the integrated resource plan. The decrement of that 100 produces marginal cost savings that we then allocate into various seasons and time buckets.
Okay, so your calculation of avoided cost for that 100 megawatts of solar, which have not gone on the system, wouldn't necessarily be representative of the avoided cost of 100 megawatts of QF power that went on the system at a previous time, would it?
Can you ask that question again? I'm sorry.
The incremental avoided costs calculations you just referenced wouldn't be representative of the avoided cost of 100 megawatts of QF or of solar generation that went on the system at a previous time, would it?
It wouldn't value those historically. What we've said is if we were to take that avoided cost value and price everything today at those prices, that's where we see the value coming in. So had we done those historically at today's avoided cost prices, that's the difference. So if that's where you're going, I guess I'm...
Sure. Well, let me just ask the question again. So an avoided cost calculation today looks at the avoided costs, capacity, and energy of 100 megawatts of QF power that have yet to go on the system. Is that right?
Correct.
Okay. And that calculation is not representative of the avoided cost value of 100 megawatts of QF power that have already been put on the system. Is that right?
Yes, that's correct.
And that's because it's the incremental cost that you're calculating. Is that right?
That's right.
Mr. Brown, on page 12 of your direct testimony, you discuss what you characterize as the overpayment risk of long-term contracts. Is that right?
Assuming it is.
Actually, excuse me for a minute. I'm not going to reference a specific text, so you don't have to.
Oh, okay, all right. Yeah, I mean, yes, I do in my testimony reference the overpayment, yes.
And you state that the long-term PURPA PPAs expose Duke's customers to an overpayment risk of about $2.26 billion over the next 15 years or so?
Yes, that's correct, based on today's avoided cost rates.
Okay. And you said in your opening that projected overpayment could vary from day to day. Is that right?
Yes, it would vary depending upon what happens to actual avoided costs over time.
Okay, so tomorrow it might be more, it might be less?
Yes, it could be.
Okay, 10 years from now it might be a lot more, it might be a lot less?
In 10 years, because what we're doing is we're modeling up a fixed portfolio, and if you for a moment don't add new contracts to the portfolio, in 10 years you're only going to have a much smaller portfolio of energy remaining just through the maturation of contracts. So it will definitely be different. It's hard to know whether it will be more or less out of the money per megawatt hour. I'm pretty certain the absolute dollar amount will be lower, but that's only because you've actually already realized 10 years worth of deliveries. Okay. And so if we keep the portfolio static, by definition, it starts to materialize into actual results.
So the $2.26 billion figure, I understand it may change. That figure, just to be clear, represents the difference between the total projected payments over the life of the current PURPA contracts and what those payments would be if those contracts had been entered into at the currently proposed avoided cost rates. Is that right?
That's correct.
Okay. And to be clear, those rates are the rates that are proposed in this docket but have not been approved by the Commission. Is that right?
That's correct. Yes, that is correct.
Okay. So it's an overpayment relative to the deal that Duke would have gotten if it could have entered into those contracts at the current proposed rates. Is that fair to say?
It's an overpayment relative to today's avoided cost value, which is what customers pay for the QF.
Okay. But as you said, that the avoided cost rates go up and down. So with regard to any specific PURPA contract, you will not know whether that contract represents an overpayment or an underpayment until the term of the contract is finished. Is that right?
You will be able to see what happened in the history, and then you will be able to see today what the current value in terms of avoided costs are of the contract. And then over time, you will have to see where that contract actually liquidates compared to marginal energy at the time to determine how much that contract actually cost relative to marginal energy.
Right, but you don't know that right now.
I don't know it. I don't know it right now. No.
So, and you'd agree that the rates under those contracts, like avoided cost rates in general, they include both an energy and a capacity component. Is that right?
That is correct. Yes.
Okay. And you testified that the decline in energy rates over the last several years has been driven primarily by changes in natural gas prices. Is that right?
A good deal of it has, yes.
Okay. And it's not so much the fact that natural gas prices have declined in absolute terms, it's that they've declined more than expected. Is that fair?
I'm not sure I fully understand what you mean, more than expected.
More than they were projected to decline when those avoided cost rates were formulated.
So actually, if you look at our avoided cost rates, we don't project huge gas declines. We have a relatively flat curve. I've got a figure in my exhibit, and what's happened is over the last several years, that 10-year forward curve for natural gas has continued to come down. Again, I think it's figure 3 in my direct testimony. It's very similar to this commission has seen us purchase gas hedges, right? And then when that gas hedge moves in value, we explain to the commission what's happened to that gas hedge. A portion of that is still forward-looking, and a portion becomes realized. So if you do, let's say, a 3-year gas hedge and you're 1 year into it, you say, here's what I've realized. I bought the gas at a certain price and I've realized a gain or loss. And here's the forward-looking 2-year portion, or it's mark to market, a very common term in the financial industry. And you say, here's where we see that remaining 2 years. So you have both a realized and an unrealized. And so what Mr. Brown was describing is exactly what we're doing with solar, is that over time, you're going to realize certain gains or losses relative to what you thought gas prices were when you signed the contract, and your volumes will decline, and you'll have an unrealized portion and a realized portion.
Okay, so the main issue, correct me if I'm wrong with this characterization, the main issue that will determine whether whether their current avoided energy rates will be accurate over the life of the next set of contracts is not whether natural gas prices will rise or fall in absolute terms, but whether they'll be higher or lower than the projected rates. Is that right?
Well, here's what I would say. I think it's a combination of factors. I think the longer the rate is fixed, the greater the probability that it will be out of the money, because you have more time for the market to move relative to when you fix that rate. I mean, that's just the way it is. But in terms of your question, if you could ask the question one more time.
Just the question, well, actually, let me follow up on that, though. When you say that there's a longer period of time for it to be out of the money, I mean, that risk is symmetrical, isn't that right? It goes either way?
It could go either way.
Okay. So it's just the longer the term of the contract, the greater the likelihood that prices will diverge from what's projected right now.
That's correct.
And they could diverge up or they could diverge down.
That's correct.
Okay. So back to the question, I'm trying to be sort of clear here about what we're talking about. When it comes to looking at whether avoided cost rates that are projected right now are going to be accurate in 10 years, with regard to natural gas prices, the question isn't are they going to go up and down in absolute terms, it's are they going to go up as much as the company has projected they'll go up, or will they, is it the case that the relevant question is how will natural gas prices compare to what's projected, rather than will they go up or down in absolute terms?
Yeah, I would say, just one quick clarity. It's not projected, it's actually the market. So natural gas prices trade on a 10-year forward. The company buys 10-year forward gas to show what that 10-year market is. That then sets the rate we use for IRP planning, avoided cost planning. It's an actual market. It's not a projection. So this is what the market's trading today for 10 years forward of natural gas. So the risk then is as you move through time, does that original market price go up or down in absolute over the 10-year period? Some years you may make money, some years you may lose. Right now, what we're saying is we mark that forward position to market. It's $2.2 billion underwater.
So there is also, we've been talking about energy costs, there's also a capacity component to the decline in avoided cost rates. Is that right?
Yes, there is.
And these questions are actually mostly for Mr. Brown since they relate to his testimony. So that capacity component it's fair to say that it's a pretty big component in the decline in the total avoided cost rates as compared to the rates that were approved by this commission in 2016?
I don't know exactly what the capacity value was in 2016.
Maybe these questions, would be good for Mr. Snyder. So Mr. Snyder, did you catch that question?
Yes. I think what we've shown is the switch from a summer planning to a winter planning does change that capacity.
And that's a pretty big difference between the 2016 capacity rates and the current proposed capacity rates. Is that right?
With respect to the capacity, yes.
Okay, so for DEC, and this is for distribution interconnected projects, I'm referring to the 10-year on-peak summer capacity rate. It may be helpful to look at the red line. Okay. But would you agree, subject to check, that that capacity rate went from $6.68 per megawatt hour to 83 cents per megawatt hour?
Subject check, yeah, I believe that sounds right.
Okay, and for the analogous rates in DEP, the capacity rate went from $6.13 a megawatt hour to $0 per megawatt hour?
Correct.
Okay. And that change in capacity prices was not driven by natural gas prices, was it?
No, it was not.
Okay. Is it fair to say that the decline in avoided cost rates has been driven primarily by the addition of solar to Duke's system?
Two things we point to. One is solar addition does change what your net load, the system used to serve gross load, now it serves net of must-take solar. The other is just over the last 5 years, we've seen a shift towards more winter peaking with several polar vortex type events, we've seen our loss of load risk, as I explained in my testimony, shift from summer to winter, just given natural changes in our load. So there's two factors.
Okay.
So we've seen both have an influence.
Okay. So addition of solar to the system and a change in the company's approach to looking at loss of load risk versus in summer versus winter peaks?
It's not a change in the approach, it's just a change in what's happened. I mean, the actual LOLE has been LOLE for, decades. It's just the result of that calculation, given the load impacts. I think this commission has seen what happens during cold winter events, and load has gone higher than we would have imagined 5 years ago.
Okay. Given that one of the drivers we've just discussed about the decline in capacity rates was the addition of a lot, well, let me back up, sorry. So with regard to the calculation of avoided capacity rates, those calculations assume that over the next 10 years, thousands of megawatts of additional solar will be added to Duke's system as well. Is that right?
To be clear, it assumes what's in the ground today, contracted or obligated under 589. So what we do strip out is any incremental solar in the IRP that isn't already producing, contracted, or obligated under law was not included in our calculations. So that's an important factor because it actually benefits to the, to increase avoided cost rates. We intentionally stripped out that incremental solar because it's not yet contracted or obligated.
But you are factoring into the calculation a few thousand megawatts of additional solar that are obligated under the CPRE program or HB 589?
I believe above what's calculated might be like 1,700. I'll have to check that to make sure. We've already contracted with our first procurement through tranche 1 of CPRE. So the remaining procurement activity I'd have to validate for sure. I think it's in that neighborhood.
So is it fair to say, though, that if the thousands of megawatts already under contract and if the additional solar that you all are assuming did not go into the system, if those previous contracts had not, those projects that had the existing contracts had not gone on the system, and you were not anticipating a few thousand megawatts of additional solar, avoided capacity rates would be substantially higher. Is that right?
I think I think you quoted the dollars, so we're talking like $6 that you just said went to 80 cents. Okay, to put it in perspective, the total energy rate went from like $65 to $30. So would the $6 potentially, instead of going to 80 cents, when you tried to separate out the two factors, be it $2 or $2.50, and the other part still being because of the change in the polar vortex load we're seeing, there potentially could be a couple of dollars of capacity, but that's out of a $30 decline. So there could be a small influence in the general decline had that solar not been there.
Okay, so you would agree that, without quantifying it, that the avoided capacity rates would be higher if that solar had not gone on the system already?
Certainly would have a potential for DEC. I think in DEP, we're much more residential oriented, so the actual load shape has as big of an impact. Well, so does solar, but it's hard to quantify exactly where that would land without doing a study on that. But yeah, it would be somewhere in between, given that there's two factors.
Okay, thank you. So to go back to our discussion of marginal value and marginal cost, so at least as it pertains to avoided capacity costs, the fact that the next 100 megawatts of QF power may be worth less to the system in terms of avoided capacity, it doesn't say anything about the actual capacity value of any previous capacity of solar, does it?
Like I said, it only to the extent that there's those two factors. You're correct on the one factor that as you add more and more solar, its value declines both in energy and capacity. That's just the nature of any resource. You're going to have more of any single resource, gas resources, hydro, wind. The more you add, the less it's worth. So yes, that factor would influence it. So does this shift in our load forecast more towards winter.
Okay. So you're not claiming that the avoided cost rates that you propose in this proceeding would have accurately represented the avoided cost for those projects that are already contracted to Duke system?
I think there's a couple of dollars in there out of the $30-some decline that you could make a reasonable argument to say that capacity, would have been a little more valuable without any of the solar. So yes, I think in that big decline that we've seen, there's a small piece of that but for that solar, we might have had a slightly more incremental capacity need in the summer. That's a fair observation.
Does the addition of solar to the system affect, or has the addition of a few thousand megawatts of, give or take, of contracted solar to the system affected avoided energy rates at all?
We haven't done those calculations. We have, a fairly deep stack of CCs and CTs, so how much that depth of market on energy would have impacted it. Like I said, it's, sort of like when you buy and sell gas. Does it affect the broader market? You still do a mark-to-market calculation and say, here's what it is priced at today's market prices. So it's hard to say how much that would have had.
Okay. So, Mr. Brown, going back to the overpayment you discussed in your testimony, when you talk about this overpayment, you're comparing the actual PPA prices for projects on the system to rates that those projects could never have contracted under. Is that fair to say? To avoided cost rates, those projects would never have been subject to. Is that fair to say?
So you're saying the legacy solar contracted at the then calculated avoided cost. Mm-hmm. That's right. That's what it contracted at, the then calculated avoided cost.
Okay. But you are comparing, when you talk about overpayment, you are comparing the then contracted avoided cost rates to the current rates.
Correct.
And those legacy QFs or legacy solar projects could never have contracted under the current rates because those current rates are based on current conditions.
Well, you mean like 4 years ago they couldn't have? Right. Well, yeah. At 4 years ago they could have contracted at the current rates, but they wouldn't have because the current rates are lower than the rates they were entitled to.
But even if you had known at that time 4 years ago that what natural gas prices are going to do, those avoided cost rates wouldn't be the same as the avoided cost rates you're proposing now. Is that right?
Oh, that's correct because 4 years ago, as we said, the energy rates were much higher, largely driven by much higher natural gas prices. So at that time, energy rates were higher, yes.
But the capacity rates have also gone down, as we've discussed, in part due to the addition of solar to the system. Is that right?
That's my understanding, yes.
Mr. Brown, I assume you're familiar with the North Carolina Renewable Energy and Efficiency Portfolio Standard, the REPS program?
Yes, I am.
Okay, and that program was mandated by the North Carolina General Assembly, right?
Correct.
And it requires investor-owned utilities in North Carolina to meet up to 12.5% of their energy needs through renewable energy resources or energy efficiency measures. Is that right?
That's correct.
Okay, and that program includes a solar set-aside.
It does have a small solar set-aside, yes.
Is it the case that Duke satisfies most of its obligations under the REPS program with RECs from QF solar facilities?
I don't. I'm going to have to speak generally.
Understood.
Because I'm not responsible for the REPS compliance, and I'm not up to date with the latest compliance filings. I know a good deal of our compliance comes from energy efficiency programs. I don't know off the top of my head the relative percentage of energy efficiency compared to solar RECs.
Okay. So, Mr. Brown, in your testimony, in your direct testimony, you discussed the CPRE program authorized under North Carolina HB 589. Is that right?
Yes.
That's the competitive procurement of renewable energy.
Yes.
Okay. And you say that you characterize CPRE as another option that Duke offers for QFs to sell their power to Duke under longer fixed contract terms?
Yes.
Okay. And is it fair to say that Duke would prefer to procure additional power through CPRE contracts rather than through PURPA PPA, traditional PURPA PPAs at fixed rates?
I would say generally, yes. In North Carolina, the option for QF is either a 5-year contract if they're over 1 megawatt, or they could participate in CPRE if they're over 1 megawatt. I mean, you don't have to be over 1 megawatt, but realistically, that's what's available to you in CPRE. And if it's below 1 megawatt, they can get a 10-year contract. I mean, I think, again, we're speaking of North Carolina today, so, or at least I am. So I would say that, you know, we feel that a 5-year contract is also a reasonable option for QFs if they want to pursue that.
Okay. Well, I read your testimony, and now I'm speaking specifically of South Carolina. I read your testimony to suggest that Duke would rather contract with QFs through the CPRE program rather than a traditional PURPA PPA. Is that right?
The benefit of the CPRE program is that we're able to deliver solar below avoided cost, and we're also able to get a certain amount of curtailment embedded in the contract that we can utilize to optimize the system economically. And in a traditional PURPA PPA, you cannot require those things. You're going to have to buy at avoided cost, not below avoided cost, and you can't economically dispatch the solar. You can only curtail it in the event of system emergency.
Okay. And when you've previously testified to this commission about CPRE program, haven't you?
Yes, I did an allowable ex parte.
Okay. And you said much the same thing to the commission in that allowable ex parte. Is that right?
Yes, that is what I said. And one more thing that is good about CPRE is there is a defined volume that we are targeting. And in PURPA, we don't have any control on the volume. The volume can be 0, it can be thousands of megawatts. It depends on what the QFs are able to do.
Okay. So you have told the commission that CPRE PPAs are beneficial to ratepayers?
Yes, I have.
Mr. Snowden, let's hold that thought, and we're going to take about a 10-minute break. We'll be back in 10. All right, Mr. Snowden.
Thank you, Mr. Chair. Mr. Brown, I believe I just asked you a question about CPRE, but I did notice during the break that you were conferring with your attorneys. Do you mind if I ask what you were talking about?
I was asking them how late that they were at the office last night working on the stipulation.
I can attest to that. They're pretty late. Okay, thank you. But you were not discussing your testimony, were you?
No.
Okay, wonderful. Thank you. Okay, so Mr. Brown, going back to CPRE, I mean, you have testified to this commission that those CPRE contracts are in the benefit of ratepayers. Is that right?
Yes.
And the reasons for that, if I may, they have long-term rates that are lower than avoided cost. Is that correct?
Yes, that's one reason.
All right, and they have, but it's a fixed 20-year rate. Is that right?
It is a fixed 20-year rate.
Okay, and the company gets limited dispatch rights under those contracts?
Company gets limited dispatch rights under the contracts. The company also gets to count them for North Carolina reps compliance purposes.
Okay. And just to be clear, going back to the limited dispatch rights, those dispatch rights are pretty limited, aren't they?
Yes, it's a volumetric limit.
Okay, and when you say a volumetric limit, you mean that the company has only has the right to curtail the output of those projects by a certain percentage without having to pay the QF for curtailment. Is that right?
That's correct, a certain percentage, and I believe it's 5% for DEC and 10% for DEP.
Okay, and so if Duke curtails a QF project or a CPRE project any more than that, then it has to pay the facility the amount it would have been paid if that energy hadn't been curtailed. Is that right?
It depends on the reason for the curtailment. If the reason is because of a system emergency, I don't think we have to compensate the QF for that. But if we do it for just like an economic reason, then yes, we would have to compensate. Realistically, we just won't do it other than in system emergency. I don't believe after the allotment of 10%.
Okay, and you have the right to you have the right to curtail any QF during a system emergency. Is that right?
That's correct.
It's not limited to CPRE projects.
Correct.
Okay. And Duke has not proposed a dispatchable PPA in this docket, has it?
I am not aware of in this docket. When you say dispatchable, do you mean curtailable?
Curtailable in the same way that a CPRE project is.
No, we have not put that into this docket.
Okay. And how many of, back up. Are there any other advantages to Duke of procuring solar capacity through CPRE?
I mean, the other advantage I briefly mentioned is that it's a defined quantity and that it's competitive. Therefore, it reflects the actual market cost to develop solar because we conduct a competitive process. So the developers have to compete with each other for volumes. We also have provided some guidance in terms of locations where the grid is more congested than other locations to try to minimize the amount of churn in the study process and to also help guide developers to places where they can be more efficient in terms of connecting to the grid.
Okay, thank you. Are there any other advantages to the company of procuring solar capacity through CPRE?
I mean, none that come to my mind right this minute.
Okay. Well, at least in North Carolina, Duke is authorized to rate base the cost of network upgrades that are associated with the winning CPRE projects, isn't it?
Yes, the North Carolina portion of network upgrades will be put into rates subject to prudency review.
Okay, and under traditional...
Mr. Snowden, make sure you get close to that mic because they were losing you over live stream.
Okay, thank you. So you just for the benefit of those watching at home, you just testified that the network upgrades for CPRE projects would be included in the rate base for North Carolina. Is that right?
That's correct.
Okay. And under a traditional PURPA PPA, the project has to pay for those network upgrade costs. Is that right?
In a Yes, in a state jurisdictional queue, which is what you have to be in to be eligible for CPRE, the project would have to come up with the upfront cost of the network upgrades. That is correct.
Okay, and Duke doesn't get rate recovery on those network upgrade costs?
Duke does not, because it reduces, it's a contribution made by the developer.
It's also true, isn't it, that Duke's unregulated affiliate has the right to bid into CPRE, isn't it?
Yes, it is true.
Okay, and so if it wins, if Duke's unregulated affiliate wins a CPRE contract, and the revenues from that contract go to Duke's affiliated company, is that right?
That's correct.
Okay. Also, CPRE bidders can offer to sell their projects to Duke outright rather than get a PPA, correct?
They can sell the projects within the solicitation if they so choose to, correct. That was part of the negotiation of the act. Several solar developers wanted that option to be able to sell the project to Duke Energy.
Okay, and that's referred to as an asset acquisition proposal in the program?
An asset acquisition proposal, and I should clarify that only the utilities, Duke Energy Carolinas and Duke Energy Progress, can actually buy those through that RFP process, through the CPRE process.
Okay.
The affiliate cannot buy it.
Understood. How many megawatts of projects were procured in CPRE Tranche 1?
I believe it was approximately 550 total.
And what was the target amount for Tranche 1?
It was originally 680.
Okay. So Duke was unable to get bids for the full amount of, or qualifying bids that would commit to PPAs for the full amount of the Tranche 1 that was targeted.
In DEC, the Duke Energy Carolinas, we were unable to get to our 600 megawatt goal. In DEP, we did achieve, in fact, slightly exceeded the 80 megawatt goal we had in DEP.
Okay. And between the asset acquisition proposals and bids from Duke Renewables, the unregulated affiliate, how many megawatts of projects did Duke win in CPRE Tranche 1?
I'm going to have to go from memory. So I believe when all was said and done, the total, and you want me to add regulated and non-regulated combined? Okay.
I can give you a number if it would be helpful.
I mean, I think it was about 180 megawatts, I want to say. Is that right?
Well, it may be different. I understand that there was a project that dropped out later. The number that I have is 270 megawatts, or about 45% of the total capacity awarded.
I think that was not the final list.
That was the number that was included in the press release that Duke issued on the...
Yes, that was the press release, but the final list, I actually have this. If you want, I can... It's about 189 megawatts is what Duke ended up with, so I was ballpark right.
You're probably better at fast math than I am. What percentage of the sort of total was that, you think?
Not as fast as you might think. I guess it's about a third.
And is it safe to say that Duke and its affiliated companies will financially benefit from winning those projects in CPRE?
Duke, I would say it's safe to say that we are comfortable with the returns that we got from the bids we made. Yes.
So it's a yes.
Yes.
But the company will benefit more than it would have if the same amount of solar had been procured through a traditional PURPA PPA. Is that right?
Yes. And that was, again, intentional as part of Act 589. Part of the, I guess, deal was that Duke was going to be allowed to compete. And so that's why the Act was very clear that Duke is allowed to compete.
That was the judgment of the North Carolina General Assembly.
The North Carolina General Assembly, that's correct.
Thank you. And how many of the projects that won CPRE are located in South Carolina?
I believe 4 projects.
Is it 3, totaling about 57 megawatts?
Sorry, 3, yes.
Okay. Right. So total 57 megawatts, so somewhere around 10% of the total?
That's correct.
Okay. How many projects with energy storage won CPRE contracts, if you know?
I believe, hold on. believe two. One's energy storage. That's what I recall.
So based on that, I mean, you would agree that there are already utility scale solar plus storage projects under development by small power producers in Duke service territories?
It appears to be that way, yes.
Okay. What was the average all-in PPA rate for winning projects in CPRE?
It was, I'm going to, again, have to make it approximate, but it was approximately $37 per megawatt hour.
Would you agree, subject to check, and this may be subject to check based on the project's dropping out, but that it was $37.75 a megawatt hour?
That sounds about right.
And about $38.81 for DEP?
That sounds right.
Okay. Those rates are quite a bit higher than the rates that are proposed in this docket, aren't they?
Yes.
Okay. And what is the deadline for projects to go in Tranche 1 to go online, as stated in the RFP?
Stated in the RFP, it was June 30th, I believe, of 2020 was the target.
Would you agree that it was July 2021?
Sorry, 2021, that's what I meant. Yes, I'm sorry about that. And it may be that some of them may be late, just depending upon what happens. You know.
So it could be 2 years or so before, another 2 years before.
Right.
So to sum up, you have testified that it is in the interest of ratepayers for the company to contract with a defined volume of solar projects that have 20-year fixed-rate PPAs with at avoided cost rates higher than the ones proposed in this proceeding, with limited dispatch rights. Is that correct?
Yes, I would say one important caveat is that at the time, the avoided cost rate to beat was higher than where avoided costs are today.
Okay. And as you did just state,
I'm sorry, there's one other, I think, just for clarity, they're not, you can't compare the two rates. It's a 20-year cost cap, and and the rates in this proceeding are a 10-year. So when you look at the 20-year cost, it has a higher projection of long-run natural gas that influence that 20-year rate versus the 10-year rate, which is lower.
Understood.
So they're just not comparable.
So a 20-year contract that was at the 10-year rate would be a very substantial discount from a 20-year contract at the 20-year rate. Is that right?
Yes, the 20-year rate is above the 10-year rate.
Thank you. Mr. Brown, you discussed North Carolina HB 589 at some length in your direct testimony. Is that right?
Yes.
Okay, we've just talked about it a few minutes ago. And you testified that in HB 589, the North Carolina General Assembly made a decision to move PURPA implementation in the state away from long-term PPAs at avoided cost and towards the competitive solicitation model. Is that right?
That's correct.
Okay. Is it fair to say that Duke would also like to see South Carolina move away from the PURPA PPA model to a competitive solicitation model?
I would say that Duke believes the competitive model is a preferable model to the traditional PURPA, non-controllable, unlimited mandate program. But I also know that Duke Energy was supportive of X62, and in X62, it says that we will offer 10-year PPAs, fixed price PPAs for up to 20% of our South Carolina peak when PPAs and interconnection agreements reach 20% of our South Carolina circuit peak, in which case the commission will decide after that. So we do continue to believe that competitive procurement is a better way, and I think the Act 62 actually has a provision that allows the commission to do competitive procurement if it believes it's in the customer's best interest.
So you would agree that Act 62 does address a number of aspects of PURPA implementation in South Carolina, right?
Yes, it does. Mostly contract term is the biggest thing that I see it addressing specifically. Everything else I think looks fairly much like for the commission to go ahead and exercise its jurisdiction over the avoided cost rates under PURPA and FERC.
Okay. So it's fair to say that the South Carolina General Assembly did not decide to move this state's implementation of PURPA away from fixed price PPAs and towards a competitive solicitation?
I would say based on Act 62, the South Carolina General Assembly has supported and decided to promote renewable energy through a limited volume of 10-year fixed price contracts.
Okay, so you would agree that Act 62 did not seek to move South Carolina's implementation of PURPA away from fixed rate PURPA contracts and towards a competitive solicitation. Is that right?
I think for that specific volume, the answer is yes, it did not seek to move it away from that specific volume. I think after that, I think the road is less clear as to what will happen in terms of the implementation of PURPA.
And you just referenced something important. You mentioned this, that the obligation to enter into 10-year fixed price PPAs only clearly is established until the utility hits 20% of what's the criterion?
South Carolina retail peak.
Okay. And so you'd agree that there's a limitation then on the number of contracts, the number of projects that can get 10-year fixed price PPAs as authorized under the statute?
I believe the statute was definitely designed to try to limit it. Okay. I have to say the mechanics of how the utility is actually going to ensure that it's only entering into that number of contracts, I think that has to be worked out still, exactly how that works, because interconnection agreements and PPAs get executed at different times for the same project often. So I think from a legislative intent standpoint, that 20% was what was intended for the 10-year rate, yes.
Okay. But in your testimony, you'd agree that you do testify, I think it's on page 16 of your testimony, that the company, that paying above market avoided cost prices over a long period of time for an infinite number of QF contracts results in the overpayment obligations you described. Is that right?
That's correct.
Okay, so just to be clear, under Act 62, the company is not facing an infinite number of QF projects, is it?
No, I think we are facing an infinite number of QF projects. We're facing 20% of peak for 10 years, at least. And then after that, it depends. It depends on what the commission does and what contract terms are after that.
Okay, well, when it comes to projects that are likely to contract under the avoided cost rates and methodologies and contracts that are at issue in this proceeding, you'd agree that there's not an infinite number of QFs that would be eligible for those rates and terms. Is that right?
Well, that gets to the mechanics that I was talking about earlier. So we have already started offering 10-year contracts. Once they pass the act, we started offering 10-year contracts in South Carolina at the rate that we thought was fair. And we will continue to do that. I think where it gets difficult is sort of continuously monitoring our progress on that 20% of peak thing and how we notify the commission in a timely manner and take action.
But that's a practical problem.
That's a practical problem. But I think you're correct in stating that we know for 20% of peak, we have a minimum of 10-year contracts. And after that, it will be up to the commission.
And you would agree that the whole purpose of that 20% cap was to limit Duke's exposure to fixed price PPAs under PURPA. Is that right?
I think it was based on when I was involved in the discussions, I think there was good back and forth about what is the right approach with respect to contract length. And I think the General Assembly settled on this approach to try to contain what could be an overpayment problem. I don't think it's absolute, but I do think that was what the goal was of the act. Yes.
So the 20% cap exists to, in your view, to contain a possible overpayment problem.
If the commission decides that's the right direction to go to after the 20%.
Okay. And you said you were part of the conversations of the company about Act 62, is that right?
That's correct.
Okay. And did Duke, would it be fair to say that Duke advocated for this 20% cap?
I believe what I recall, based on the conversations that I was in, we did say that we believe there should be some limit on this predetermined contract length. That's my recollection, that we did bring that up. It could be that the other side brought it up first. I can't remember who actually brought it up. But I think both sides pretty quickly were okay with that, from my recollection. I think the issue was still we hadn't quite landed on the 10-year, but we had sort of a concept that there was a limited amount that would be subject to wherever we land on the 10-year.
Understood. Okay, so but to go back to that, there are a limited number of projects that will be able to contract under the rates and terms that are established in this proceeding. Is that right?
Above 2 megawatts, that's right. I think the standard offer may be a different ballgame, but we're talking the big stuff right now, yeah.
Okay. And would you also agree that that there are other limitations on the practical ability of an infinite number of solar projects to go online in South Carolina?
Yeah, I mean, I think at some point, realistically, I think there will be difficulty to connect. I think primarily because of interconnection costs that will ultimately, because the interconnection costs will have to be, borne by the developer under the rules. Now, one thing to remember is that, yes, the developer has to come up with the costs, but they only will incur those costs if the PPA enables them to pay for those costs. That's why the North Carolina Commission agreed to rate base, because we take the revenue requirement from the upgrade and deduct and add it to the PPA price to compare it to the avoided cost.
That's specific to CPRE, though, isn't it?
That's specific to CPRE, but the concept remains that the developer's only source of revenue is the contract price during the contract period. So if that contract price is sufficiently high, then they will be able to afford the network upgrades.
Because the developer has to pay the entire cost of interconnection out of its revenues from the PPA.
That's correct.
Right? Okay. And so, as you said, interconnection costs will be going up over time as more projects are added to the grid. Is that your expectation?
My belief, yes.
Okay. And would you also agree that interconnection times, study times will probably go up as well?
The study times may or may not go up as much. It depends. But what will take time is interconnecting the facility, literal interconnection. Just because there's only so many crews, and there's storms that happen and crews get dispatched to storms, and I mean so you just there's sort of some natural limit. I don't know exactly what it is that you could connect every year.
Okay, so it takes a long time to do the interconnection work, right?
It can.
Yeah. Are you aware of, does Duke have a sort of standard expectation for the amount of time it takes to do interconnection work on a project that requires network upgrades?
I am not aware of what the standard time would be, no.
Okay. But you are aware that the interconnection study queue is already pretty well backlogged, right?
Yes, I am.
Okay. So, and as you said, the limited availability of interconnection crews will also tend to make interconnection take longer the more projects seek to interconnect. Is that right?
Yes.
So would you agree that interconnection study times and construction times will naturally inhibit the interconnection or the development of additional QFs in South Carolina?
I think it will delay it, possibly. It depends what happens to the cost of solar.
Okay. Going back to Act 62, I got sidetracked, I think, but we were talking about Act 62 and competitive solicitations. And what does Act 62 say about competitive solicitations?
I don't have the exact thing in front of me, but essentially what it says, there's one section or subsection, I'm not sure what you call it, of the PURPA section that says that the commission is authorized to open a docket, I think, to explore the benefits of competitive procurement of renewable energy, if it's in the interest of customers, or something to that effect, ballpark.
Okay, thank you. And the Act 62 doesn't say anything else about competitive solicitations, right?
I don't believe it says anything, certainly in the PURPA section. No.
Okay, so...
I'm sorry, it does say one more thing. It says, Act 62 says, nothing in Act 62 shall be inconsistent with PURPA. So to the extent, you know, FERC right now is looking at a NOPR that is considering competitive solicitation as an alternative, you know, in the future, that could require Act 62 to be consistent with whatever comes out of that NOPR. So there is the link in 62 to be consistent with FERC, and FERC is taking this very issue up at the moment.
Okay. And just to be clear, what you just said is that Act 62 requires this commission, whatever it does, to be consistent with whatever comes out of the NOPR. Is that right?
That is correct.
Okay. It doesn't require this commission to do anything consistent with the proposed rule, right?
No.
Okay.
That was not.
So, Mr. Brown, going back to my line of questions here, it would be fair to say, wouldn't it, that the South Carolina legislature has taken a different approach to PURPA implementation than the North Carolina General Assembly?
I would say that with respect to contract term for standard, for what I'd call normal PURPA contracts, yes, it has for large projects.
Okay. And it's taken a different approach with respect to competitive solicitations, right?
Yes, the North Carolina General Assembly has mandated a competitive solicitation.
Okay.
Yes.
And the South Carolina General Assembly has authorized this commission to explore the possibilities of competitive solicitation, right?
That's correct.
Okay. Mr. Brown, I'd like to actually look at your direct testimony on page 16, if I may.
Okay, I'm there.
Okay. I'm not quite there yet. Oh. So, Mr. Brown, you say towards the bottom of the page, well, about halfway through, that there are three primary components that contribute to the overpayment risk for customers under PURPA: avoided cost rates, length of contract, and the volume of contracts. Is that right?
That's correct.
Okay. And then you say that because this commission cannot control the volume of contracts the companies must enter into under PURPA, and I'm skipping ahead, it is imperative that the commission ensure avoided cost rates are accurately calculated. Do you say that?
Yes, I do.
Okay, I'd like to unpack this a little bit. When you say it's imperative that the commission ensure avoided cost rates are accurately calculated, the commission is already legally obligated to do that, right?
That's correct.
Okay, and they were before Act 62 as well.
That's correct.
Okay. Is it a fair reading that you're asking for this commission to approve lower avoided cost rates as a way of controlling the volume of QF development?
Lower than what?
That's a good question. That the commission should, well, let me ask another way, that the commission should lean in the direction of approving lower avoided cost rates?
No.
Okay. Are you suggesting perhaps that if it's a jump ball, the commission should err on the side of lower avoided cost rates?
I'm not sure what you mean by a jump ball. Jump ball in what way?
If there is perhaps a close call on an issue of reasonableness, that the commission should err on the side of lower avoided cost rates?
No, I think the commission should make its determination that whatever issue in front of it's dealing with this is our best and reasonable estimate of the actual avoided costs.
Okay, I guess what I'm struggling with here is then because I think you refer to these as you refer to this passage, I think, in your opening remarks or your summary as a customer protection issue.
Yes.
Okay. And I'm trying to understand the relationship that you think there is between avoided cost rates, length of contract, volume of contracts, and accurate avoided cost rates. What is that relationship?
Well, perhaps one way I could try to take an illustrative example. For example, if a commission were to order the utility to pay for societal benefits from solar, and that's $4 a megawatt hour, made up number. I mean, that would be, in my mind, inappropriate under PURPA and would be a mistake because the customers are going to pay that $4 and you don't know, whether that's a good thing or a bad thing. And it's certainly not an avoided cost of the utility. So, I mean, I had to take kind of a crazy extreme example because I'm not 100% sure what you're asking. Maybe you could try it one more time.
Well, Mr. Brown, you're aware that no party in this proceeding has asked this commission to approve rates that exceed what they view as the actual accurate avoided cost, correct?
I assume that, yes.
Okay. Well, you heard Ms. Doolin's, did you hear Ms. Doolin's opening statement?
Yes, I did.
In which she said that avoided costs cannot be inflated to achieve policy goals. Do you agree with that?
Yes, I agree.
Okay. Can avoided costs be deflated to accomplish policy goals?
No.
Okay. Because I read this passage to suggest that you would prefer that the commission deflate avoided cost rates as a way of controlling customers' exposure to solar overpayment. Is that not correct?
That was not my intent. I was just trying to articulate how you get to a large overpayment problem.
Okay. Let's talk about this overpayment problem. Doesn't overpayment risk exist whether or not avoided cost rates are calculated accurately at the time?
To a certain extent, yes, it does, because, again, and now we're in the theoretical discussion realm, right, as opposed to what Act 62 says and so on and so forth. But theoretically, the longer the contract and the greater volume, then you're going to have more risk that those contracts will be out of the money.
Okay, but it really doesn't matter. That has nothing to do with whether the rate is accurate or not, does it?
Well, assuming that the commission correctly, and I acknowledge that perhaps maybe in the eye of the beholder what correct is, but assuming the commission correctly calculates the avoided cost rate, they've done what they can as far as the rate goes. Okay. There's nothing more they can do. And then it's just a question of what happens from there and how many years are the customers on the hook for that rate.
So is it your view, Mr. Brown, that there is only one correct avoided cost rate or one correct way of calculating avoided cost rates?
We believe there is one way based on the Peaker method. I'm not the expert. Mr. Snyder will.
Okay. Well, we can talk about that in a few minutes then. Okay. So, Mr. Brown, though, based on your understanding of ratepayer risk and your view of it, would you say that lower avoided cost rates result in lower risk to ratepayers?
Lower than,
all things being equal, a lower avoided, as between two rates, whatever they are, the lower rate will result in lower risk to ratepayers. Is that what I take from your testimony?
I would say, generally speaking, yes.
Okay.
Yes.
And rates that are below the actual avoided cost rate would reduce ratepayer risk even more than an accurate rate. Is that correct?
Well, I would say that they reduce the cost of the solar to customers. There will still be some risk. But if you think about, I'll go back to CPRE, I think the average was something like $250 million savings relative to avoided cost. So you can think of it as like a $250 million head start before you're out of the money, just relative to that. Maybe that's one way to think about it.
Okay, that's a good point. That's a good question, though. So those CPRE projects, although the magnitude of the risk may be different because you've got that head start, wouldn't you agree that CPRA projects or CPRA contracts expose ratepayers to an overpayment risk?
I would say there still is some overpayment risk, yes. But it's mitigated by the Head Start, and it's mitigated by the dispatchability.
Mitigated but not eliminated.
Unless you pay, in my opinion, unless you pay variable rates for energy, I don't think you can completely mitigate that risk.
Do you think the risk to ratepayers is increased by the fact that they're 20-year contracts instead of 10-year contracts?
All other things being equal, I would say a 20-year contract. But again, you got 20-year contract with dispatchability, you got a 10-year contract without dispatchability. I don't know exactly how that's going to shake out over the entire life. But generally speaking, the longer the contract, the greater the risk, yes.
But in the context of CPRE, you believe that a 20-year fixed price PPA doesn't expose the ratepayer to undue risk?
Well, the 20-year PPA rate was mandated in the law.
Okay, but you've testified that those 20-year contracts are in the interest of ratepayers several times, haven't you?
I believe they are in the interest of ratepayers, yes.
Okay,
I believe that, yes.
Going back to the relationship between rates and risk to ratepayer as you conceive of it, would you agree that an accurate avoided cost rate would actually result in greater ratepayer risk relative to an inaccurately low rate?
An accurate avoided cost rate?
Say hypothetically avoided cost rate for a specific period is $3, right? And that results in a certain amount of ratepayer risk. Wouldn't that impose more risk on the ratepayer than a $3 rate, which is inaccurate but lower?
You said $3 and $3.
Oh, I'm sorry. Say $3 and $4. Okay. My apologies.
Okay, $4. Okay, so the accurate rate is 4?
Yes.
And the inaccurate rate is 3. Everything else is the same. Okay. Yeah, I would say that the 3, by virtue of being cheaper, will start out with the less risk to ratepayer than the 4 would.
Okay.
But that's true just because of the math. That's
right. But the accurate $4 avoided cost rate exposes the ratepayer to more overpayment risk than the inaccurate $3 rate.
Yeah, yes. Again, accuracy is very important. It's not going to be the be-all and end-all about determining whether or not customers are going to have overpayment risk.
Okay. Mr. Snyder, I'd like to ask you a few questions. You discussed in your direct testimony the methods that Duke uses to calculate avoided cost, right?
Yes.
And Duke uses the Peaker method to calculate its avoided costs?
Yes.
But there are other methods to calculate avoided costs, aren't there?
Yes, there are.
What do those include?
There's differential revenue, proxy, next unit, several different economic frameworks that NARUC has recognized.
Okay, and so NARUC has recognized them all as appropriate ways of calculating avoided cost?
I am not an expert on the other ways. I have seen documents that talk about pros and cons to each of the different ones, but there are different frameworks.
Okay, and would you agree that each of those approaches has its pros and cons?
I would.
Okay, and you're aware that Dominion Energy South Carolina uses a different methodology than Duke, correct?
Yeah, it's interesting because unlike, if you're familiar with the EE world, there's a RIM test, a TRC, a utility cost test. These are very well defined through some, the inputs are defined very precisely. My reading of the different methodologies in NARUC, differential revenue requirement, Peaker, proxy, they all sort of blend together. There's a lot of interpretation as what makes one way, what makes one the other. Their intent is the same. Their intent is to calculate that indifference price. But for the QF, what would the utilities costs have been? But when it gets down to can you find a manual such as the California Standard Practice Manual that was developed for all the different energy efficiency tests, I have not been able to find one that articulates those differences. So my point there is, and a little long-winded, is what some people call DRR is really just a variant of the peaker and vice versa. But they're all striving to do that same thing, which is to allow the utility to calculate the true indifference price that the QF is providing for consumers.
So they're trying to get to conceptually the same result, but they get there in different ways. Is that?
That's correct.
Okay. But there are variants, and different companies do it differently. Is that correct?
That is my understanding.
Okay. Do these variant or different methodologies, do they always yield the same results from given the same set of inputs?
I think the intent, as I said, is to yield the same result, which is what is that indifference price. So that's the intent.
Okay, well, I wasn't asking what the intent was. I understand the intent is the same, but do they in practice actually yield the same results?
I don't know. I've not calculated avoided cost under multiple methods to compare results.
Okay, so you have no idea whether different methodologies might yield different results?
I think again, it depends on how the methodology is deployed. Okay. I think even where you talk DRR, it may be deployed differently in different jurisdictions. But I do believe their intent is all the same, which is what is that indifference price? But I can't say as to which ones have different results. We've never done that.
Okay, and when you say deployed differently, does that mean the company has choices about how it will apply the methodology?
I think the company has to establish its indifference framework in front of whatever its jurisdiction is. So, you have different jurisdictions around the company. They deploy these multiple methods in a way to evaluate the indifference principle. They have an established process that they've developed over a number of years, in all likelihood, just like we do here in North and South Carolina that I'm familiar with. And then those deployment methodologies are approved by the commission.
Okay. And with the understanding that Duke's methodologies have been in the past approved by this commission, has this commission ever told Duke how it needs to deploy its use of the peaker method in calculating avoided costs?
Since I've been in this role, this commission has not directed me to deploy it any differently than we are today.
Okay. Would you agree that the company has to make some judgments in deciding how to, any company calculating avoided cost has to make some judgments in deciding how to deploy its chosen methodology on its system?
There's a limited amount. I mean, like I said, we have a pretty well-established framework for our integrated resource plan. We try and follow that framework. I think I point out 2 adjustments that we made, both of which serve to increase avoided cost rates because it was the theoretical correct thing to do, and it was just and reasonable for the QF.
What were those 2 adjustments?
Relative to the IRP process, as I explained earlier, we had more solar in the IRP than we used in the avoided cost calculation. So we stripped the additional non-contracted, non-obligated solar out. In addition, our peaker cost, in the interest of transparency, we used an adjusted EIA number. So we started with a very public number, made some transparent adjustments to accommodate economies of scale. That number in net is higher than our proprietary engineering estimates of what it costs to build a simple cycle turbine. So we actually use a higher number in avoided cost for the basis for capacity than we would if we were doing typical IRP planning and say, what is a CT cost? So those are the 2 adjustments I could think of that we made to our IRP. Otherwise, an IRP has dozens and dozens and dozens of inputs. We use those identical inputs. So this same framework is not just used in avoided cost, it's used in IRPs, it's used in Certificate of Public Convenience and Necessity. We have to maintain an integrity to that process, and we've maintained that integrity throughout not just this avoided cost proceeding, but throughout other proceedings before this commission.
Okay. And Mr. Snyder, why did the company decide to use the EIA information rather than proprietary information regarding the costs?
We had had debates before, not just before this commission, before other commissions, about proprietary information and the ability for third parties to look at that information. And we decided that in an effort to put that issue aside, to use a more publicly available information. So EIA, even though it's higher, we feel it's not that much higher, and it wasn't worth fighting over the transparency issue versus our proprietary engineering estimates that we always were filing under seal. To be clear, we would give those to anyone that had a confidentiality agreement. We filed them under seal, but that became an issue, and so we said we'll move. We made a decision, I think, several years ago to switch over to this data.
Mr. Snyder, my recollection is that you were ordered by the North Carolina Utilities Commission to use the public information. Am I wrong about that?
Yeah, we agreed with that. We had no problem. We didn't, we haven't tried to bring that back up. They've ordered us things in the past that we've come back and said, we've made another case in the following proceeding, and then they've agreed to change their position from prior years. In this case, we've consistently, for the last several years, used this EIA data. And I'm simply pointing out it is an example of where there was an adjustment. It does not lower avoided costs. It actually serves to increase the capacity rate. And the same thing, no one ordered us to strip out the additional solar. We looked at that as the analytically correct thing to do, and we made that discernment to pull that out. Other than that, like I've said, there's literally probably over 100 inputs. We keep them all the same. We don't put our thumb on the scale on any of the inputs in one hearing versus another. We try and produce our best accurate, avoided energy and avoided capacity.
But just to be clear, the company was ordered to use that publicly available information, and you were simply complying with that order and not changing your approach in the subsequent proceedings? Is that right?
Yes.
Okay. Thank you.
And to follow up, though, this commission never ordered us to do that. So we were not compelled to use that EIA data in South Carolina. In the interest of consistency and transparency, we made the decision not to use our IRP CT cost.
Understood. So going back to what we were discussing, the company does, would you agree that the company does make a number of judgments in deciding how it, well, you just described two of them, but the company does make a number of judgments in deciding how to calculate avoided cost rates. Is that right?
No, I just think I described the two I'm aware of. I said it makes a very limited, we very intentionally stay consistent with our established framework for producing an integrated resource plan. We use the same models, by vast and large, the same inputs. We update them annually through our IRP process. That entire framework is used to support not just the IRP, avoided cost, resource selection for the utility, CPCNs. So this is a established framework that is not looked at in this proceeding as where can we start tweaking variables. We don't do that.
Understood. And I apologize if I was not clear with my question. I was not asking about changes in judgment the company's made. I'm simply asking whether the company actually exercises judgment, whether it was 20 years ago or this year, in deciding how to calculate avoided costs.
I think, whenever you put together any model, it has inputs that require, some judgment, yes.
Okay. And when it comes to making a judgment call, is it your view that there's only ever one right way to do that?
I think in the context of the framework I'm talking about, there is a right way to do it. And if this commission decides they want different inputs, for example, in EE or DSM, there's an appropriate venue for that. We simply use the EE and DSM projections that we are consistently given that come out of a separate docket. We put those into the IRP, and that's what we use when we calculate avoided cost. We've had interveners suggest we should use something different, pick a different number for this proceeding. That's not how we progress. So we have used consistent inputs, the way they were developed in prior dockets, the way they get adjusted across time, You know, a load forecast is going to change from one IRP to the next. Gas prices will change. We will update those inputs on a periodic, methodical basis. We do not come into this docket looking to tweak inputs to put our thumb on the scale, and I just want to make that very clear.
Understood. And Mr. Snyder, I'm not suggesting that you were trying to, this is not the line of my questioning, is to suggest that you were trying to put your thumb on the scale. I am merely trying to understand the basis for review that there seems to be only one right answer when it comes to avoided cost. Is that your view, that there's really only one correct avoided cost value?
I believe there is one correct value that comes from a discernment of the process to say, here is what the commission believes are the appropriate avoided costs after they examine all the facts in the case.
Okay. So if Dominion Energy did its own avoided cost calculation, say it had the same system you did, it did its own avoided cost calculation using a different methodology and came up with a different answer, they would simply be wrong?
I think if they had the exact same system with the exact same load forecast as we had, this commission would have to, in consistency and fairness to the QF community and customers, harmonize those avoided costs. So if we have two identical systems and every single variable is the same, then yes, the commission in all likelihood should agree on here is the appropriate avoided cost for both systems.
Okay. So in your view, it would be appropriate for this, if this commission were to, well, it would be appropriate for this commission to mandate the use of the same avoided cost methodologies for all investor-owned utilities in South Carolina?
No, I don't think, like I said, the methodologies themselves are all attempting to do the same thing. You know, so it is more a determination of, you're hearing arguments on both sides around, did this calculation get run correctly? Was there bias? Is there any reason to believe that the utilities inputs need to be adjusted? If you determine they are, then they do. If not, they don't. But at the end of the day, whether Dominion uses one method or we use the other, again, they're striving, just as we are, to project our true avoided cost value as it relates to that indifference principle that we've spoken over and over about.
Okay. And you mentioned load forecasts. Avoided cost calculations do require the utility to make a lot of projections, don't they?
To the extent the avoided cost calculation, as I testified to, I think I said in my opening comments, uses a consistent set of models and inputs to the IRP. Those models and inputs will have an influence on the avoided cost. I think what I've just spoken to over the last few minutes here is that we try and keep a very consistent methodology, evaluation methodology from both modeling and inputs across time. And so, yes, to the extent the IRP has a series of inputs that go into it, those inputs carry over to the avoided cost.
Okay, so the IRP depends a lot on projections of various things. Is that right?
Yes,
gas
by
prices,
solar prices, gas prices, yes,
demand,
load forecast,
yeah.
yes.
Retirement of generating units?
Correct.
Okay. So to the extent that the avoided cost calculations rely on the IRP, those calculations also rely on projections. Is that fair to say?
Both the IRP and the avoided cost is a forward-looking projection. You're actually simulating how the system will run over the next 10 years at a at an hourly level. So those all, when you look out 10 years and say, what's the cost? What is this system going to look like over 10 years? By definition, they're going to have forward-looking assumptions.
So when you make those projections over time, is there any uncertainty associated with those projections?
Certainly.
Okay. Would there also be uncertainty associated with the avoided cost?
There absolutely is. Mr. Brown testified to, when you walk through reality, things will be different than you projected.
Understood. So there are a range of possible future values, and some are more likely than others. Is that fair to say?
I think what we're saying is we've given our best estimate of what that fair value is at every input. And so if you accept those fair values for each of the inputs as being fair, just, and reasonable inputs, then there's one value for avoided cost. To the extent interveners want to come in and they've, without exclusion, sought to handpick inputs to raise avoided cost, that's the decision of this commission to say, are those arguments they're making to hand select inputs to raise avoided costs fair, just, and reasonable?
Okay, so is it your position that with regard to all of the inputs, assumptions that are baked into the avoided cost methodology, there's only one correct way to resolve any of those questions?
I think the correct way is to adjudicate each of the inputs and say, is this fair, just, and reasonable input? Yes.
Okay. So let's talk about projections for a moment, though. We talk about natural gas price projections. Those are an important part of avoided cost calculations, right?
Yeah, I think I clarified natural gas market, but yeah.
Okay. And has Duke changed the way that it projects natural gas prices since the last time it proposed avoided cost rates to this commission in 2015, I suppose?
In 2015...
It'd be the 2016 vintage rates, but I believe they would have been proposed in 2015, 2016.
Yeah, I believe that was a settlement that we just settled into a rate. I forget which prices we used at that time, but subject to check, we may have, because I know just frankly over the last several years as the gas markets become more liquid, we've been able to go out and buy further and further into the future. So, you know, if you go back 6-8 years ago, we were only buying a few years out. We now can buy 10 years out. So as we've gotten more transparency into those forward markets, that's one of the IRP assumptions that continue to be updated. We use that same gas projection. So in this proceeding, the same 10-year forward curve that we used in the 2019 IRP. I will say, you know, you go back enough years, we did not use that much forward. You know, we had a different forward market and we had different fundamental forecasts back then. So I am sure that while I don't know the exact number, that yes, it is different today, and that input has consistently been applied across all of our modeling, not just in the avoided cost proceeding. It's been applied in our IRP and any other analysis we do internally to look at, you know, the efficacy of plan uprates or to look at economic analysis within the company. We use those same inputs. So that is an input change that has changed globally over our modeling system as we've had more liquidity in those gas markets.
And just to be clear on how the company is projecting avoided, natural gas rates, my understanding as a lawyer and not a person who does what you do, is that the company has some, I guess, 10-year forward natural gas contracts. Is that right?
Yeah, we get regular quotes, monthly quotes for 10-year natural gas. So we update our models based on the quotes, and then a couple of times a year just to demonstrate market liquidity and that it's actually a transactable market. There's a very narrow offer and bid spread, and the fact that people are willing to sell that far forward, we actually buy a couple of times a year so that we can have a demonstrable price that we can use in our modeling process.
But you are not, the company's not actually procuring all of its natural gas supply for the next 10 years via forward contracts, right?
Not all of it, no.
I mean, is it fair to say it's a pretty small amount or proportion of its supply?
Yeah, the portion that we've done is enough to demonstrate price liquidity. The same issues of risk for a long-term contract, as I said earlier, with solar QF is the same risk with fuel. So if you went out and bought all of your projected needs 10 years forward and you were wrong, then the consumer would be exposed to that. So no, we don't buy all of our needs. We simply do a small portion to demonstrate price liquidity in order to demonstrate the true indifference price at that moment in time. And as we've all pointed out here for quite a little while this morning, that price will change over time, but at the point in time you set the rates, this is the best available market price for gas.
Okay, and those forward contracts, though, they're just a way of demonstrating what you expect the 10-year price will be when the gas is, well, demonstrating what the actual price will be when the gas is procured in several years. Is that right?
I think it's, it's a bit of a nuanced point, and, at the risk of going too far down it, PURPA offers the QF two options. You can do a variable rate and say what is gas at the time of delivery will set the revenues you get, or you can do a forward fixed price contract. And the forward fixed price contract needs to be indifferent with the forward fixed price that the utility could otherwise purchase. So on one hand, they could elect to say, hey, if I think gas prices are going up, I'm allowed to take a variable rate, and as gas prices rise, I'll benefit from that. If they want a fixed price for a specific period of time, and in this case we're talking 10 years, then they get the equivalent 10-year forward gas price. So whether it's spot price at the time of delivery or whether it's forward price, PURPA allows either path for the QF. We're here today to determine that 10-year forward price, and so we use that 10-year gas purchase as that indifference equivalency principle.
Thank you for that. Guess going back to natural gas prices, though, the company uses the forward contracts as a way of projecting what gas prices will be over the next 10 years. Is that right?
Yeah, again, I hate to use the word projection because it is the forward market for gas. But yes, it is people often call that the projection. That's what the markets believe gas prices are at this point in time.
Okay. But and that's a different way of projecting. We'll use that not as a term of art, but a different way of projecting natural gas prices over 10 years than using a fundamental forecast, right?
Yeah, again, I think a fundamental forecast is there's one market, right? You can't buy at three different markets. We call multiple brokers are within a penny of each other. There's multiple fundamental forecasts, and they vary depending on which fundamental forecast you get, what point in time you get it. Fundamental forecasts take, several months to put together. The market changes daily, changes hourly. So yes, they're different. And again, that difference is one is representing the true market price, and today that you could actually transact at. You can't transact at a forward price, at a fundamental price. That's just an economic analysis of what gas might be at that point in the future. So there's some important differences, yes.
But the company has changed its approach to projecting natural gas prices for use in the IRP and the avoided cost projections, right?
The company, as I said earlier, has consistently said the best available prices are actual market. And as the market has become more liquid and as the company has been able to purchase deeper out into the market, we have globally done that across our entire planning framework. And I think it's really important that this was not done in isolation for this docket or any other avoided cost docket, that planning framework that I referenced is consistent with our integrated resource plan, our internal analytics. It's how we make capital asset decisions. And so it goes well beyond avoided cost. So yes, it has evolved as the market has evolved, but it is not done in isolation in this docket.
Mr. Steiner, I'd like to ask you about the company's resource plan. And I think you may have already answered this question, but yeah, how does the company use its resource plan as an input in the calculation of avoided costs?
So again, an integrated resource plan is the best estimate, once you have a plan going forward, of what your system will look like. It's got your load, your resources. It's called again, at the risk of getting into the detail, they run a unit-constrained, security-constrained economic commit and dispatch model. And the whole intent of that, without getting into the difference between the different linear programming and MIPS models and all this, is that model is a trying to replicate how the system will operate hour to hour across the next 10 years with as many of the, trying to be as real world as humanly possible with how our system, actually works, what the unit characteristics are, what their heat rates are, what their maximum output is, how long it takes them to ramp up, how, what they're going to look like over time. So we do all of that, and then we say, given all of the inputs, what does it cost on an hour-by-hour basis to run this system for the next 10 years? And if I had 100 megawatts of baseload generation free, how much would that come down? So I'm getting a free generator in every hour for the next 10 years. That's going to lower your production cost. It's going to lower the number of starts your system has. It's going to change the time units start from one period to the next. All of that is going to create an economic savings for the consumer. We then take that and we apportion it to the seasonal and hourly buckets that we have described in our filing.
Is the resource plan used to determine the first year, for purposes of avoided capacity calculations, is the resource plan used to determine the first year when an avoidable capacity need exists?
It is.
Okay. And the significance of that is that in the years before a capacity need, or in the years before a capacity need is deemed to exist, there are no avoidable capacity costs. Is that right?
That is correct.
Okay, so with the understanding that these are levelized rates, the avoided capacity costs for those years is zero, right?
Yeah, and just out of clarity, we don't pay zero. What Mr. Snowden was referencing is when you calculate the average value, you take the first year of need and you start calculating an avoided annual carrying cost in that year. You have no value up until that year. You levelize all that, and then that payment is what the QF receives in every year of the QF contract.
So for DEC, the first year of avoidable capacity is 2026, is that right?
That is correct.
Okay, and for DEP, it's 2020?
That is correct.
Okay. Does the resource plan also drive the seasonal allocation of capacity to some extent?
To the extent the resource plan relies upon a reserve margin study and other hourly, sub-hourly studies that look at LOLE, which is, again, in my opening statement, that loss of load expectation study. We use those loss of load expectation to determine when does capacity, is it really needed? In what seasons and what hours are you at the highest probability of a loss of load due to not being able to serve generation from inadequate supply? And so that loss of load expectation study is what drives, several things. It drives our reserve margin, it drives our allocations. So it's a component of both. I would say it's an input to both, but it's not an output of the IRP. It's an input to the IRP, it's an input. LOLE is an input to the IRP, it's an input to avoided cost.
Understood, thank you. Does the resource plan have an impact on avoided energy rates also? Or is it an input to avoided energy rate calculations?
Yeah, as I just explained, it's our projection of, what our load is and what our resources are, what those fuel costs are, and what's that marginal, value of that 100 megawatts of free generation over that 10-year period. That's consistent with the resource plan.
Okay, so in order to calculate accurate avoided cost rates, would you agree that it's important that the resource plan accurately reflect, to the extent possible, what the company's resource needs are going to be over the time horizon?
Load, resource, fuel prices, all key drivers.
Okay, but if the resource plan is not accurate, avoided cost rates aren't going to be accurate, right?
That is, yes, they're interrelated, so absolutely.
Okay. Is the source of the resource plan that was used by DEP and DEC in their avoided cost calculations the company's 2019 IRPs?
It was our 2019 update, that is correct.
Okay, and you were involved in the development of those documents, right?
Yes, I was.
Okay, and when were those IRPs made public?
First week of September, second, third. I'll subject to check. I'm sure this commission knows. I'll agree with you that it was first week in September.
Okay, but just to be clear, that was the first time the resource plan the company used for its avoided cost calculations was shared with the other parties in this case. Is that right?
Other than data requests, which again, we've answered hundreds upon hundreds of data requests in this docket. And so to the extent the IRP relied upon things like the load forecast and the fuel prices and all of that, that was provided to parties in advance of us filing the IRP.
But the resource plan was not actually provided to other parties, was it?
I don't recall. I would have to, that's a subject to check. So if anyone asked for what the underlying resource plan, and I do believe parties did ask for what our model was, like what our resource assumptions were, we would have provided it. So I actually believe if anyone asked for it, we would have. I'll have to check with council to see if that particular data request was asked before or after the first week in September, but we would have certainly provided it.
Okay. I would like to talk about the DEC IRP. You testified just a few minutes ago, and in your testimony you say the first year of avoidable capacity need in DEC is 2026. Is that right?
I did.
Okay, and in the IRP, the need for new capacity is driven by load growth and the retirement of aging generation resources. Is that right?
Yeah, that is correct. I think I also testified that another instance of where we actually raised avoided cost benefits from the North Carolina to the South Carolina case is rather than relying on the 18 IRP, we knew the 19 IRP was ready. You know, we were working on the production of the words and producing the document, but the analytics were done in time for this filing, so we wanted to be as up-to-date and consistent between the two filings, so we actually accelerated that need, which was 2028 in the North Carolina avoided cost case, to 2026, because North Carolina was dependent upon the 18 IRP, South Carolina is dependent upon the 19 IRP, so this is another example of where we, by going to updated data, we've actually increased the capacity cost available to the QF. Had we relied on the 18 IRP, we would have used a 2028 year of first need.
Okay, but it would have been inaccurate to rely on that 2018 IRP, is that right?
Right, but the dilemma that we were just talking about when you were saying, you know, we have a filing deadline for the IRP that was a couple of weeks after our filing deadline for this was, you know, the debate was we haven't filed the IRP yet, but we're ready to give all the information to interveners. We want to be transparent about it. We want to be up to date and be consistent with the most recent data. So in that, part of that decision was let's do that. And even, you know, that is one of the variables that did change and it moved forward, which increased our capacity rate for DEC.
Thank you. Mr. Chairman, I'd like to enter an exhibit into evidence. This is an excerpt from the DEC 2019 IRP. Mr. Adams has got, yeah, it's the one. And bless you.
I'm sorry, may I have a copy of that?
Sure, do we, yeah. My apologies, I did attend, but.
Appreciate that.
I did my count incorrectly, I apologize. Okay. I'd ask this document be marked as SBA Cross Exhibit 1.
Okay, this will be entered as hearing exhibit number 3.
Okay. Mr. Snyder, do you recognize these pages as being an excerpt from the DEC 2019 IRP?
Yes, I do.
Okay, and what is discussed on these pages?
We have what's called an LCR, Load Capacity Reserve Table. It discusses what load we have, what capacity we have, and what effective reserves we have. These are some of the details that go into that.
Okay. Do these pages describe the planned, do these pages describe the planned retirement dates for DEC's fossil generating units that are described in the IRP?
Yes, they do.
Okay, and looking at the bottom of the first page, is marked as page 54. What are the assumed retirement dates of Allen Units 4 and 5?
December of 2028.
Okay, and those are coal-fired generating units, is that right?
Yes, they are.
Okay, and they've got a total capacity of 526 megawatts, is that right?
That is correct.
Okay, and moving on to the next page, how about Cliffside Unit 5? That's also a 540 megawatt coal-fired generating unit, isn't it?
That is.
Okay, and it's expected to be retired in 2032?
Correct.
Okay, and these retirements are also described, or further described on page 89, the last page of this, is that right?
Yes, they are.
Okay. Mr. Snyder, is it true that after the 2019 IRP was filed, Duke indicated in a rate filing with the North Carolina Commission that it planned to move up the retirement dates for these units we just discussed?
It asked for in the rate filing, yes, to consider accelerated depreciation to move the highlighted units forward.
Okay, so the Allen Units 4 and 5 would be retired in 2024 and not 2028?
That is what is currently in the rate case.
Okay, and Cliffside would be retired in 2026 instead of 2032, is that right?
That is correct.
Okay. So is it fair to say that the resource plan in the IRP does not accurately reflect the company's actual intentions for the retirement of 3 coal units with a total capacity of more than 1 gigawatt?
No, doesn't say that at all.
Okay. Well, you just testified that the company has stated its intention, subject to approval from the North Carolina Commission, but has stated its intention to move up the retirement dates for those coal-fired generating units. Is that right?
Yes.
Okay.
So clearly, the IRP was filed before the rate case. We're in a dynamic environment. The world changes as we move forward, right? We have an IRP that was filed in September. Beginning of that, analysis started well in the spring of that year. These were the best assumptions going through the summer that we had. This is the IRP we filed. We subsequently filed a rate case and said, on a go-forward basis, we put before the Public Service Commission in North Carolina that we believe it's prudent to accelerate some of our coal plant retirements, given changes in the marketplace. To the extent the North Carolina Commission agrees with that, we will reflect those results in our 2020 IRP. We always try and stay consistent with the depreciable lives that are approved by the commissions, and we put those in the IRP. So as factors change across time, it doesn't mean that the prior one was inconsistent. It simply means there's a change. And if those changes are agreed to, we will reflect such changes in our 2020 comprehensive. Again, 19 was an IRP update year. We're going to have a comprehensive filing before both commissions next year. And we fully intend to reflect what comes out of that depreciation study in our IRPs.
But those wouldn't be reflected in the avoided cost rates that have been proposed in this docket, right?
No, nor would the reduced energy rates that would come with that.
Okay. Approximately how long was it? Well, approximately how long after the filing of the 2019 IRPs was the rate application filed?
I don't have the. I'll agree, subject to check. I'm sure you have the number in front of you directly.
What was the date? What was the date of the IRP filings?
September 2nd or 3rd.
Okay, and you'd agree that the rate filing was made on September 30th. Is that right?
Yes.
Okay, but it's your view that the company didn't know when it did the IRP that it would be seeking permission to accelerate the retirement of these units?
No, it was. Let me be clear. The company, when it's doing its IRP, starts its IRP process in the spring using the best information. This was an update. We're simply updating the comprehensive 2018 IRP. Clearly, with the rate case being developed, there's discussion around, is it appropriate to accelerate coal plant retirements in today's environment? And the question is, which one drives what? And we have consistently applied a process where once a depreciable life is approved by a commission through a depreciation study, we reflect that in the IRP. And so, you know, again, you have to snap a chalk line at a certain point in time and then say, these are my best inputs at that point in time. To be very clear, if we move these accelerations up, what will happen is you probably would have maybe a 1 year from the current avoidable capacity going from 26 to 25. I think we have enough excess length. I think I looked at that before this proceeding, enough excess length to make it to 2025. But you also accelerate more efficient replacement generation, which will also have an impact on your energy price. So you can't pick variables in isolation and say, oh, your capacity need moves up, we need to change the capacity calculation, without recognizing you would also change your energy calculation. And so I think it's important to say that's why we're doing these periodically. It's why we have a process in place to make changes. And to the extent we make this change and reflect it in the 2020 IRP, we will reflect those changes in our next avoided cost filing.
But as we stand here today, the retirement schedule that is in the 2019 IRP is not reflective of the company's current intentions for the retirement of those units.
Subject to, you know, I think you glossed over quickly, subject to commission approval. Yes, so we need to see where the commission comes out, where we are in the depreciation study. We'll be consistent with that in the 2020 IRP, and that will affect more than just the capacity calculation. It'll affect the total avoided cost calculation, and we fully intend to incorporate those in 2020 IRP and future avoided costs.
Mm-hmm. So what I'm hearing from you is that you're waiting on approval from the North Carolina Commission before you reflect those changes in your IRP.
That's a fair statement.
Okay. Looking back at the exhibit, it's marked as page 55. It's the second page. It says here that the hydro facilities for which Duke has submitted an application to the FERC for license renewal are assumed to continue operation through the planning horizon. Am I reading that correctly?
Yes, you are.
Okay, so for purposes of the IRP or the resource plan, you're assuming that FERC's going to grant approval of what the requested relicensing?
Yeah, I believe the license go beyond the 10-year period we're talking about here.
Okay, well, this indicates that Duke has submitted an application for license renewal for those facilities, right?
Yeah, it's like a 10-year in advance process. So we're doing submitting a license approval to continue to run our pumped hydro.
Mr. Snyder, you testified a few minutes ago that it was important to snap the chalk line at some point to decide sort of what's going to be in the resource plan and what's not. Am I characterizing your testimony correctly?
Yes.
Okay, and you said that was done in the spring of 2019?
The spring is when we started working on the IRP, and then we finalized the IRP in, late summer, sometime before filing.
Okay, so presumably information that the company had in the spring of 2019 could have been incorporated into the IRP.
Again, I think I've testified that we filed this in the rate case following the IRP. If the North Carolina Commission approves this, it will go into the 2020 IRP, and it will change more than just the capacity variable. So again, yes, you have to snap that chalk line, say, what are you using for the purpose of this filing? As we had a line of questioning just a little bit ago around moving from 18 to 19, and there was some questions as to, we were 2 weeks late filing the 19 RP compared to when we filed this, and did that provide enough time? And so on one hand, we don't want you to do something that's contemporaneous. On the other hand, you should need to be even more forward-looking. So I think we just have to reconcile. We just have a difference of opinion as to where to snap that chalk line. But our position is it's not in our IRP. It will not be put in our IRP. Until we have had a chance to bring this through the process and see if that's the agreement with parties when we go through the rate case.
Okay. I'd like to introduce. Mr. Chairman, I'd like to introduce another exhibit into evidence. This is an excerpt from company's, the rate filing we've been discussing with the North Carolina Utilities Commission.
Thank you.
We'll mark this as number 4, hearing exhibit number 4.
Thank you, Mr. Chairman. Mr. Snyder, do you recognize this document as an excerpt from an exhibit to the testimony of Mr. Spanos in docket number E7 sub 1214 before the North Carolina Utilities Commission?
This is the first time I've seen this document, but I will accept that this is what you say it is.
Okay, thank you. And do you see the date at the bottom of the first page?
I do.
And what date is that?
December 31st, 2018.
Okay. Let's turn to the second and third pages. Do you see a table of probable retirement years there?
I do.
Okay. And does this appear to refer to as identified in this, discussed in this exhibit, the probable retirement years of Duke Generating Utilities?
I see that.
Okay. And do you see the probable retirement year of Cliffside 5 identified as 2026?
I do.
Okay. And on the next page, you see where it says Allen, the probable retirement year is identified as 2024?
I do.
Okay. Would you agree that this, well, does this appear to be a depreciation, excerpts from a depreciation study?
It does appear to be that.
Okay. And based on the heading of this document, would this appear to be a depreciation study that was relied upon by the company in the current rate case?
Yes.
Okay. So I read this study as identifying the probable retirement year of the Cliffside Unit 5 is 2026, and the probable retirement year of the Allen units is 2024. Would you agree with that?
I agree with that.
Okay, and those probable retirement dates were identified as of December 31st, 2018, based on this study. Is that right?
That is what this document says.
So this information would have been available to the company by by the spring of 2019 when it did its IRP. Is that right?
Certainly.
Okay.
Yep.
Okay. But these retirement dates are not reflected in the IRP as we discussed.
Just to be clear, I'll say it one last time. This is still subject to North Carolina Commission approval. And while I have not run the numbers, I am fairly confident that had we included these retirement dates let's say the North Carolina Commission magically approved these really, outside of a rate case, and we included this because it was a known fact, it would actually serve to lower the avoided cost rates that are filed in this proceeding, without, subject to check, without running them, because you'd have a slight impact on your capacity need in DEC by maybe 1 year, but you would also have an acceleration of more efficient generating capacity. The reason you look to early accelerate is there's a more efficient solution that lowers your energy cost. We did not make that adjustment. It has not been approved yet. Our standard practice within the IRP, by and large, is once a depreciation study is approved by a commission, that then becomes our best estimate. And I think we use those terms in the IRP, our best estimate of depreciable life. And then we move them following the approval. What this whole line of questioning is going for is, why didn't we do it the other way? Why didn't we do the IRP first and then go to the rate case? And you can make arguments either way. Our standard practice has been, we're not sure if parties are going to agree that that's the best depreciable life. When they do, and we have that information, that will inform our IRP. And when we inform it, it'll have global impacts, not just the acceleration that was discussed here. It will impact the entire resource plan and the calculation of avoided cost. At such time that happens, we'll do it. I mean, that is the process we followed, and this has not been an exception to that.
Mr. Snyder, I seem to recall from your opening summary that you said the company used for avoided cost calculations, it used the resource plan and the IRP with some small differences. That might not have been the term you used. If that's correct, could you summarize what those differences are?
Yeah, I think I mentioned the two that I'm aware of right now is that when you look at the IRP, it has, as Ms. Doolin said in her opening statement, the two IRPs combined project us to grow to over 8,300 megawatts of solar. You know, where some of the I would guess our utilities are probably in top 1, 2, 3, somewhere in top 5 for sure, of installed solar in the country. When you look at that, though, as I said in my earlier statement, the more of any resource you add, the less valuable the next increment becomes. So what we've done is we've said it's really in the calculation of avoided costs, it's not appropriate to have more solar in the base case than we currently have in the ground, contracted, or are obligated to take under House Bill 589, Act 236. So there's a legislative mandate to get a certain amount of solar. We have a certain amount already of that contracted. We have a bunch already in the ground producing. That's the only solar we left in the IRP. We then took out the additional solar and did not have that because we don't have that either mandated or contracted. So we took out that amount of solar. That was the one adjustment that we made. The second adjustment I talked about was, and it's really not, it's more on the capacity valuation side, not on the production cost side, but for the setting of the capacity costs, we use publicly available EIA data with some adjustments for economies of scale, and that number is higher than our proprietary engineering estimate. So those are the two adjustments I can think of off the top of my head, Mr. Snowden.
Thank you. So, Mr. Steiner, when you, and we're almost done here. When the company does its avoided cost calculations and it looks at the resource plan that it's sort of using as an input, you're not sort of formalistically following the IRP. You're just using your best judgment to come up with the most accurate resource plan at that time. Is that right?
It was formalistically following the IRP, everything in the IRP with those two, as you said, we made the judgment. If you want to say it's a judgment, you know, we were ordered in North Carolina. We did not contest. We haven't since tried to move back from that position to use EIA data. We wanted to maintain that same level of transparency and consistency in South Carolina, even though we didn't have that order to do that in this state. So that served to raise our capacity cost. And it's our consistently used IRP with the hundreds of input. The one we did adjust, we felt was to raise the avoided cost slightly by removing the additional solar. We viewed that as the appropriate way to take the IRP and apply the peaker method. So that is, you know, out of the hundreds of inputs, we made two adjustments that I can think of. Both serve to raise the rate, both of which we think are very consistent with the IRP, but some small adjustments as one was ordered and in the interest of transparency, and the other because it's as you apply the peaker method, we have viewed that as the appropriate economic framework was to not include the QFs we have yet to contract for.
Okay, so there's not a legal requirement that you use the IRP as the basis for avoided cost calculations, is there?
No, I think what the NOPR is looking at is, can we get to a competitive procurement? We're not there yet. Is there other ways other than having to use, administratively determined rates to get us there? Right now, though, before that NOPR, if it's not enacted, I don't know of any other, no matter which one of the economic methods we spoke about earlier you choose, they're almost all certainly involved in using an IRP to accurately calculate that indifference price.
But you're aware that Dominion Energy, although the IRP is a factor, does not use the resource plan that is identical to the one in its IRP, its avoided cost calculations.
I do not know what Dominion uses. I did not.
But the important thing is that the resource plan be as accurate as possible. Wouldn't you agree with that?
I think the important thing is the resource plan be as accurate as possible.
Okay, great. Thank you. I have no further questions. Thank you very much.
Thank you. Let's see. I was told we marked that last exhibit, but didn't enter it, so I assume you want to enter it.
Yes, I would ask that exhibit be entered.
We will enter it as exhibit number 4. Okay. JDA. I was going to say, you got 10 or 12 minutes in you?
Probably.
We'll give it your best shot.
What I always try for. Mr. Snyder, it's good to see you again. We've spent a lot of time together, and I feel like we know each other well. Mr. Brown, I don't think we've ever met. I'm Jamie Golden on behalf of Johnson Development Associates. For the record, and to clear up any confusion, I want to ask you a couple of questions about Act 62 and the process. I'll direct this to you, Mr. Snyder, because I think we did work closely on it. I believe I said in my opening that you opposed us at every turn, and I believe that to be true, but there were parts of that bill and parts of the act that you supported, correct?
Yeah, I actually think it's important to have a fair clarification. We did not oppose at every turn. As a matter of fact, we had one significant area of disagreement, and that is the length of the contract that's appropriate for the setting of PURPA rates. And parties at the table would have liked to seen 15 or 20. The company thought 5. We went back and forth. I testified at a couple of Senate subcommittee hearings on that very issue. And that's the one issue where we didn't find common ground. We had managed in working sessions to find compromise on every other piece of the bill. So to say we opposed them, I think, is a little bit of an overstatement. Whenever you are participating in a process like that, there are two different opinions. There's staff there that's helping to mediate that and say, can we find middle ground? And we found middle ground on everything but this one provision. I think someone said 9,888 subject to check words. In that entire bill, we couldn't come to agreement on the term of contract, and the legislature went in the middle. They said not 15 or 20, not 5, we're going to do 10 up until we reach this 20% cap, and then we're going to allow this commission to readdress that issue once we hit that. So, I feel very good about the work everyone did on that bill, including our parties on the other side. We didn't come to agreement on just one issue. The rest of it we came to agreement on, and I think we supported that bill except for that one issue in both chambers.
Thank you, Mr. Snyder, for that. I don't want anyone to attack my integrity, and so I appreciate you clarifying that and us having this discussion. What I would like to say is that's a pretty big issue, though. We disagreed. You all thought 10 years, and I think you would agree with this. You thought 10 years was the cap, and that was the position you would have advocated for. We certainly wanted to see 10 years as the floor, and that was the big debate, right?
That was the big debate.
All right. Thank you, Mr. Snyder. Mr. Brown, I'll turn to you. Is Duke opposed to a 10-year fixed price contract based on avoided cost?
Not up to 20% of peak.
Okay. But Duke has opposed a 10-year fixed price bill credits in its GSA program, correct?
In North Carolina? You're referring to the North Carolina?
Well, I think you filed what you've proposed to file down here as well.
Yes, we filed it here, but when you say has opposed, I don't know that, have we received testimony?
Comment letters, but I don't mean to speak up for you.
Okay. Well, yeah, so just to be clear, yes, Duke in the GSA, which is what our Voluntary Renewable Energy Program is called, that's what we call it, we support a 5-year bill credit 5-year avoided cost bill credit. So the bill credit would be fixed for 5 years, and then it would be reset at the then avoided cost rate for another 5 years.
And you said earlier in your direct testimony here today, or your summary, you thought 5 years was reasonable for a PURPA term. Is that accurate?
Yes, I do think 5 years is reasonable for a PURPA term. We are seeing QFs sign 5-year PURPA contracts now. I think we have over 400 megawatts of those executed.
Subject to check, we asked an interrogatory on that, and it came back that out of the 4,000 megawatts that you have under contract, only 12 of those megawatts are 5-year terms.
I think the 5-year term contracts may have, I'm not sure with the date of I know the date of the 4,000 that's in the testimony probably preceded the date of when those contracts were executed.
Okay.
I think because this is a recent occurrence in the last few weeks, that is when I became aware of this.
Okay. So the last few weeks there's been more signed, but prior to the last few weeks, subject to check, less than 0.0003% of your contracts or your PPAs under contract are at 5 years.
That sounds about right. It was very little, very little.
And the arguments you make in your testimony that question the wisdom of PURPA and a fixed price contract or an administratively determined contract, as we've alluded to, are essentially the same arguments that were presented to the General Assembly, correct?
Yes, I think we expressed our concerns that you can end up in a bad situation depending upon how you end up implementing PURPA to the General Assembly. I think that is generally what we did say, and that at the end of the day, the customer will pay for that.
But the General Assembly, in passing the act, didn't find that persuasive?
I think the General Assembly reached what it viewed as a reasonable compromise.
That would be a minimum of 10 years at avoided cost.
Right, for a certain quantity.
And then over 10 years at a decrement and appropriate terms, right?
There's a provision in there that says that interveners can file for a longer than 10-year contract at appropriate commercial terms and at a discount or something to that effect well, I don't remember the exact words, but that's the essence of it.
Other terms and conditions, a decrement, I think those are words used.
Right.
But it's not just to 15, not just to 20. It could be on up to 25 years even. I mean, there's no cap on it.
I don't think there's a cap on what they can propose.
Okay, thank you. In your testimony, how many times do you mention the shareholders?
I don't know.
Okay. What do you consider to be Duke's fiduciary duty to its shareholders?
Well, I'm not a board of directors fiduciary lawyer, so I can tell you my layman's.
If you don't know, it's okay.
I mean, I think that they have to look out for the interests of the shareholders. The board and management has to look out for the interests of the shareholders, no question about it.
Does Duke consider the impact on shareholders when it takes a position on state legislation like Act 62 or on federal legislation like PURPA?
It does. I would say that it looks at all legislation broadly and looks at the impact on our operations, the impact on our customers, the impact on the company's finances. I mean, it looks at everything, yes.
Okay. When Duke abandoned the Leaf nuclear facility, how much of the cost for those abandoned units did Duke propose to have ratepayers cover compared with shareholders?
I don't know the exact numbers that were proposed because I was not involved in that rate case.
Okay. That's fair. You've made the argument that North Carolina ratepayers have overpaid for QF power based on the drop this decade in natural gas. Is that correct?
Well, actually, all customers have paid for that. Because those are purchase power contracts, they are allocated across all three classes of customers we have, which is North Carolina retail, South Carolina retail, and wholesale.
But the point being, you've stated there's been an overpayment by those classes of ratepayers.
Yes. Now, to be clear, the 2.2 number is a forward-looking overpayment, but there has been an overpayment even in the actual results, yes.
So you agree it's forward-looking, so it is a bit premature to determine if the jury is correct on that.
Yes, I would acknowledge that the exact amount that it will be determined over the next 10 years-ish.
So we've got 10 more years before the jury comes back in on that. Okay. Ask the witness.
Okay. We're going to take a break for lunch. And I would ask everyone to be back here at about 1:43. You guys are still here? Okay. Mr. Bateman, before we move forward.
Good afternoon, Mr. Chairman. Just a quick housekeeping matter. I mentioned this morning that ORS was reviewing the partial settlement agreement and hopes to get back to the commissioners by the end of the day. We had a chance to review it at lunch. We will not be signing on, but we do not object to the partial settlement agreement. Thank you so much.
Thank you. Okay, we're still in cross ecoplexus, Mr. Witt. Okay, SACE and SCCL. Ms. Bowen.
Thank you, Mr. Chairman and Commissioners. Good afternoon, gentlemen. How are you? Good. Okay, Mr. Brown, I have some questions for you, and then my colleague, Mr. Holman, has some questions for you, Mr. Snyder. Mr. Brown, you acknowledge in your testimony that you are not a lawyer, correct?
That is correct.
Okay. But you are generally familiar with PURPA and its requirements, is that right?
That's correct, yes.
Okay. And would you agree with me that Section 210 of PURPA was intended to encourage cogeneration and small power production?
Section 210, I don't know the specific sections related to the, like what's related to what section. So if you want to point me to it, I'll tell you what I think.
Sure. Subject to check if you need to. Section 210A of PURPA says, and I'll quote it, that, for example, the Federal Energy Regulatory Commission shall prescribe rules to encourage, and this the quote, encourage cogeneration and small power production, and to encourage geothermal small power production facilities at not more than 80 megawatts capacity. Does that sound familiar to you?
That sounds familiar, yes.
Okay. Similarly, the U.S. Supreme Court has acknowledged this in its case law. And again, I'll quote, Section 210 of PURPA was designed to encourage the development of cogeneration and small power production facilities, end quote. Do you have any reason to disagree with that?
I do not have any reason, no.
Okay. And then would you also agree, Mr. Brown, that interpreting PURPA, the Supreme Court of the United States has declared that Congress believed that increased use of renewable energy would reduce the demand for traditional fossil fuels?
Yes, I've read things to that standpoint. Yes, it was designed to try to reduce the demand for generation from fossil fuels. Yes.
Okay, thank you. And Congress, to the best of your knowledge, Congress further recognized in that same case, actually, that the electric utilities had traditionally been reluctant to purchase power from and sell power to non-traditional facilities. Were you aware of that?
I presume that, given that the law required the utilities to enter into a contract, so there must have been reluctance. I mean, it's a long time ago, so yeah.
And in response to the question in your testimony of who pays for all of the power that PURPA requires the companies to purchase from the QFs, did you respond that the customers would pay for that?
Yes, the customers will pay for that.
Okay. And you would agree with me that customers also pay for all the companies' non-QF power, is that right?
Generally speaking, yes, subject to prudency review, the customers pay for the non-QF power that we purchase, like economy purchases or things like that, yes.
Are you also aware, Mr. Brown, that courts have recognized that the effect of PURPA is to encourage competition with utility-owned resources? Are you aware of that?
I am not aware of that.
Okay, and you may not have read this case, but, you know, for example, there's case law out there saying that Congress has introduced competition into the generation component of the electric power industry by enacting PURPA. Were you aware of that?
No, I'm not familiar with that particular case.
Would you agree with me, Mr. Brown, that competition can apply downward pressure on prices over the long term?
Yes, I agree that competition can apply downward pressure relative to no competition, yes.
Okay. Mr. Brown, are you aware that the Energy Freedom Act requires an avoided cost proceeding before this commission at least every 2 years?
Yes, I am aware of that.
Okay. And there's nothing in the Energy Freedom Act, to your knowledge, that would prevent the commission from holding an avoided cost proceeding before that 2 years have passed if it was needed?
don't think there is. I think it could be more frequent.
Thank you. And in your testimony, you say that solar advocates are advocating for higher avoided cost rates. Isn't it true, to the best of your knowledge, that the parties have submitted testimony in this proceeding regarding how to accurately and fully quantify avoided cost rates in this proceeding?
In my direct testimony, I don't recall talking about what the solar advocates filed, because they hadn't filed anything yet.
So it might have been in your rebuttal. I'll save that for rebuttal. And then are you aware, Mr. Brown, that FERC Order 69, which you do reference in your testimony, includes an analysis and a description for why it requires QFs to be paid at the full avoided cost rates?
Yes, generally speaking, yes.
And are you aware that the order acknowledged that the avoided cost construct ultimately benefits, and I'll quote here from FERC Order 69, benefits ratepayers and the nation as a whole from the decreased reliance on scarce fossil fuels such as oil and gas and the more efficient use of energy? Does that sound right to you?
I'm not specifically familiar with that exact order, but I believe what you said.
Okay.
That's in order.
Okay, thank you. And Act 62, or the South Carolina Energy Freedom Act, similar to PURPA, encourages renewable energy generation and compensation at full avoided cost rates. Would you agree with that?
Yes, I think it requires that the commission finds that we should pay avoided cost, full avoided costs, or actual avoided costs, yes.
Okay, I have nothing further. Thank you, Mr. Brown.
Good afternoon, gentlemen. I'm Bland Hallman. I have a few questions for you, Mr. Snyder. Your testimony opines on the purposes and meaning of Act 62, does it not?
Yes, it mentions Act 62.
And you contend that Act 62 does not materially change the way PURPA avoided costs are determined in South Carolina. Is that right?
No, what Act 62 did change was the tenor, and that we spoke a lot about that earlier this morning, is it codified the 10-year tenor and up to the 20%. But with respect to the actual calculation, Act 62, as I think many people on the other side of the table have pointed out, hasn't changed what has been a longstanding obligation of FERC and this commission, which is to accurately and fully quantify avoided costs.
Okay, you said it didn't materially change. Does that mean it didn't change it at all?
Well, I was trying to get in the 10-year. I mean, I think where we've had debate in the past is what's the appropriate tenure. Act 62, as it relates to how the commission should interpret and implement PURPA, clarified that up until 20% of retail sales are met through 10-year contracts, this commission was directed to use a 10-year tenor. And so I think that was the part that was clarified that maybe wasn't in, but in terms of, you know, the calculation, is my understanding that Act 62 has the identical language to PURPA that PURPA has in terms of just and reasonable rates. Act 62 talks about protecting the consumer and ensuring that the rates are accurately and fully calculated. But nothing has changed in terms of that's been PURPA's intent from the beginning.
So your testimony is that contract tenor is part of the avoided cost calculation?
The avoided cost calculation, part of it is the tenor. Yeah.
Okay. Would you agree that Section 584105 of Act 62 directs the Commission to ensure that rate design, quote, properly reflects changes in the industry as a whole, the benefits of customer renewable energy, energy efficiency, and demand response, as well as any utility or state-specific impacts unique to South Carolina? Do you agree with that?
Subject check. I don't have the act in front of me.
Do you know, was there any law that said that before this act was passed?
None of that you just read has any implication on the calculation of the PURPA avoided cost rate. That was not the intent of the act, was to use that language to change the rate.
Okay, I'm gonna try to move quickly. So I'm gonna ask you questions that are basically yes or no questions. And my question was whether or not this provision of law existed before it was enacted in Act 62.
I don't know that it had or had not.
Would you agree, Section 584120B of the Act's provisions regarding avoided costs directs the Commission shall treat small power producers on a fair and equal footing with electrical utility-owned resources by ensuring that rates for the purchase of energy and capacity fully and accurately reflect the electric utilities' avoided costs. You agree
That has been the standard forever, yes.
so that's not a new provision of law?
That's been very much in what PURPA has said. You know, it's twin pillars of PURPA, fair and non-discriminatory rates towards the QF that are at the utility's incremental avoidable costs. So the but-for principle is one pillar, and fair and non-discriminatory rates is the second. The language that was just read is basically codifying what PURPA has said in my interpretation of PURPA for 40 years.
And it doesn't just say accurately. It says fully and accurately.
They're one and the same.
There's no difference in those?
No, there's not.
So why do you think the General Assembly used both words instead of just one?
Fully and accurately means you have to do the but-for principle. It clearly is not meant to mean more than but-for or less than but-for, and neither does PURPA.
Okay. Would you agree that Section 584120B3 of the Act requires the Commission must ensure that each electrical utility's avoided cost methodology fairly accounts for costs avoided by the electrical utility or incurred by the electrical utility, including but not limited to energy capacity and ancillary services? You agree that that is in the Act?
I do agree that that's in the Act.
And that's a new provision?
It
may not be new to you in terms of your concepts.
No, it's not new to PURPA. It is simply articulating what PURPA has said. So it's making very clear what the PURPA intent is, and I think it's very consistent with PURPA.
Okay, and you would agree that Section 584120F2 of the Act addressing avoided costs expressly directs the Commission to consider QF contract terms to promote the state's policy of encouraging renewable energy. Is that new?
Mr. Chairman, if I could, before the witness answers, I just want to make sure he has a copy.
You need to get toward the mic so we can hear you.
Yes, sir. I think I haven't heard subject to check yet, and Mr. Snyder is doing the best that he can to recollect what's in the Act. But to the extent Mr. Holman's going to move from the Act.
We're moving on from the provisions of the Act, but if you would like to hand it up, that's fine with me.
This is the last question. I
think that's it.
Very
Okay.
good.
Well, I say that. I've actually got one more question. This is, in your testimony, page 7 of your testimony, you agree that Act 62 requires the Commission to minimize risk. You need to review testimony.
Yeah, I see that statement. Mm-hmm.
The company has argued that these long-term PPAs present risk because, for example, North Carolina avoided cost rates have fallen in recent years. Part of the discussion earlier.
Yes, we've talked about the overpayment risk that we're now realizing.
And you've testified that the primary driver of avoided energy costs is natural gas commodity prices.
It is one of the primary drivers, yes. That's part of my testimony.
And regarding those gas prices, your testimony presents natural gas pricing forecasts over recent years compiled in Figure 2. I think you've got that figure that shows the cost curves on page 25 of your testimony.
I see those, yes.
And Figure 2 shows that for the year 2026, the cost forecast in July of 2019 is higher than the cost that was forecast in January 2019. Is that right?
As of the date of this publishing, that one data point is correct.
And it shows that, excuse me, for forecast year 2027, the price projected in your July 29th figure is higher than the price projected in 2018.
Subject to check. I mean, they're pretty close.
In fact, in the figure, your most recent July 2019 estimate shows gas going from $2.50 per MMBTU in 2020 to about $3.40 per MMBTU in 2029.
That looks about right.
That's
The market's come down a little since then, but that's right for at that point in time.
That's about a 36% increase subject to check.
Again, that's what we look at is the 10-year average price when we set a 10-year rate or levelized price. Some years are lower, some years are higher, but yes.
Okay. Excuse me. Turning to a different issue, a resource planning issue, I'd like to ask you some questions about Duke's Cliffside 6 unit. That was built as an 825 megawatt coal burning facility. Is that right?
I was not there at the time with Duke, but yes, that's correct.
It was put into service, I think, at the end of 2012. I think it was end of 2012, December 30th, 2012.
Correct.
Cost $1.8 billion.
Subject to check. Again, I wasn't there. I was not responsible for that certificate of public convenience and necessity.
And South Carolina ratepayers, by virtue of the system design, are going to pay for a portion of that, whatever their allocation is. Is that right?
That is correct.
Okay, so if the unit costs $1.8 billion, but Duke, I think during your tenure, did then spend about $65 million converting that to be able to burn natural gas?
Yeah, it used new technology. I mean, they're not even new technology, but it determined as market events changed that it was a worthwhile investment to allow the plant to burn either coal or gas to take advantage of the flexibility of the market prices. So it added value to allow to burn coal when coal was cheaper, gas when gas was cheaper.
And in terms of efficiency expressed as heat rate, the unit averaged about, it looks like 9,100 BTUs per kilowatt hour. Does that sound about right?
That sounds about right.
That's similar in efficiency to a combustion turbine?
A little better.
Okay. Much less efficient than a new combined cycle plant?
Not as efficient as a new combined cycle, no.
Can it ramp as quickly as a new combined cycle plant?
I do not believe so.
Can it operate at low capacity levels like a new combined cycle plant could?
No, these upgrades improved its ramp and its efficiency. I mean, not its efficiency, its ramp and its flexibility, but it was not, it was done at a fraction of the cost of a new combined cycle. So this wasn't an either or. This was to take advantage of the energy and flexibility savings you could get from this conversion.
How long will ratepayers be paying for that plant?
I believe someone handed me the depreciation schedule earlier. I don't have it in front of me, the exact retirement date.
Sir, hang on.
I'll let him finish. But, Mr. Chairman, we've gone pretty far down the line, and I've not heard anything that ties the Cliffside Unit 6, which is in base rates today, has nothing to do with the company's avoided costs, how this is relevant to the issues before the commission in this proceeding.
I'd be glad to explain. The utility builds large pieces of infrastructure for billions of dollars. Ratepayers then have to pay for them for decades. Part of the company's point has been that avoided cost contracts are risky because they lock payers into a period of payment, and the point is utility is doing that with indeed more expensive resources. So we do think it is relevant, but I can move on.
Okay, well, let's make that point and then let's move.
All right. Well, the last question is that ratepayers may have to pay for that even if the plant ultimately ends up running very little.
Yes.
You testified that the company did not include avoided CO2 emission costs because they are speculative. On page 28 of your testimony.
Yeah, they're not allowed under PURPA or Act 62 to be included in the calculation of avoided cost.
You say they're speculative,
right? Can you direct me where in my testimony?
Yeah, it's page 28. On the bottom of page 28, lines 16 to 17.
I give that as one example of what a speculative cost is that's not permitted to be included in avoided cost.
You would agree that there is a risk of CO2 costs before 2029 being imposed on the utility?
There could be, yeah.
And the company includes the cost of a proxy cost for CO2 in its IRPs?
It runs scenarios. So it runs scenarios that shows how an integrated plan would look like with and without carbon. So we do have both scenarios. We use the no carbon scenario for the development of our avoided cost.
And does the 2019 update IRP, the base case with carbon tax is used as, I believe the language is as a placeholder, and the company said it feels it is prudent to continue to plan for that scenario?
Yeah, you plan for both with and without. We have many scenarios we run.
And you would agree that the company announced last month that it is speeding up its efforts to reduce climate change with a new goal to cut carbon emissions from electricity generation to net zero by 2050.
Yes.
And you would also agree the company announced that it's sped up its goal for cutting emissions by 2030 from 40% to at least 50%.
That is correct.
Is the recent acceleration of retirements for Cliffside 5 and the Allen units that were being discussed earlier, is that consistent with this newly announced plan?
That certainly will contribute to meeting the 50%, but I wouldn't say that was the driver.
Okay. And when did you become aware of the plan to accelerate the retirement of Cliffside 5 and Allen, those Allen units that were discussed earlier?
I knew it was being discussed as a potential in the rate case for, I don't know exactly when I became aware, but it's fair to say, for at least a year.
Okay, so before you filed testimony in this case?
Yes.
And isn't it true that in IRPs that the company submits, they often include resources that have not, and decisions that have not yet been approved by the commission, for example, possibly building a combustion turbine or a combined cycle unit in the future?
Yeah, when it comes to retirements, I think what I've explained before is we have a standard practice of using what is in the depreciable lives of the assets as our best placeholder for retirements. I think we point out that those retirement dates could move in time, but when we get a new depreciation study that changes that depreciable life, we then reflect that in the IRP.
No further questions. Thank you.
Thank you. ORS.
Mr. Chairman, ORS has no questions for this panel on direct, but wishes to reserve its right to ask cross on rebuttal.
Coming back to that. Thank you. Okay, commissioners. Commissioner Williams.
Thank you, Mr. Chairman. Good afternoon, gentlemen.
Good afternoon.
The background for this question is with this new law, this is not the first new law that has come before this commission that arrived here with a lot of fanfare, and I'm referencing Act 62. At one point, the Baseload Review Act came before the commission with a lot of fanfare. My concern is that there may be elements of the law that, even though they're plainly written, that no one is paying attention to. So I want to give you the opportunity to share your worst case scenario, the worst case outcome for the ratepayer under this act. If we were the commission to give JDA and the Solar Business Alliance what you consider an inflated avoided cost rate, what would be a doomsday scenario for the ratepayer?
I'll take a first shot. Again, I think that's wholly dependent on, if this commission were to have rates that were actually above the true avoided cost, and that there is this interrelationship to price and the amount of volume you get. I know there was some testimony earlier about there's the 20% cap, but as Mr. Brown alluded to, you might have a lot of people signing contracts that by the time you procedurally work through instituting new rules, once those contracts are signed, if you go from 20% to 25 or 28 while you're working through what is a very, sometimes thoughtful and takes some time to get through what we're going to do after we hit that 20% cap, I just don't know what the volume times, it's a volume times price issue, right? So the worst case is where you set high rates and you get a lot of volume, and then you go through time and, rates come in much lower. And then the customers, similar like my example with the gas hedge, had we gone out and done long dated gas hedges at huge volumes at a certain price, and then you move through time and that comes down, then you're left paying for that. The other thing I point out which is something to consider in the contract or in the enactment of the law is, technology improvements are a good thing, but the question is, who do they benefit? So if, let's say, we expect and we project in our IRP significant declines in solar still. We project declines in storage technology. The question is, who benefits from those declines? So if you set high, long-term avoided cost rates, and the QF then deploys these future technology advancements behind an existing contract, that half-price contract is good for the half-price technology is good for the developer, but the consumer is still paying the old avoided cost rate. They never see the benefits of the decline in the price. So it's not just gas prices. It's also thinking about, when you implement it, who's going to benefit from future technology improvements? Are the consumers going to be the beneficiary of those future technology enhancements? Or are those going to get put behind existing contracts where the price is locked in at today's avoided cost prices? So I think you've got those two risks, both on tenor and price, that become a potential risk for the consumer.
Yeah, I really don't have much more to add to that. I personally believe that if the state is interested in procuring solar energy, that we should procure it based upon the cost of solar energy, the lowest possible cost of solar energy. Just generally speaking, that's your most efficient way to do it over the long run. We have a PURPA obligation. We stand by that obligation. We will buy it at the avoided cost rate approved by the commission. I think that is one way to do it. I don't think it's the most efficient way to do it.
So, do either of you have a possible number or figure? Someone testified that there is like $2 billion or so in overpayments. I think that's coming out of North Carolina.
Yeah, I have that in my testimony. That number is based on what we've already got executed. And those contracts, some of them are several years old already. And that was 4,000-ish megawatts, just ballpark of what we're talking about. So, I mean, I don't want to speculate on where the market's going to go, or, how many contracts we're going to end up selling. We know, or purchasing rather, I know we're going to do 20% of peak, and then the commission will revisit what the contracting terms are at 10 years. So honestly, it's kind of hard to say in total how things could go.
I understand that, but I want you to understand where I'm coming from. I do not want to see any overpayment amounts in South Carolina. That would be a problem for the commission. So I'm trying to give you all an opportunity to help me understand how, if at all, we can prevent an overpayment situation. Or is that just baked into the law, that potentially may happen? And we'll just have to deal with it if it happens.
I think there is a certain amount, the law says you will, whenever you have a fixed price, and this is true, I mean, parties agree on this, whenever you have a fixed price for a long term, there's a risk. And so when the law obligates to a 10-year fixed price, and there is some amount of risk that is going to end up being some contracts that were signed at above the then prevailing market. similar to any other sort of fixed price or hedge position. So again, it's the cumulative nature of the risk is a function of tenor, and we've all had a lot of testimony on this earlier. I used to be in a risk role within the company in a past life, and it's a very straightforward concept. The further you go out in time, you get this cone effect, right? There's a much bigger uncertainty of risk the further you go out in time. So tenor exacerbates the risk and volume. And so, you know, as the act gets implemented, as we move through time, it's, you know, you think about how we do other hedges, it's good to do specific, you know, not put all your eggs into one time period or one tenor. You think about how you hedge your 401k. You don't go all in the first year of your career and never put in, you know, you put in a little bit every year, and sometimes you win, sometimes you lose. So, you know, I think it's how do we ensure that we're doing the right amount of volume at the right pace and at the right price. And I agree with Mr. Brown that competitive procurement with set volumetric targets seems to help mitigate the risk as compared to no volumetric limits and an administratively determined price.
All right. Mr. Brown, you talk about the company's competitive procurement of renewable energy program on page 17 of your pre-filed testimony. In your opinion, has the passage of Act 62 influenced the demand for QFs entering into that program?
I don't know yet. Honestly, we don't know. We've got the window. The window is now open, and we'll see what kind of responses we get to the procurement.
Recognizing that Act 62 allows this commission to approve PPAs with durations longer than 10 years, but with a reduction in the contract price relative to the 10-year avoided cost. In your opinion, would this information be useful in assessing what an appropriate market-based discount off of avoided costs might be for a 20-year PPA term?
You mean would using a market-based price to set the decrement be useful?
Right.
Is that what you're asking? That could be one possibility. If it depends on a number of factors, but that could be one possibility.
Could you share those factors with us?
Well, what I'm mostly concerned about is it isn't clear to me whether we're talking about a standing rate that is out there for however long it's out there for as much volume as you want, as the solar market can make work, because that still may result in customers paying more than it needs to. And but I mean, if you are trying to get at closer to what the market cost of solar is, then what you could do is you could do an RFP, and then that could set the rate for a period of time under PURPA for contracts longer than 10 years. But then you kind of say, well, if you're going to do an RFP to set the rate, why not just do the RFP to purchase the solar? Because then you have the benefit of fixed volume, and you don't have an unlimited put.
Okay. Mr. Snyder, a couple of questions for you. To your knowledge, are there times when the companies elect to decommit a generating unit given levels of solar output and then have to shortly thereafter start a unit, for example, a combustion turbine?
Yeah, I'm going to give you a high-level answer and then ask that you would ask that of Mr. Holman, who's our system operator, who will be up later. But it is my understanding that, yes, you know, as we get solar, especially in a higher radiance, low load day, we have to decommit and recommit units to work around solar. As I've said, we used to, for a number of years, your generators need to follow load every minute, every hour, every week, every year. So we have planning that goes on from the minutely level all the way to the IRP that's 15 years, and it would follow load. Now generators follow load net of must-take solar. So it changes how your generation fleet is committed and dispatched to work around the impact of solar. And we've all seen the duck curve, and we've talked a lot about the shift to winter planning as a result of that.
Could this need to start a unit be avoided by dispatching down solar generation?
Solar generation outside of PURPA in our competitive procurement does give some dispatch down capability. Within PURPA, it's my understanding that you have a must-take obligation to take all power unless it's a system emergency. So that provision you've talked about is available to some extent in our CPRE to be able to dispatch down when it makes good economic sense to do that. But my understanding is it's not available as a tool within a standard offer PURPA contract, which requires the utility to buy the complete output from the solar generator.
Thank you.
Commissioners.
That's all I have.
Okay. Mr. Belser.
Thank you, Mr. Chairman. Good afternoon, gentlemen. Mr. Brown, just a few things for you. This morning, you used a term a couple of times, marginal energy. Could you explain that to me, please?
Yes, what I mean by marginal energy is sort of the cost of the last few megawatt hours that you're either generating or purchasing. Because when we dispatch the fleet, we use the cheapest power first, and then as we have to go up, we pay increasing amounts either by fuel or by purchase power if the market is there, until we meet what the load needs. So that's what I mean.
Also, in your discussion regarding the CPRE this morning, you mentioned a count for North Carolina. I'm not sure if you said RECs, RECs, or REPs for requirement purposes. Could you clarify which one you were talking about?
Yes.
I think it's REP.
The nomenclature I used was that the renewable energy credit,
so it's REC,
would count in essence for North Carolina compliance purposes in the North Carolina REPS law, excuse me. So we get to count those as clean energy for compliance purposes, yes.
But it's REC? I'm just trying to make sure I've got the right term. Okay.
Right.
Are you familiar with the Duke's unregulated subsidiary that bids on QF projects?
I am somewhat familiar with them.
Is there a minimum term of contract that that subsidiary requires when it bids on QF projects?
I don't know what their
Anybody that's going to be testifying that would know that? Do you know?
I don't know. I don't know.
Okay. Were you involved with responding to discovery requests from the parties?
Yes, I was.
And I believe Mr. Golden asked you some questions on 5-year contracts and responses to discovery requests?
Yes.
And it sounded like he didn't have up-to-date information. Was there a continuing duty to respond to those discovery requests of the parties?
Well,
I think you indicated that there was some contracts that have been signed in the last few weeks that would have increased the amount that he was asking you about.
Well, yes. In my testimony, there's an amount of solar and QF power of roughly 4,000 megawatts, and that's what was used. That snapshot in time was what was used to estimate the overpayment. Now, from that moment forward, we continue to execute contracts, the company, so that the total amount of contracts we have continues to go up over time. So the discovery that I remember was related to that 4,000 that was in the testimony, which would predate. I don't know whether there was another question later about following up on, has that 4,000 number changed? I don't see all the data requests.
Thank you, sir.
Sure.
Mr. Snyder, I'm not forgetting you.
Thank you,
You
Commissioner.
acted like you wanted to answer something to that last question.
Well, no, I was just going to add on actually I was thinking the other one, we said REX. It does confuse because there is actually an renewable energy portfolio standard, that is REP, and then you collect renewable energy credits to meet your REP standard. So we have a lot of acronyms in our industry, and I wanted to make sure you had them both. There is an REP and an REC.
And I didn't understand if he was saying rep or rec, and that's why I was trying to clarify.
Yep, and we have them both, and I think he was referring to the REC.
Mr. Snyder, do you have your Exhibit 1 with you? I believe this is a confidential exhibit. And without divulging any of the confidential information contained in this exhibit, can you just walk me through what the various parts of this exhibit are? I've got a rudimentary understanding and just want to make sure that I've got it.
Yes,
I'm not asking you to state any of the material that is deemed confidential in that document.
Turn to that exhibit. So this is the actual rate calculation support that we have to determine the ultimate rate. So what you're looking at in Exhibit 1 are the 9 different energy buckets. So you're developing a price by period. Again, we have, I believe it's 4 winter, 2 shoulder, and 3 summer price periods. So you'll see those 1 through 9 across the top. The avoided energy cost that we talk about, that I explained about that no cost 100. We say how much production cost value does that create? We then put that on a per unit basis, levelize it into those 9 buckets. That's what you're seeing in the avoided energy. That's really the part that most of this testimony has been about today. And then the rates group has a couple of adjustments they do for working capital, a loss factor, and an excise tax that brings it from sort of my realm to an actual filed rate. And so that's what you're looking at in Exhibit 1.
Okay. And then that's on pages 1 and 2, right? Is that correct?
Correct.
And then we get over to page 3, and that's termed avoided energy costs there.
Yes.
And how does that play into the schedules on page 1 and 2?
So I think this is
contains confidential, so please.
Right. Yeah, I'll be careful. All this does is we offer, those 9 energy buckets, and it's a 10-year levelized rate. So the rate doesn't change as you move throughout the 10-year period. This is just the yearly detail that goes into that 10-year calculation.
And then on page 4, tell me about the capacity credits.
So the capacity credits on page 4, again, are looking at the levelized cost, sort of return of and on that CT on an annualized basis. That capacity value is then taken, so you get think of an annual number. The annual number needs to be spread into the seasons and then into the capacity bucket hours. And then, so you'll see the seasonal allocation piece that does that. And what it does is it takes it from that annual number and moves it down to the peak hours, and then makes it, because you're starting with $1 per kW, you have to put it on $1 per kilowatt hour. So it looks at how many kilowatt hours are in that price period and moves it from that sort of annual number to a per kilowatt hour period. And that's what's taking place on page 4.
And then page 5 just takes that single year rate and puts it into a 5-year?
Yes.
And then page 6 makes it the 10-year long-term?
Yes.
And then page 7 is where y'all have calculated annual avoided capacity cost?
Yes, and that's where you'll see where we have a levelized cost using these annual numbers.
I think that kind of gets me to where I'm understanding. Thank you for that explanation. On page 15 of your testimony, where you're talking about that the company used the EIA data and adjusted the data to reflect economies of scale associated with building a 4-unit CT site. I think that's on page 15. My question is, if the calculation was for a single CT unit, would the resulting value under the Peaker methodology be more or less than the result of the company's studies? Instead of using the data, assuming a 4-unit site, what if it was just for a single unit?
Yeah, so to be clear, and I may need to, that should have said scope and not scale. So I'm sorry, I can't believe I didn't catch that before, but what we do for a,
well, how does that differ?
So
Scope and economies of scale.
So there's 2 economies that can be had. One is just the fact that you've got a big piece of property and you can fit turbines on that big piece of property. That's scope. What's the scope of the site, right? And then scale is actually how many units are you building at one time? So do I have to mobilize and demobilize a construction crew? Do I have to do engineering, for all of it at once, or do I do it sequentially? What we've done is the EIA data is for a single unit site. And we've said, looking at that, there are certain costs in there that you shouldn't multiply times 4. So you don't need 4 administrative buildings if your standard practice is to have multiple units at a single generation facility. And so there are certain economies of scope that we've made adjustments for that result in a lower capital cost to recognize, you don't have 4 different staffs, you don't have 4 different, administrative buildings, you have one gas M&R station and not 4 separate gas M&R stations. Those minor adjustments are economies of scope. We did not adjust for economies of scale. So we did not assume that we were going to build all 4 at one time and get the efficiencies that would come from only mobilizing and demobilizing a construction crew, let's say one time. We didn't back those out. So with economies of scope, what we've done, and I think I'm saying this backwards. I always tell my team I get the 2 mixed up, scope and scale, to your question. But we took the economies that were associated with having our IRP recognizes our history has been that we're not going to build a single CT here, there, and everywhere. We're going to have groups of CTs together. That's going to create some economies of scale. I think I just told you I get the 2 flip-flop, but I think scale is right. What we don't do is we don't assume any savings from building them all at one time. So that's how we adjusted the EIA data, was just to make the adjustments for the larger piece of property.
Do you always build 4?
Sometimes.
You reference your IRP and what the company usually does. Do they always build 4, or do they sometimes build 2?
They sometimes, very rarely, will we only have 2? Our average is more than 4. If you look at the number of units from, sometimes we'll have 2 simple cycles sitting next to 1 or 2 combined cycles, but the number of units that are on a single piece of property it averages over 4. You can find some unique examples where we only have 2 for unique reasons, maybe put next to a plant that already was needed for like voltage control out in the Sutton area, out in Wilmington. We might have just a little bit of generation there because there's not enough load, but that's not our typical practice. If you look at I think it's Appendix B to our IRP, we list out all of our gas facilities, and if you just sort of do a quick review of how many units we have at each of the gas facility site, you'll see that it's 4, 5, 6, 7, 8, by and large, more than 4.
But they weren't all built at one time.
And we don't include those building at one time in our number to get to EIA. So all that, again, just to be clear, and I'm sorry if I confused the issue, I apologize. The only thing we account for is having a big piece of property that can accommodate multiple. So one administration building, one gas pipeline coming in with one M&R, one substation. That's the economies we take into account. We do not adjust the EIA numbers to assume we're building them all at one time. So the mobilization, demobilization, the efficiencies you would get if you just sort of rolled a crew in and built 4 at a time, we do not reduce EIA numbers. To be clear, we did not adjust our EIA numbers to reflect those economies of scope, only the economies of scale that come with the scale or the size of the.
Well, in the adjustments that y'all performed, whether it was to scope or scale, and
yeah, I apologize. Yeah.
Did that increase the EIA data or decrease it?
It decreased it.
Let's see. The performance adjustment factor. You indicated that inclusion of a PAF in calculating capacity values is an example of how Duke's application of the Peaker methodology treats QFs on a fair and equal footing with utility-owned resources.
That is correct.
Sound correct? How does use of the performance adjustment factor treat QFs equally as utility-owned resources?
I will note, I've looked at some other people's. I don't see anyone else that puts in a PAF. We think it's appropriate. It raises the avoided cost. What it does is it says we look at the fact that the avoided peaker is going to have a certain amount of forced outages, and we can estimate what that is based on historic data. And we say to be fair and just with the QFs, we should increase our capacity cost to recognize that the QF shouldn't have to be 100% available to earn 100% of the capacity credit, just as the CT is not 100% available. So if the CT has a 95% availability rate and we add 5% to the avoided cost, then both the QF and the peaker are on an equal footing. So the QF, if he's available 95% of the time of the capacity hours, gets 100% of the capacity cost. If they, for some reason, were some type of QF that is there for all of the capacity hours, they would actually get 105% of the peaker cost, of the annual peaker cost. So it's a multiplier to increase the capacity rate in an effort to put the QF on an equal footing with the utility.
Thank you. On page 16, you were discussing when the need, when the IRP would identify avoided or capacity need, and it was 2026 for DEC and 2020 for DEP.
Correct.
Sound familiar? Why did DEC's first year of need arise 2 years earlier in the update than in its 2018 IRP?
We had an increase in our load forecast. It showed that units now needed earlier.
And that was just from 1 year to the next.
Yeah.
What caused that?
Our economic outlook, we'd been getting some criticism that our forecast might be too low given how much load growth and peak demands we've been seeing. And our load forecasting team is continually re-looking at the load forecast every year. And they saw, an increase in the amount of, I think it's driven by customer growth is part of it, as well as wholesale, what our wholesale customers are, which are largely residential, are consuming. They update their forecasts as well. We review that. So between the retail and the wholesale load forecast, we saw an increase that moved our need from 2028 to 2026. And that served to increase the avoided cost rate from the 2018 IRP to the 2019, Commissioner.
On pages, well, it's actually the tables, the pricing periods in your testimony, and it's also your Exhibit 2, where you have both of them together. Why would there only be 3 pricing periods for voided capacity when Duke is proposing 9 periods for avoided energy rate? Why should there not be a match of that?
Let me start with try and keep this brief, but energy is the marginal, as Mr. Brown was explaining, we have a host of different units, right? And so energy looks at what's the marginal unit, and as I explained earlier, what's the value of actually a 100 megawatt decrement. And that changes by season and time of day, because you have different units that are running, let's say, on the margin, or that top of the stack in the spring and the fall than you have in the summer and the winter. So right there you have different seasonal, your loads aren't as high, you're not running as much of your resource portfolio in the shoulder months. In the winter and in the summer, you have a very different load shape. So I wish I had a graphic in my testimony, I don't think I do, but in the winter you have this double hump, right? So you have a very high winter morning peak, load comes off as it gets warm during the day, and then when the sun sets, load goes up again. So you get this camel-shaped load impact. As you add solar, that camel shape gets even more pronounced. And that sets different marginal units as you move throughout that day. You have a lot of your fleet on in the morning, then some of it comes back off, and then some of it comes back on. So you have these pricing periods that are trying to recognize, where am I in my fleet? And I'm dispatching them from least expensive to most expensive. So you're trying to send the right price signal by time of day. And you're saying, here's when my prices are high, medium, and low. And that varies by month, or by season, and certainly by hour without the day. That's the reason you go to 9. Capacity is an entirely different animal. Capacity is saying, when are the handful of hours within a year where I'm in danger of not being able to serve load because I simply don't have enough generation in my fleet? And that's what we use, what's called a loss of load expectation study. When is all of that loss of load risk being driven during extreme weather events? So IRP is weather normal. You carry a reserve margin to deal with this LOLE. What if I get extreme weather? And that extreme weather then says, well, when am I likely to need capacity to avoid this loss of load expectation? That is all grouped into a very finite number of hours, right? If you actually look at our LOLE calculation, it shows that the winter morning carries by far the highest loss of load risk. And that's what we've experienced in reality, and that's what the models forecast in the future. So you have a much smaller group of hours that are needed for capacity than you need for energy. There's energy value in every hour. There's only capacity value, that marginal capacity value, during the hours that generate loss of load risk.
And you mentioned the LOLE study. That's a recognized study that is done, and y'all put great faith and stock in that. Is that correct?
Yeah, we use LOLE to do our reserve margin study. It's an industry recognized approach for calculating across the country. Yep.
I want to talk about the avoided cost periods a minute, but let me just, were these avoided cost periods that are proposed in the application developed in response to the North Carolina Utilities Commission's requirement to offer more granular rates that better align with the actual cost of generation during each period?
Yeah, that certainly is one of the considerations. I mean, the company was looking at making them more granular. We'd been talking to stakeholders about it. The North Carolina Commission actually ordered it, but it was something that we were fully supportive of. And then we worked through quite a bit of back and forth with the public staff in North Carolina to come up with the right level of granularity without trying to be too granular.
And correct me if I'm wrong, but I understand that the companies operate their power systems across the NERC balancing areas, and that encompasses DEC and DEP service territories across both states. Is that correct?
That is correct.
Are the avoided energy costs in North Carolina and South Carolina the same, or at least generally the same?
Yes, they are. I mean, except for, and when you're talking about the rates, we filed North Carolina a little bit earlier, so some of the things have changed. Like I said, we went from the 18 IRP to the 19, but in terms of if we were to file the same rates at the same time, we would have the identical rates. So we wouldn't have, with some very minor differences. I think there's some, in the rate details, some difference in the excise taxes and some of the nuances, but from a generator IRP perspective, our complete generating fleet serves the entire balancing authority. There isn't a set of generators to serve South Carolina and a different set to serve North Carolina. That's not how we operate the fleet.
And I want to make sure that I'm clear on something from this morning, but the avoided cost, I think it's quite clear that the avoided cost analysis in y'all's application and testimony is based on the IRP updates for 2019. Is that correct?
That is correct.
Now, does that update reflect the accelerated retirement of the 5 coal plants that was announced in September?
They do not.
And what are those what are the implications for avoided energy and avoided capacity cost analysis by not reflecting those early retirements of those 5 coal plants?
So I'll walk through it. I think it's an important issue. I've explained our rationale and how the process we follow, but the impacts are as follows. So at DEP, we haven't, we're not even talking about DEP. So just at DEC, what we're looking at is right now, the accelerated coal units would do 2 things. They would change when your first need was. So instead of 26, I believe, based on some preliminary work, we would move that up 1 year to 25. But we would also, there was another retirement that was moved up in Cliffside 5. As those retirements move up, the more efficient replacement generation moves up with them, right? So you can't just retire and have no change in the rest of your resource plan. So in DEC, while you would have, instead of your first need in 26, it might move to 25 now, but you would also have more efficient generation coming in sooner that would serve to lower the avoided energy rate, because you're taking less efficient generation offline, you're accelerating more efficient generation, and so you would have a lowering of your avoided energy rate and a slight increase in the avoided capacity rate. Now, as it applies to solar, without storage, they're not going to see much on the capacity side of the equation because they're not available in the capacity hours, but they would see the lower energy rate from having the more efficient. So this certainly was not an example of us in any way biasing our filing in this proceeding. Had I snapped that chalk line a month later and assume again that the commission approved it and that it was in the IRP, we would have actually without having done the calculations, I can tell you methodologically, we would have had lower rates in this proceeding. So we think once this is approved, we'll incorporate that in the 2020, but until then, we left the rates higher.
Thank you,
So that's about it on that.
I appreciate your patience with me. Thank you very much.
No, appreciate it, Commissioner.
Mr. Whitfield.
Thank you, Mr. Chairman. Good afternoon. Good news is most of my questions have been asked. I know Commissioner Williams hit you with a couple of tough ones, and there is one I want to follow up possibly with Mr. Holman on about the CTs. We'll get to that next, as you referred to. But Mr. Snyder, if you could, I know that with this partial settlement agreement that was introduced earlier today, and I'm kind of like Mr. Bateman, I'm still kind of wading through it too. And I know Cross has been limited to that, but if you could, of course, the commission still has to approve or not approve regardless of what happens. So I want to ask you about item 3 of that settlement. Do you have that in front of you?
I do not have it in front of me.
Give you a second to get that. I just... You there?
I'm there.
You there? Okay, on page 3, item 3, you say Duke, or excuse me, the part of the terms of the settlement says Duke cannot impose the solar integration services charge on a solar QF that is a, quote, control solar generator. And you go on to say, meaning generally any solar QF that demonstrates its facility is capable of operating and contractually agrees to operate in a manner that reduces the need for additional ancillary service requirements. Could you talk about that just a little bit, the need for additional ancillary services or service requirements? And then you go, of course, you say, but not limited to QFs with battery storage. So obviously, there's some room for technology improvements, but talk to me a little bit about those ancillary services and help me get my arms around item 3.
Certainly. So this is, what we're talking about here is ancillaries are generally, when I said generation has to follow load minutes a minute.
Right.
So you have to have online generation that's capable of moving to follow load, and now you have to have it to follow load plus solar. And I had a graphic in my direct testimony that showed, just an example of what intermittency looks like. It wasn't intended to be quantitative. It was more illustrative in my direct testimony, and I was trying to turn to that real quickly. And so what happens is the system reserves a little bit more online generation to be able to follow that load. And item 3 talks about if a solar generator deploys a technology in a manner that gets rid of that intermittency. So maybe it's using battery storage to produce a smooth output. It wouldn't be appropriate to charge them for an ancillary service charge because they're not causing that need to hold more of that generation back to follow load. So what we meant to show there is if they have the battery and then deploy it in a manner that reduces volatility, they would be exempt from the integration service charge. And I think all parties agree that that's a good thing.
So it didn't just have, and that's my question, it didn't just having the technology and the capability, it's deploying it in a manner that reduces that volatility.
Yes, I mean, I show an example on figure 5, page 40 of my testimony that sort of shows sort of controlled and uncontrolled.
Right.
And it's, again, illustrative example. I don't want anyone to say that this is the quantitative perfect example, but it basically says you can you can deploy a battery if you choose, and again, this is at the developer's discretion, to smooth that output from what was the green line in Figure 5 and move it to that red line. And if they're able to do that, then they should not be charged the solar integration service charge. And so in the stipulation, we've agreed to that term that, if they operate in that manner and demonstrate that, we're in agreement that charge should not be, imposed upon that developer.
Thank you. That's all I have, Mr. Chairman.
Commissioners, any other? Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Snyder, what does the term flexible solar mean to you?
Flexible solar means a solar developer that employs technology that allows it to change the total must-take output to shape it differently. And so, in just explaining to Commissioner Whitfield, again, I tend to think of this more at the negotiated space than these smaller, 2 megawatt and under that's at case here today in these rates. But if someone came to us in a negotiated space and said, I would like to, have a PURPA-based rate for 10 years, and I'm going to put a 1 hour lithium-ion battery that I'm going to use to smooth my output, and they can demonstrate moving from that green line to the red line, then we would say that's a controlled generator that would not be subject to the charge.
Do you have any of those in your fleet at this time?
We had a couple, as Mr. Brown alluded to, that successfully bid into our competitive procurement. They are not yet online, and it'll be up to them to decide how they want to use that battery storage. They may decide it's more economic to just shift energy from one pricing period to another and not try and smooth. They may try and smooth. They may try and do both. I mean, we'll certainly see how that, once we have some experience with them, how they deploy those batteries.
Do you see the cost of batteries dropping dramatically over the next few years?
We do expect declines in batteries, and per my comments earlier, we'd like to see consumers benefit from those declines.
Thank you, sir. Those are all the questions I have.
Thank you. Commissioners, any other questions? Gentlemen, let me just ask you this real quick. With respect to the CPRE which you employ in North Carolina, is it true that DEC and DEP didn't meet the goals in Tranche 1 of the program? And I guess that's meaning that not enough projects were selected to sign the PPAs.
Duke Energy Progress did meet the goal.
Okay.
And Duke Energy Carolinas did not meet the goal. Duke Energy Carolinas, the original target was 600 megawatts, and I believe we ended up somewhere around 450 megawatts. But in Duke Energy Progress, we were looking for 80, and I think we got 86 megawatts.
Okay. Thank you. Companies have indicated that avoided costs often decline as additional solar is added. If this occurs and the avoided cost ceiling of the CPRE program declines further, might it be more difficult for the companies to realize their procurement targets for the CPRE program?
So
your red light was first.
Okay, we're battling over this one. I'll let Mr. Brown have his turn. I think that's one factor, but we just talked about declining technology costs too. So the question is, what declines faster? Do solar facilities get cheaper faster than their value declines or not? So I think just because you're adding solar doesn't mean you're not going to clear if that solar is enjoying the benefit of declines in its cost structure.
I would generally agree with that, what Mr. Snyder said.
Okay, thank you. Commissioners, any other questions? Any redirect?
Very briefly, Mr. Chairman.
And if you don't mind, I was going to attempt to use the Elmo. Mr. Brown, I just wanted to follow up on the exchange that you had earlier with Mr. Golden and just more recently with Commissioner Belzer with regard to the responses by Duke Energy Carolinas and Duke Energy Progress to Johnson Development's interrogatories. I believe the interrogatory that was being asked about is this, which is what we call 1-1. Do you recognize this? I've put it up for display.
Yes, I do recognize that, yes.
And were you involved in the response to this interrogatory?
Yes, I was.
And if you don't mind, could you just read the interrogatory 1A?
Please provide how much of the QF power cited to was specifically financed under a 5-year PPA and under a variable rate contract.
And do you mind reading the first part, the after number 1, that starts with respect to?
With respect to the direct testimony of George Brown on page 9, starting at line 8.
Thank you. And you have your testimony with you, correct?
Yes.
Could you look at page 9, starting at line 8?
Yes.
And could you read the question and read the first sentence of your response, please?
The question is, how many megawatts of QF power are the companies currently obligated to purchase pursuant to PURPA? Answer, as of July 1, 2019, the companies have almost 4,000 megawatts of QF PURPA power under contract on a system basis, with the significant majority of these QF purchase obligations being in DEP. Figure 1 depicts the significant year-over-year growth of QF PURPA contracts in DEP and DEC from 2011 to July 1, 2019.
Thank you, Mr. Brown. So is it your understanding then that the interrogatory from Johnson Development was specific to this portion of your testimony?
Yes, that is my understanding.
And do you believe that as of July 1st, 2019, the 5-year PPAs that you referenced earlier would have been executed at that time?
Which 5-year PPAs?
With regard to the 5-year PPAs that were in question, would those have been executed as of the date of July 1, 2019 and encompassed in the 4,000 megawatts?
No, the ones I referenced verbally today would not have been in that number because I believe they were executed after that date.
Thank you. And to the extent that this was an ongoing, that there was an ongoing obligation to update the data request, because because your testimony was specific to the amount of megawatts that were under contract as of July 2019, then would you have believed an obligation to exist to further update the discovery response?
I would not.
Thank you. No further questions. Thank you very much, Mr. Chairman.
Thank you. Any recross?
Sorry, Mr. Chairman, I was finishing with Mr. Brown. We may have one for Mr. Schneider, if it pleases the commission.
Sorry.
Not a problem, I'll be brief. And I think...
Make sure you're in front of that microphone.
Tough being tall. I will be brief, and I think it'd be most helpful if I pass out a redirect exhibit that will expedite my questions. So, Mr. Schneider, scale and scope.
Yes.
15, line 3 of your testimony. Just to confirm for the commission, Commissioner Belzer asked you some questions. Is your testimony as it is written today accurately stated?
Yes, it is. I'm sorry, I mixed those up when I was speaking to the commissioner, so it's correct as written.
Thank you. And the document that I've provided you here, are you familiar with this document? Would you agree with me that this is a response by Duke Energy to the South Carolina Solar Business Alliance third set of requests for production of documents,
Yes, it is.
specifically interrogatory 3-9?
Yes.
Yes, it would have been interrogatories and requests for production. So this is interrogatory 3-9. Would you have been responsible for either drafting this response or supervising its?
I reviewed it before it went out.
Thank you. And so the Solar Business Alliance specifically focused on this and asked about the company's adjustments for economies of scale and whether adjustments were made for economies of scope. Is that generally accurate?
Yes.
And I just won't spend a lot of time going through it, but their first sub-A, they asked you to describe in detail the adjustments that were made to reflect economies of scale.
That is correct.
You and your team proceeded to do that over the next page and a half or so?
That is correct.
Okay. And then on page 9, just middle of the page, second, I guess it would be the third bullet down, it specifically says, fourth line in the middle, that the EIA adjusted estimate does not include economies of scope.
That is correct.
That's consistent with your understanding.
Yes.
And then subpart B to the Solar Business Alliance request, because they were investigating whether this was a fair adjustment to be made, they asked how many sites in the last 10 years or planned to be constructed the next 10 years had CT units at each site, so multiple CT units at a single site. Is that
Yes.
generally the gist of that question?
Yes.
And then starting on 9 and going over to 10 of this request, the company identified the power stations for Duke Energy Carolinas and Duke Energy Progress, where there's kind of going top of page 10 from the largest to the smallest number of CTs. Would you just walk through that quickly for the commission?
Yes. So on top page 9, I show where Lincoln has 16 CTs, Darlington has 13 CTs, Mill Creek is 8, Smith, Wayne, Rockingham, 5 CTs each, Blewett, Weatherspoon, 4 CTs, Asheville, Sutton, Lee, 2 CTs.
So just my math is 8 of the 11 power stations identified have 4 or more CTs. Is that?
That is correct.
Thank you. Mr. Chairman, I think I neglected to ask this to be marked as an exhibit, but this time I'd like for it to be marked and entered into evidence if that's acceptable to you. That's all.
We will mark it and enter it as exhibit number 5.
Thank you, sir. No further questions from me for Mr.
Thank you. Thank you. Any recross?
Mr. Schneider and Mr. Breitschworth, thank you for clearing that issue up. I appreciate that. Mr. Brown, Commissioner Randall asked you, I think just as sort of at the tail end of your discussion, about the possibility that the company may have a hard time meeting its CPRE targets in future tranches, given the experience in Tranche 1. Do you recall that?
Yes, I do recall that question.
Okay. And actually, Mr. Brown, it may have been you, it may have been Mr. Steiner's response that sort of reduced the question to, well, what declines faster, technology costs or avoided costs? Mr. Steiner, was that your testimony?
Yes, it was.
Okay. The company published I guess I'll call it a CPRE cost cap prior to Tranche 1. Is that right?
Yes, it did.
Okay, and that represented the avoided cost sort of on a 20-year rate at the time. Is that right?
Yes, it is.
And what was the cost cap for Tranche 1?
I don't have that in front of me. It was a rate for each of the time periods.
Okay. It wasn't a single all-in number.
No.
Okay. Has the company published that for Tranche 2?
I believe they've published, I don't know if it's the final one, but I believe they published at least an indicative. I don't run that process, but it's my understanding that has been shared with stakeholders.
I believe that's correct too.
Okay.
But the final one will have to be, I think it has to be worked because the orders just came out from the commission.
Understood. So, Mr. Snyder, did you have a hand in calculating that 20-year rate?
I am familiar with it, yes.
Okay. Can you tell me sort of generally in a ballpark way how much that cap has declined between tranche 1 and tranche 2?
Generally, I know it's come down. I just, without the numbers in front of me, I don't want to, I don't think it was massive, but there was a decline. I just don't have the percentage in front of me. I'm
Okay,
sorry.
could you say whether it was, has it come down more than 25% or less than that?
I don't think the energy rates have come down that much. I think the capacity rate has come down.
Okay. You'd say, so possibly by more than 25%?
In total, I don't believe it's that much, but again, I'm sorry, I just don't have those numbers in front of me.
Understood, thank you. And between the publication of the cost cap for tranche 1 and the preliminary cost cap for tranche 2, how much time do you think has elapsed?
A little more than a year. Little more than a year, is that right, George?
I'm trying to calculate it in my head. Yeah, probably a little more. Probably a little more than a year.
Okay, a little more than a year. Thank you. And do you think that technology costs for solar PV and storage have come down by that much in a year, as much as the avoided cost cap has?
Very well. I mean, I don't know. I've seen some pretty impressive bid prices, both internally and from around the country that, just a year or two ago, I would have thought would be, a pretty big drop, but they managed to come in. So we're seeing declines. I don't know when that flattens out. I guess we'll get that information when we see how tranche 2 goes.
Okay, so, but you've just spoken about bid prices, not about actual development costs, is that right?
I'm assuming that bid prices reflect development costs. I don't think anyone's going to bid at below cost.
Okay, thank you.
Thank you. Any other recross? Okay. If not, gentlemen, thank you for your testimony, for your direct testimony, and you may step down. Okay, we're going to take a 10-minute break, and then we'll call the next panel. Okay, so we're way behind where I thought we ought to be by this time, so let's call this next panel.
Thank you, Mr. Chairman. We'll move things along just as quickly as we can. The committee is called Steve Wheeler and David Johnson.
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Mr. Chairman, in the interest of clarity for the commission, Mr. Wheeler and Mr. Johnson will be presenting their direct and their rebuttal testimony together. So bear with me, the intro is just a little bit longer, but you only have to see them once. So we'll move this right along. I'm going to start with you, Mr. Wheeler, please. Can you please state your name for the record?
Well, cut your microphone on. There you go. Well, one more time. Oh, you didn't get it. Now you're on.
Stephen B. Wheeler,
And by whom are you employed and in what capacity?
Duke Energy Business Services as a Pricing and Regulatory Solutions Director.
And did you cause to be pre-filed in this docket direct testimony consisting of 32 pages?
Yes.
Do you have any changes to your direct testimony at this time?
No.
And so if I were to ask you those same questions contained in your direct testimony today, would your answers remain the same?
Yes.
Mr. Chairman, I would ask that the direct testimony of Steve Wheeler be entered into the record as if given orally from the stand.
Mr. Wheeler's pre-filed testimony will be entered into the record as though given orally from the stand.
Thank you. And Mr. Wheeler, did you also cause to be prepared 12 exhibits to your direct testimony?
Yes.
Do you have any revisions to those exhibits at this time?
No.
Mr. Chairman, I'd ask that Mr. Wheeler's 12 exhibits be marked as the next hearing exhibit.
Mr. Wheeler's 12 exhibits will be marked as hearing exhibit number 6.
Thank you. Mr. Wheeler, did you cause to be pre-filed in this docket rebuttal testimony consisting of 30 pages?
Yes.
Do you have any changes to that rebuttal testimony at this time?
No.
So if I were to ask you those same questions contained in your rebuttal testimony today, your answers would remain the same?
Yes.
Mr. Chairman, we'd ask that the rebuttal testimony of Mr. Wheeler be entered into the record as if given orally from the stand.
Mr. Wheeler's rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you. And finally, Mr. Wheeler, did you cause to be prepared 5 rebuttal exhibits?
Yes.
Do you have any revisions to those exhibits at this time?
No.
And Mr. Chairman, finally, I would ask that the 5 rebuttal exhibits of Mr. Wheeler be marked as the next hearing exhibit.
Mr. Wheeler's 5 rebuttal exhibits will be entered into the record as hearing exhibit number 7.
Thank you.
And I think I just said his 12 previous were marked, and we'll enter those as exhibit number 6.
Thank you. All right. So, Mr. Wheeler, you've said that you are the Pricing and Regulatory Solutions Director for Duke. Can you tell the Commission a little bit more about your background and what your responsibilities are as they relate to this proceeding?
I've been employed by Duke Energy and its predecessors for over 43 years. My early years were in the customer service capacity where I assisted customers with their energy needs. For the past 35 years, I've worked in the rates and regulatory area with primary responsibility for the development, design, and administration of company tariffs. This includes the development of rate designs that attempt to better align tariff rates with cost causation principles and incent customers to consume electricity in an efficient manner.
Mr. Wheeler, is it fair to say you've testified before this Commission a few times?
Yes, this is my last. I hope.
Mr. Wheeler, on page 4 of your direct testimony, you state that the purpose of your testimony is to support the company's standard offer tariffs, standard offer PPA, and the standard offer terms and conditions. It's a lot of documents. Could you explain those for the Commission, please?
Yes. The company's purchase agreement with a QF consists of 3 distinct parts. The standard offer purchase power agreement sets forth the specific details regarding the QF's facility and its interconnection to the grid. It includes the description of the facility, the site location, delivery voltage, generation capacity, description of the facility, and other information that is unique to the site, such as an energy storage protocol, be part of that purchase power agreement. The second piece is the standard offer purchase power schedule. The schedule sets forth the rates and price parameters that apply to the QF, essentially how much we pay them for what we purchase. And the third piece is the standard offer terms and conditions for the purchase of electric power. This sets forth the agreement and how we administer it. It has details such as how often payments are made, what happens if a meter breaks, how do you handle that, and other parameters that deal with the administration of the contract on a day-to-day basis. All three of these tariffs are subject to review and revision in each avoided cost proceeding, subject to commission approval, to ensure that they continue to adequately serve the interests of retail customers in the QF community. However, any levelized rates in their essential terms are not subject to revisions until the conclusion of their contract term.
Thank you. And I want to make sure we're all on the same page here. So the contracting documents that your testimony supports, those are for smaller QFs, right?
Yes, smaller than 2 megawatts. Act 62 specifies the company's standard offer tariffs only applicable to QFs with a capacity of 2 megawatts or less, and that's what these documents relate to.
Thank you. And could you please describe for the Commission the issues set forth in your rebuttal testimony that you believe to still be in contention today?
Yes. First, as I described in my rebuttal testimony, ORS witness Horry agrees that these documents are commercially reasonable. The only issue raised in my rebuttal testimony that is still under contention is the provision requiring a QF to deliver power within 30 months. As I described in my rebuttal testimony, this provision ensures that retail customers aren't paying stale and inaccurate avoided cost rates due to extended delays in the construction of a QF facility.
You also testify to the implementation of the integration services charge, is that correct?
Yes, that's correct.
And are you aware of the stipulation that has been reached by certain parties in this proceeding regarding the integration services charge?
Yes, I am. Duke supports the terms of the stipulation. I believe the stipulation represents a fair, reasonable, and full resolution of all issues in this proceeding regarding the integration services charge. Moreover, my testimony should not be construed as advocating any position that is contrary to the terms of the stipulation.
Thank you. Mr. Chairman, in witness Levitus's rebuttal testimony, he raises issues for the first time that Mr. Wheeler has not had an opportunity to respond to through his pre-filed testimony by the order of the way that you receive testimony. I would like to ask Mr. Wheeler to address those very briefly because without that, he has not had the opportunity to respond to witness Levitus's rebuttal testimony.
Okay, go ahead.
Thank you. So, Mr. Wheeler, does Mr. Levitus raise any issues for the first time in his rebuttal testimony that you have not addressed in your pre-filed testimony?
Yes, Mr. Levitus proposes that Duke should link the requirement to deliver power to the in-service date of the interconnection facilities and network upgrades.
And do you agree with his proposal?
No, I do not. Mr. Levitus' proposal would significantly extend the length of the time that can pass after QFs lock into avoided cost rates until they begin delivering power to the grid. Moreover, the language in the tariff currently provides QFs an extension if they are delivering power within the 30 months, but their construction is nearly complete and they demonstrate a good faith effort to complete their project in a timely manner.
Thank you. And does Mr. Levitus' rebuttal raise any other new issues that you have not had the opportunity to address through your pre-filed testimony?
Yes, Mr. Levitus requests that the terms and conditions be clarified.
Oh, hold on one second, Mr. Golden.
Mr. Chairman, on behalf of JDA and SBA, for the record, I would object to this. This is essentially a sir rebuttal, which is not allowed under commission practice nor procedure, and would ask that that not be allowed.
Mr. Chairman, if I may respond, council will have plenty of opportunity to respond to the testimony that Mr. Wheeler is giving right now. And I think that's fair for the commission to hear a response from the rebuttal testimony where there's not any opportunity provided otherwise through pre-filed testimony.
Mr. Chairman, the scheduling order was set specifically to file testimony with direct rebuttal, sir rebuttal, not sir rebuttal. And so it's not in pre-filed testimony. Mr. Chairman, I would also offer, if they want to cross-examine Mr. Levitas at the appropriate time about his rebuttal testimony, that we do not have any problems with.
I just would offer in response that at the commission's discretion, to me, it would seem as if it would be helpful to hear from Mr. Wheeler's opinion of, I can't provide Mr. Wheeler's opinion to Mr. Levitas through cross, so Mr. Wheeler's opinion of what Mr. Levitas' recommendations are.
Okay. All right, we're going to let you talk, but we're without any. I'll be honest. I've played a judge on TV, but not. Sir, rebuttal's the first one on me. So not on TV, on stage.
Sounded
sorry.
good.
So, sir, rebuttal is only supposed to be in response to rebuttal. So, we're going to continue on, and we're going to let y'all talk to Mr. Levitas as well, and we'll have all that straight.
Thank you, Mr. Chairman.
Thank you, and duly note everybody's objection. And
Mr. Chairman, I just want to be clear what you mean by continue on. Would you like for me to continue with Mr. Wheeler? We'll be very brief. Thank you. Mr. Wheeler, if you could, that was my last question to Mr. Wheeler, so if you don't mind just finishing that, thank you.
Mr. Levitas requested terms and conditions be clarified to provide that Duke's consent to requested material alterations will not be unreasonably withheld, conditioned, or delayed. Duke believes it is understood that terms and conditions will be applied on a reasonable basis, but doesn't oppose this proposal, doesn't oppose it if the commission deems it to be appropriate. Kind of assumes that we unreasonable in our interpretation of the terms and conditions, and we don't think that's really how we would normally interpret our tariffs. Mr. Levitas also states that terms and conditions should only be applied prospectively to new PPAs. I disagree with Mr. Levitas since it contradicts existing long-standing language in the rate update section of Schedule PP in Provision 1B of the terms and conditions. This language was repeated to be clear that all provisions of the company tariffs are subject to review and revision by the commission, and upon approval would apply to all standard offer QF purchases. The only exception that's identified in this language is that any levelized rates will not change during the contract term to offer the QF the price certainty necessary to secure financing.
Thank you, Mr. Wheeler. Thank you. Mr. Johnson, I'm going to turn to you. Can you please state your name for the record?
David B. Johnson.
By whom are you employed and in what capacity?
Duke Energy Corporation as Director of Business Development and Compliance.
Did you cause to be pre-filed in this docket direct testimony consisting of 38 pages?
Yes, I did.
Do you have any changes to your direct testimony at this time?
No.
So if I were to ask you those same questions contained in your direct testimony today, would your answers remain the same?
Yes.
Mr. Chairman, I would ask that the direct testimony of David Johnson be entered into the record as if given orally from the stand.
Mr. Johnson's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Johnson, did you prepare two exhibits that were attached to your direct pre-filed testimony?
Yes, I did.
Do you have any revisions to those exhibits at this time?
No.
Mr. Chairman, I'd ask that Mr. Johnson's two direct testimony exhibits be marked as entered into the record and marked as the next hearing exhibit.
Mr. Johnson's exhibits will be marked and entered into the record as hearing exhibit number 8.
Thank you. And Mr. Johnson, did you cause to be pre-filed in this docket rebuttal testimony consisting of 43 pages?
Yes.
Do you have any changes to your testimony at this time?
No.
So if I were to ask you those same questions contained in your rebuttal testimony, would your answers remain the same?
Yes.
Mr. Chairman, we'd ask the rebuttal testimony of Mr. Johnson be entered into the record as if given orally from the stand.
Mr. Johnson's rebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Johnson, did you also cause to be prepared two exhibits with your rebuttal testimony?
Yes.
And do you have any revisions to those exhibits at this time?
No.
Mr. Mr. Chairman, I would ask that the 2 exhibits to Mr. Johnson's rebuttal testimony be entered into the record and marked as the next hearing exhibit.
Mr. Johnson's 2 exhibits will be entered into the record as hearing exhibit number 9.
Thank you. So, Mr. Johnson, I'd like to very briefly walk through your direct and rebuttal testimony to provide an overview of it to the Commission. You've said you're the Director of Business Development and Compliance. Can you tell the Commission a little bit more about your background and what your responsibilities are as they relate to this proceeding?
Yes, I've worked at Duke for about 39 years now. In my current role, I'm responsible for all the PPAs that Duke enters into with third parties, including negotiation of the PPAs and the ongoing management after they've been executed. Prior to the Duke Progress merger, I did similar work for Duke Energy, where I managed a group that was responsible for the negotiation of all the PPAs.
Can you tell the Commission what the purpose of your testimony is in this proceeding?
My testimony sponsors the PPA for projects 2 megawatts and greater. My testimony refers to this as the large QF PPA. I also sponsor the Notice of Commitment to Sell form.
Let's first talk about the large QF PPA. Could you provide a brief overview of this PPA for the Commission?
Yes, the large QF PPA, which is included as Exhibit 2 to my testimony, is a form contract that QFs larger than 2 megawatts can use to sell power to Duke. My rebuttal testimony points out that ORS witness Horry found the large QF PPA to be commercially reasonable. My rebuttal testimony also addresses SBA witness Levitas' comments on the large QF PPA. I would note that, as pointed out in witness Levitas' rebuttal testimony, only a few issues addressed in my rebuttal testimony are still in contention.
Could you describe those remaining issues from your rebuttal testimony that remain in controversy today?
Yes. The first issue has to do with when a QF can enter into a PPA. As described in my rebuttal testimony, we believe it is appropriate for a QF to enter into a PPA after it sends a facility study agreement back to the utility. At this point in time, the QF has insight into its interconnection and system upgrade cost and can evaluate the commercial viability of the project. In order to accommodate witness Levitas' request to create a flexible commercial operation date, adding this provision was also important to Duke to ensure QFs are not prematurely entering into PPAs as a result of this added flexibility. Witness Levitas advocates that a QF should be able to enter into a PPA once it has been an interconnection customer for 1 year. However, as I describe in my rebuttal testimony, without knowing interconnection cost and estimate of time frame to achieve COD, the QF facility is not to the point in the development process of knowing whether the generating facility is commercially viable. The second issue has to do with whether the QF should be allowed to terminate the PPA because its interconnection costs are more than $75,000 per megawatt. My rebuttal testimony explains that this is an unnecessary provision because under Duke's proposal, the QF would already know its interconnection cost before entering into a PPA. But more importantly, this option would not provide for a binding commitment by the QF, as it could terminate their PPA without penalty. I would note that these 2 issues also apply to the Notice of Commitment form.
So now I would like to move to the Notice of Commitment form. I understand this to be a complicated concept, so could you provide a brief overview to the Commission, please?
Yes, as I explained in my direct testimony, the Notice of Commitment form is simply a form that the QF can execute in order to lock into avoided cost rates if certain conditions are met. The concept of the Notice of Commitment form was created in Act 62. My understanding of Act 62 is that the legislature wanted to create a way for the QF to sell power to the utility pursuant to what is called a non-contractually legally enforceable obligation.
Could you describe your understanding, as it's set forth in your testimony, of a legally enforceable obligation?
This is a complicated legal standard, and as I point out in my testimony, I'm not a lawyer. However, as I describe in my direct testimony, my understanding is that the FERC describes a LEO to be created in two ways. First, through a PPA, which we have proposed in this proceeding. And then second, if the utility refuses to enter into a PPA, a QF can create a non-contractual LEO.
And what is your understanding of how a non-contractual LEO is formed, as you've explained in your testimony?
As I describe in my direct testimony, my understanding is that the QF must commit to sell its power to the utility such that a binding, legally enforceable obligation is created.
So going back to the notice of commitment form, can you describe the intervener's comments to the form as you describe in your rebuttal testimony?
Yes, my rebuttal testimony points out that ORS witness Horry found the notice of commitment form to be commercially reasonable. My rebuttal testimony also addresses SBA witness Levitas' comments on the notice of commitment form. I would note that, as pointed out in witness Levitas' rebuttal testimony, only a few issues addressed in my rebuttal testimony are still in controversy.
And could you describe what issues from the notice of commitment form you understand to still be in controversy? And I'm asking about those issues raised in your rebuttal testimony that you believe to still be in controversy.
Yes, as described in my testimony, it's reasonable to require a QF to deliver power within 365 days after executing a notice of commitment form to ensure that QFs are not locking into prices or into rates for an extended period of time, and then requiring customers to pay for those stale rates on those purchases. My testimony points out that the 365-day period is less stringent than the requirements in other states like Texas and New Mexico. The second issue that's still in contention is the requirement that a QF must secure all environmental permits and land use approvals in order to execute the notice of commitment form. I believe that this is a reasonable requirement that demonstrates a commitment by the QF to develop the project and sell power to the utility.
And again, Mr. Chairman, and I'll direct this to SBA witness Levitas' counsel as well, there were two issues raised in witness Levitas' rebuttal testimony for the first time. One is with regard to a surety bond, and the other is witness Levitas' comments on the liquidated damages. And Mr. Johnson would like to respond to those 2 points to clarify the record as to his position and where the companies and SBA now stand in terms of their negotiations to reach an agreement on the form, I'm sorry, not on the form, but on the PPA itself.
Mr. Golden.
Mr. Chairman, jointly SBA and JDA would both renew our objection to that Sir rebuttal.
Mr. Chairman, in the normal course of business, we receive pre-filed testimony in the following order, which is the company's direct testimony, followed by all other parties' direct testimony, the rebuttal offered by the company, if any, followed by surrebuttal of all other parties. Now, in the normal course of business, rebuttal testimony should be responsive, that it would be the company's rebuttal testimony, should be responsive to, fairly specific to, the assertions made in all other parties' direct filings. Similarly, in surrebuttal testimony provided by all other parties, one would expect that the issues therein addressed would have been addressed in the company's rebuttal testimony. Now, am I understanding correctly that in this surrebuttal testimony of the witness previously identified, there are novel issues being raised for the first time in the surrebuttal testimony?
I'd direct this to SBA's counsel. There is one issue related to a surety bond that is the first time that that issue is raised.
So it is the first time
And
as to that issue.
And with regard to the second issue I wanted to raise, this testimony has been unique as Duke has put forward a proposal. Mr. Levitas has agreed with some of the company's proposal and made some suggestions. The company in response has agreed with some of Mr. Levitas' suggestions and made progress toward an agreement. And now the company is simply trying to take the next step to get the commission to a place of understanding where the company and SBA are aligned. And so I can limit this only to the surety bond, and we can that's fine. We can limit this only to the surety bond, or the commission can hear where the parties currently are with regard to the liquidated damages provisions, which I believe would be helpful for the commission in resolving the question as to what liquidated damages should apply.
That's fine as long as we're extended the same courtesy.
Absolutely. Thank you.
Okay, thank you. Thank you.
So, Mr. Johnson, could you please very briefly address any new issues that Mr. Levitas raises for the first time in his sir rebuttal testimony that you haven't had the opportunity to respond to through pre-filed testimony?
Yes, Mr. Levitas suggests through sir rebuttal that Duke should allow the use of a surety bond as a permissible form of performance assurance. The company's considered comments from the solar community on this issue when developing the PPA that was used for CPRE, and do not believe that a surety bond would be a permissible form of performance assurance. Duke has never allowed a surety bond in any previous PPA, and Mr. Levitas offers no reason why this is reasonable. Finally, with regards to the default liquidated damages proposed in my rebuttal testimony as a replacement for those damages proposed in my direct testimony, Mr. Levitas' sir rebuttal testimony states that SBA will accept either method of calculated liquidated damages, whichever is lower. While it appears that the updated default liquidated damage formula will result in lower values than the previously proposed formula, I cannot guarantee that will be the result in every case. The companies believe it is reasonable to accept the calculation of LDs set forth in my rebuttal testimony, as this represents a fair compromise between the calculation in my direct testimony and that proposed by Mr. Levitas. According to Mr. Levitas' sir rebuttal testimony, SBA would not object to this.
Thank you very much. Appreciate the cooperation from opposing counsel on that. And Mr. Chairman, these two gentlemen are available for questions from opposing counsel and from the commission. We also appreciate everyone's willingness to adjust the order of the panels here so we could arrange that a little differently. Thank you.
Thank you. Let me just make sure, Mr. Elliott. Okay, Mr. Adams.
Mr. Johnson, I'm Weston Adams of Nelson Mullins. I just have a few questions for you.
Make sure you get in front of that microphone,
Yes,
Mr.
sir.
Adams.
Yes,
They're
sir.
not picking you up back.
Got it.
There you
You
go.
referenced the NOPR in your testimony. Can you tell me what that stands for, the acronym?
Sorry, notice of proposed rulemaking.
So that is only a proposed regulation. It's not a final regulation, correct?
Correct.
So it's not legally binding on your company right now.
That's correct.
Mr. Johnson, on pages 27 to 28 of your rebuttal testimony, you described the respective LEO standards for Idaho, Texas, and New Mexico, correct?
Yes.
And then on, let's see, your direct testimony, page 12, lines 3 through 7, you describe the LEO standards for Wyoming, Montana, Oregon, and Pennsylvania.
Correct, subject to Jack.
Right. Are you admitted to practice law in any of those states?
No, I'm not.
That's fair enough. Mr. Johnson, Duke's proposed large QF PPA at Section 5 requires the seller to post performance assurance to secure its obligations to Duke under the PPA, correct?
That's correct.
And per Duke's proposal, the allowable forms of performance assurance provided for in the PPA are, number 1, cash, number 2, letter of credit, number 3, a guarantee, correct?
Correct.
Are you aware that Dominion's proposed PPAs allow for the use of surety bonds as an additional fourth form of performance assurance?
I'm not.
Can you think of any reason why Duke should not be required to allow surety bonds since Dominion does so? What's the logic behind that?
Sure, I can respond to that. Although I'm not in the credit department, finance credit department, my understanding is surety bonds are harder to collect on than a letter of credit or obviously cash.
All right, but the fact that Dominion is doing so doesn't lend any credence to the idea that this is a good idea.
I can't really respond to that.
Understood. No further questions, Mr. Chairman.
Thank you. Johnson. Thank you. Ecoplexus. Mr. Holman. Ms. Bowen. ORS.
No questions, Mr. Chairman.
Commissioners. Commissioner Belser.
Thank you, Mr. Chairman. Good afternoon, gentlemen. Mr. Johnson, I am curious about the performance bond as well. Is it Duke's position that they don't want to allow a surety performance bond because it's harder to collect if there's a default?
That's correct. It's harder to collect on than, for instance, a letter of credit.
Well, doesn't the surety bond have terms and specifications that would set forth what constitutes a default?
I'm really not the expert in that area. I think what I've testified is that our company is just not comfortable with that as a form of performance assurance.
How big a company is Duke? How many lawyers you got working over there?
I have no idea.
Okay, thank you.
Maybe I'll add one more point to that. We dropped it from our service regulations as a form of credit several years ago because we don't have assurance that the surety bond will be left in effect the entire contract term because it's purchased by the QF. We have no assurance that he'll continue to renew it every year. So for the full life of the contract, it may not be there.
So if they put up cash, what are they doing? Are they giving you cash to hold for them? Are you paying them interest on it?
Yes, an interest-bearing deposit.
And what about a letter of credit? Doesn't that have to be renewed periodically?
Yes, but usually it's easier to make certain that's being done in a reasonable and commercial manner.
Usually easier. Tell me where you're getting that information from.
From Lewis Camp, our credit manager.
Ah.
That's what he's told us. He feels like a letter of credit is a lot better assurance that the customer will be responsible for his debt to us. It won't be passed on to other ratepayers. It's uncollectible.
Okay. Thank you.
Thank you. Commissioner Hamilton, make sure you get in front of that microphone good. You were getting away from it.
All right, sir. Mr. Wheeler, in your direct, I believe in rebuttal testimony, you discussed the standard offer tariff.
Yes, sir.
Is this the same in all of Duke's jurisdictions?
Essentially, yes, sir. In both North and South Carolina, we use a terms and conditions purchase power agreement and scheduled PP in both North and South Carolina. Okay. In North Carolina, they're applicable for 1 megawatt and smaller projects. Beyond that is a negotiated agreement. In South Carolina, it's 2 megawatts and smaller.
And I believe you determined a 30 month.
Yes, sir. We allow in both scheduled PP and in the terms and the purchase power agreement itself, it states that the project must be complete within 30 months of the Commission's order approving the rates that are in effect in the PPA. We feel like 30 months from the date of the order is a reasonable time frame for the project to be completed. If it's reasonably close to completion at the end of 30 months, it can be extended upon mutual agreement by the parties. We think that's adequate time to complete a project and put it into service once you've contracted with us to sell power.
Have you had any problems where you had to cancel the contract because of the 30-month period?
I think my coworker can address that. David?
Yeah, I would say no, we haven't. I mean, we've had some run up against that time frame, but I think what we've recognized, if they're progressing towards completion, we'll allow it to move on. So we give them a little leniency.
Okay, thank you very much. Thank you, Mr. Chairman.
Thank you. Commissioners, any other questions? Okay, any redirect? Okay, gentlemen, thank you for your testimony, and you may step down, and I know, Mr. Wheeler, you need to be excused.
Thank you.
Okay, we're going to get back into order and call the next.
Mr. Chairman, the company calls Nick Wintermantle to the stand.
Hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Good afternoon, Mr. Wintermantle.
Good afternoon.
Hear me all right?
Nope. You said on?
Well, I have this mic here, but trying to compensate for me being tall.
Speak loud.
Yes, sir. All right. Good afternoon, Mr. Wintermantle. Would you please state your full name for the commission?
Yes, my name is Nick Wintermantle.
And by whom are you employed in what capacity?
I'm a principal consultant and partner at Astrape Consulting.
And did you cause to be pre-filed in this docket direct testimony consisting of 26 pages?
Yes.
Do you have any changes to your direct testimony today?
No.
If I were to ask you the same questions that appear in your direct testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, I would ask that Mr. Wintermantle's direct testimony be entered into the record as if given orally from the stand.
Mr. Wintermantle's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you. And Mr. Wintermantle, did you cause to be pre-filed 2 exhibits to your direct testimony?
Yes.
And do you have any revisions to those exhibits at this time?
No.
Mr. Chairman, I would ask that Mr. Wintermantle's 2 direct testimony exhibits be marked as next hearing exhibit.
Mr. Wintermantle's 2 direct testimony exhibits will be entered as a hearing exhibit number 10.
Thank you, sir. Mr. Wintermantle, did you cause to be pre-filed in this docket 43 pages of rebuttal testimony?
Yes.
And do you have any changes to your rebuttal testimony today?
No.
And if I were to ask you the same questions today, would your answers be the same?
Yes,
we're not doing rebuttal later. We're doing just.
Mr. Chairman, I apologize. We probably should have made that clearer earlier. So as a result of the stipulation that the company has entered into with certain other parties, the issues addressed in Mr. Wintermantle's rebuttal testimony have largely been resolved. So with the Commission's permission, we'll just put him up once and address both his rebuttal and direct. And I think that's been communicated to all the parties. So
everybody good with that?
Everyone's good with that.
Okay. Thank you.
Yes, sir. So I think we established you don't have any changes to your rebuttal testimony.
That's correct. No changes.
And if I were to ask you the same questions in your rebuttal testimony today, your answer would be the same?
Yes, they would.
Thank you. So, Mr. Chairman, at this time, I'd ask for Mr. Wintermantle's rebuttal testimony to be entered into the record as if given orally from the stand.
Mr. Wintermantle's rebuttal testimony pre-filed will be entered into the record as though given orally from the stand.
Thank you, sir. And Mr. Wintermantle did have 1 rebuttal exhibit, but the company filed a letter in response to the motion in limine filed by Solar Business Alliance on Friday, and so we are not asking for that exhibit to be put into the record in support of Mr. Wintermantle's rebuttal testimony at this time.
Okay.
All right, Mr. Wintermantle, I'd like to briefly ask you a few questions to introduce your testimony to the Commission, as well as the stipulation the company's entered into, which addresses the integration services charge. So first, since this is your first time testifying before the Commission here, can you please give the Commissioners a little information about your background and the work that Astrape does?
Sure. So I'm an engineer with an MBA and have worked in the utility industry for almost 20 years. I began my career with Southern Company, where I worked in various roles within the planning organization and joined Astrape Consulting in 2009. Since, I've performed resource adequacy studies, planning studies, and integration cost studies for entities around the country and internationally. Astrape Consulting has performed resource adequacy studies for Duke Energy in 2012 and 2016, as well as a solar capacity value and ancillary service study last year. In addition to my work for Duke, we have performed studies for other southeastern utilities such as Southern Company, TVA, and Entergy. We have also performed studies for large system operators such as ERCOT, SPP, and MISO.
Thank you. Can you describe briefly the general purpose of your direct and rebuttal testimony?
Yes, the purpose of my testimony is to support the solar ancillary service study that Astrape completed for Duke Energy. The solar ancillary services study calculates the solar integration services charge that is proposed by the companies in this proceeding.
Are you aware of the stipulation agreed to by the company and certain other parties in this proceeding related to that integration charge?
I am. Duke supports the terms of the stipulation. I believe the stipulation represents a fair, reasonable, and full resolution of all issues in this proceeding regarding the integration services charge. Moreover, my testimony should not be construed as advocating for any position that is contrary to the terms of the stipulation.
Can you please briefly tell the Commission about the terms of the stipulation as they relate to your testimony?
Yes. The stipulation adopts the results of the Astrape study for the existing plus transition solar penetration level for DEC and DEP. As described in my testimony, at the existing plus transition solar penetration level for DEC, the study showed that an additional 26 megawatts of load following reserves were required to integrate 840 megawatts of solar. The cost of these 26 megawatts of load following reserves translates into an ancillary service cost impact of $1.10 per megawatt hour. For DEP, the study identified that 166 megawatts of additional load following reserves were required in order to integrate 2,950 megawatts of solar generation. For DEP, this resulted in an ancillary service cost impact of $2.39 per megawatt hour. Also, as Duke witness Snyder testified, the stipulation fixes the cost of the integration services charge over the term of the PPA.
Thank you. So, understanding that this stipulation has been reached on these issues by some of the parties in this proceeding, could you provide a very brief summary of the study for the Commission?
Sure, I'll provide a very high-level description of the study. Astrape was retained by Duke in late 2017 to analyze and quantify the ancillary service impact of integrating existing and future solar generation for the companies. This study was concluded in the fall of 2018 and is being relied upon by Duke witness Glenn Snyder to support the integration services charge presented in the company's avoided cost filing. The main premise of the ancillary service study is to assess the integration cost impact of adding different penetrations of solar generation while ensuring that system reliability is the same before and after the additional solar is added. The study determines the amount of load following reserves that are required to maintain the same level of reliability when adding various amounts of solar penetration, and then also calculates the cost of these additional reserves to develop the integration charge.
Mr. Wintermantle is...
Yeah, we weren't picking you up there for a second.
Had shut it off, but hopefully, am I back now?
You're back.
Yes, sir. At this time, Mr. Wintermantle is available for cross-examination from the parties and questions from the Commission.
Okay, thank you. Okay, Cross, Mr. Elliott. Okay, SBA. Thank you. Johnson. Thank you. Ecoplexus. Thank you. Southern Alliance. ORS,
No questions, Mr. Chairman.
Commissioners. Okay. Any redirect? Just thought I'd throw that out there for y'all. Okay. Anything else for Mr. Wintermantle? Mr. Wintermantle, thank you for your testimony, and you may step down.
Thank you.
Mr. Chairman, Mr. Wintermantle has traveled from out of town. Would anyone object to Mr. Wintermantle being excused? No objection.
You are excused.
Right. Thank you very much, Mr. Chairman. And that concludes the company's direct case. Thank you.
Okay. All right. Let's, so we're going on to SBA's first direct panel.
SBA calls Steve Levitas, and JDA calls Rebecca Chilton.
And as I'm reading, we're doing direct and rebuttal.
Yes, sir.
Okay.
We're passing out some summaries right now, so just give us 1 minute and we can get that done.
Okay, while y'all are passing stuff out, we're going to take about 10 minutes.
solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Okay, Mr. Adams.
Yes, sir, Mr. Chairman. I'm going to start with Mr. Levitas. Mr. Levitas, please state your name and business address for the record.
Stephen Levitas, my business address is 130 Roberts Street, Asheville, North Carolina.
And where do you work?
Pine Gate Renewables.
And briefly, what do you do for them?
My title is Senior Vice President for Strategic Initiatives, and in that role I oversee the company's regulatory and government affairs activities.
And are you the same Steve Levitas who calls direct testimony to be pre-filed in these proceedings on September 11, 2019, consisting of 33 pages?
I am.
The same Steve Levitas who calls Sir Rebuttal to be pre-filed in these proceedings on October the 11th, 2019, consisting of 12 pages.
I am.
Both sets of testimony prepared by you are under your direction.
Yes, they were.
Any changes or corrections?
No, sir.
If I asked you the same questions that are set forth in your pre-filed direct and Sir Rebuttal, would your answers from the stand be the same today?
They would.
Mr. Chairman, the Solar Business Alliance would ask that the pre-filed direct testimony and pre-filed Sir Rebuttal testimony of Steve Levitas be entered into the record of each docket as if given orally from the stand.
The pre-filed direct and pre-filed Sir Rebuttal testimony of Mr. Levitas will be entered into the record as though given orally from the stand.
Yes, sir. And I just want to make sure that's in both records.
Both records.
Yes, sir. Thank you, Mr. Chairman. Mr. Chairman, the Solar Business Alliance would ask that Steve Levitas exhibits 1, 2, 3, and 4 be identified as marked for each docket.
Okay, we will enter the exhibits as hearing exhibit number 11.
Thank you, Mr. Chairman. Mr. Levitas, have you prepared a summary of your pre-filed direct and Sir Rebuttal?
I have.
Could you please provide that summary now?
I will. Good afternoon, Mr. Chairman, members of the Commission. My direct testimony summarizes my extensive experience over the past decade with PURPA and specifically with the negotiation of power purchase agreements or PPAs with utilities, including Duke Energy Carolinas and Duke Energy Progress. In addition, I've been involved in litigation before state commissions, FERC, and the courts relating to PURPA, specifically concerning PPA terms and conditions and the formation of legally enforceable obligations, or LEOs, by QFs under PURPA. One example of particular note is that the Michigan Public Service Commission recently required major changes to DTE Electric's proposed standard offer PPA based on objections raised in my testimony to the Commission. I was also one of the principal authors of the section of Act 62 dealing with PURPA and have been heavily involved in the proposed PURPA rulemaking at FERC, which you've heard about. In my direct testimony, I identified a significant number of terms and conditions in Duke's proposed standard offer PPA and terms and conditions, large QF PPA, and notice of commitment form that I believe don't strike a fair and reasonable balance between the interests of QFs on the one hand and DEC and DEP and their ratepayers on the other. In all cases, I either propose that the problematic terms be deleted or I propose modified or substitute language to address my concerns. Following the filing of my direct testimony, Duke witness David B. Johnson and Duke witness Stephen B. Wheeler filed rebuttal testimony in which they, on behalf of DEC and DEP, agreed to a number of changes to the company's proposed documents to address concerns that I had raised. SBA and I very much appreciate their responsiveness to our concerns. In an effort to extend this spirit of compromise and to narrow the matters in dispute further, in my rebuttal testimony, SBA accepted Duke's position on a number of the remaining open issues. Because there are now only a limited number of issues in dispute, rather than summarizing my direct testimony, I will now summarize the most significant remaining open issues as discussed in my rebuttal testimony and as you recently heard about from Duke's witnesses. With respect to Duke's proposed large QF PPAs, I note that Duke now proposes to condition PPA execution on the seller having executed a Facilities Study Agreement, or FSA, under the Commission's interconnection procedures. This is a new condition, I believe introduced for the first time in Mr. Johnson's rebuttal testimony. I state in my rebuttal testimony that SBA doesn't object to this requirement, provided that it's not applicable where a year has passed since the filing of the QF interconnection request. And I want to explain the basis for that because I don't think it was adequately addressed by Mr. Johnson, and I do that in my SIR rebuttal. In the absence of such an exception, so an exception to this absolute requirement of a facility study agreement, in the absence of such an exception, the utility could potentially control and frustrate the QF's contract formation, which has been expressly prohibited by FERC. And even in the FERC NOPR, they maintain that principle. As I pointed out in my direct testimony, the North Carolina Utilities Commission, with Duke's consent, has adopted exactly this sort of approach where there's an alternative of having completed a step in the interconnection process or a certain amount of time has passed which should have been adequate for that step to be completed. The primary outstanding issue with the Duke Large QF PPAs discussed in both my direct and SIR rebuttal testimony is my proposal to add a condition precedent that allows a seller to terminate the PPA without penalty if its interconnection costs are projected to exceed $75,000 per megawatt, a condition that Duke opposes. I acknowledge, as Witness Johnson has pointed out, that such a condition precedent is not needed if the system impact study has been completed and the FSA has been executed. In that case, the interconnection information, cost information will be available. It is, however, needed in the other situation that I've proposed, where the utility has failed to complete the system impact study in a timely fashion, and where I contend the QF should then be allowed to enter into a PPA a year after its interconnection request. At that point, it would have no interconnection information, but it wouldn't have cost information, but it would not have that information because the utility had not provided it in a timely fashion. I note that Dominion has agreed to such a PPA provision, and I also noted in my direct testimony that a similar provision of a $75,000 per megawatt cost condition precedent has been agreed to by Consumers Energy in Michigan. Also, with respect to the Duke Large QF PPAs, I recommend in my SIR rebuttal testimony that Duke be required to allow the use of surety bonds as a permissible form of performance assurance. As you've heard, I note that Dominion's proposed PPAs allow for the use of surety bonds and include a commercially reasonable form bond for this purpose. I won't say more about surety bonds at this point since it's beyond the scope of my testimony, but I would be happy to answer questions of the sort that were tendered to Duke regarding surety bonds. Let me also just digress from my prepared summary for a moment to speak to the issue that Witness Johnson addressed concerning liquidated damages. And the issue there was that Duke made an initial proposal with respect to liquidated damages for failure to achieve timely COD. I had made a counter proposal in my initial testimony. In Mr. Johnson's rebuttal testimony, he proposed a new alternative. In my SIR rebuttal, I said, as you heard, that either could be acceptable. We'd prefer to see the lower one. I agree with Mr. Johnson that their most recent proposal is the preferred way to go to simplify things for you. So we're prepared to accept that most recent proposal, which is, as I understand it, a combination of 1 year's, the average annual for 1 year capacity payment plus 10,000, up to 15 megawatts, and then above that $10,000 per megawatt over 15 megawatts. I realize it's a little complicated, but it's laid out in the testimony. The point is we're prepared to agree to that. The most significant issues I address relating to Duke's Notice of Commitment form or NOC form concern the conditions that Duke would require a seller to have met as a condition of submitting the NOC form and forming a non-contractual LEO. I explained that the question for this commission is whether it's commercially reasonable to require a seller to meet such requirements before having secured pricing by forming a LEO. That's the whole issue here of balancing the need for price certainty versus a reasonable understanding that QFs have taken a certain sets of actions to advance their projects. I also explain that the FERC's Notice of Proposed Rulemaking, which Duke points to in support of its proposed NOC eligibility requirements, is a proposed rule that may never be adopted in its current form and has no legal significance in this proceeding. In my direct testimony, I objected to Duke's requirement that the QF be capable of being placed in service within 365 days as a condition of LEO formation using the NOC form. However, in my surrebuttal testimony, I state that SBA is prepared to withdraw that objection if the deadline is extended to account for additional time needed by the utility to complete required interconnection facilities and network upgrades. I note that the Dominion NOC form contains just such a provision, and I would also note that this is similar to Duke's large QF PPA term, which extends COD based on interconnection delays. As with Duke's large QF PPAs, I don't object to Duke's proposed requirement that a signed FSA be a condition of LEO formation through the NOC form, provided that this requirement doesn't apply, as I propose with respect to the PPA, if a year has elapsed since the filing of the QF's interconnection requests and the QF still doesn't have any interconnection cost information from the utility. I also explained in my direct testimony why it's not reasonable to require QFs to obtain all environmental permits and land use approvals without having firm pricing. And I note in my surrebuttal testimony that Duke has never made such requirements a precondition of executing a PPA and does not propose to do so in this proceeding. Finally, with respect to the NOC form, I continue to think that, as with the PPA, the seller should have the ability to terminate a non-contractual LEO where interconnection costs exceed $75,000 per megawatt, as Dominion has now agreed to with respect to PPA termination. As for the standard offer, in my direct testimony, as you heard earlier, I recommended removing the requirement in the Duke proposed PPA that a QF be placed in service within 30 months of the Commission's approval of the standard offer tariff. In my surrebuttal testimony, I state that SBA doesn't object to this outside in-service date, provided it's linked to the interconnection facilities and network upgrades in-service date, as Duke has agreed to with respect to large QF PPAs. So there's a COD deadline under contract that is extended based on interconnection delays. I'm suggesting that the same thing apply with respect to the standard offer PPA. And I'd be happy to speak more about that 30-month condition and how it's been applied in other contexts. I also state that SBA would be willing, as part of a global resolution of outstanding PPA issues, to drop its objections to Duke's substantial modifications to the standard offer terms and conditions relating to so-called material alterations to QFs, to the infrastructure of the facility, subject to two conditions. And what I'm talking about here, just to illustrate, if you'll excuse the sort of kind of rough sense of this, but this is Wheeler Rebuttal Exhibit 2, and I just want to give you a little sense of the red ink. This is the existing terms and conditions, the pre-existing Duke terms and conditions that have been heavily, heavily modified as proposed in this proceeding. So I just want to underscore the extensive nature of these changes compared to what's been approved in this state in the past and in North Carolina for that matter. So the first condition to our willingness to consent to these changes, and this is a major concession on our part, the first condition is that the terms and conditions need to provide that Duke's consent to requested material alterations will not be unreasonably withheld, conditioned, or delayed. Now, witness Wheeler said, I believe, that they were prepared to agree to this. He made it sound as though it's no big deal and that, of course, they would be reasonable. But in fact, the document as it's currently written gives them unfettered discretion to deny these sorts of alterations. And so we want it to be clear that it cannot be withheld, conditioned, or delayed in an unreasonable manner. And Duke has agreed to a similar condition in its large QF PPAs. So the large QF PPAs also limit modifications to the facility, but provide that Duke may not unreasonably withhold consent to such modifications. The second second condition on our willingness to agree to these very extensive changes is that they must be applied only prospectively to new PPAs and not be made applicable retroactively to existing PPAs. Now, Mr. Wheeler pointed out in his sir rebuttal, if you will, that you have adopted language in the past that does provide that where you approve changes to the standard offer forms, that they may be made applicable retroactively. So that language does exist, but that doesn't obligate you to make them applicable retroactively. And I would submit to you that where you have many contracts that are in place today based on the laws and the terms of these conditions that were in effect at the time, to adopt this kind of wholesale change to a document and then incorporate all of those changes retroactively to existing contractual relationships is terrible public policy. And while, as I said, we don't oppose these types of changes being made going forward, if your view was that if we make them going forward, we're also going to make them retroactively, then our position would be don't make them at all. So I will stop there. That concludes my summary.
Mr. Chairman, I'll move to Ms. Chilton now, if that's all right. Ms. Chilton, please state your name and business address for the record.
Rebecca Chilton.
And for whom do you work?
Apologies. Rebecca Chilton. I'm with Azuba Consulting.
And what do you do for them?
It is my own independent consulting service providing operational, financial, and development services to renewable energy projects nationwide.
Are you the same Rebecca Chilton who calls direct testimony to be pre-filed in these proceedings on September 11, 2019, consisting of 10 pages?
I am.
And are you the same Rebecca Chilton who calls sir rebuttal to be pre-filed in these proceedings on October the 11th, consisting of 5 pages?
I am.
Were both sets of your testimony prepared by you or under your direction?
Yes, they were.
Do you have any corrections or changes to either set of testimony?
No, I don't.
Ms. Chilton, if I now asked you the same questions that are set forth in your pre-filed direct and sir rebuttal testimony, would your answers from the stand be the same today?
Yes.
Mr. Chairman, Johnson Development would ask that the pre-filed direct testimony and the pre-filed sir rebuttal testimony of Rebecca Chilton be entered into the record for each docket as if given orally from the stand.
Ms. Chilton's pre-filed direct testimony, pre-filed direct and sir rebuttal testimony in each docket will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. And Ms. Chilton, you did not have any exhibits, correct? No exhibits.
Correct. No exhibits.
Have you prepared a summary of your pre-filed direct and sir rebuttal?
I have.
Could you please provide that now to the Commission?
Yes. To Chairman Randall and your fellow commissioners, good afternoon. It's a pleasure to be with you again today. In this proceeding, I was asked by Johnson Development Associates to provide testimony based on my more than 21 years in structured finance, the last 9 years of which have been focused on lending to and supporting the development of renewable energy projects nationwide. Specifically, I was asked to speak to the commercial reasonableness of certain terms of PPAs between the utility and qualifying small power production facilities, or QFs, as defined in PURPA and the South Carolina Energy Freedom Act. I was further asked to address the weight both laws give to their respective goals and the unique purpose both statutes identify for QFs to play in the electricity sector. I note first in my testimony that PURPA, FERC regulations, and the Energy Freedom Act all direct the Commission to strike a balance between two important concerns. First, that the rates that South Carolina ratepayers ultimately pay for QF generation must be just and reasonable, and second, that small power producers must receive fair treatment and have the ability to obtain PPAs with terms that do not discriminate against them in South Carolina's electricity generation landscape. I repeat throughout my testimony that this is a both-and analysis. The Commission must both ensure fairness to QFs and create a just and reasonable outcome for ratepayers. Because I am speaking primarily from a financing party's perspective, my testimony then delineates an implicit requirement of both PURPA and the Energy Freedom Act that QFs must be able to access regularly available market rate financing. Both Congress and the South Carolina General Assembly define QF's unique role in reducing dependence on fossil fuels for electricity generation and shifting that generation towards renewable sources. QFs are asked to do this despite what the utility may also be doing around renewable energy. Because they distinguish QFs from utilities, Neither Congress nor the South Carolina legislature can have expected QF developers to be sitting on vast funds to build these important projects, nor to be able to obtain the unicorn financing to which the utility monopoly has access. QFs must seek financing in normal markets that can be paid for within the strict confines of the PPA. And thus, to be fair and balanced towards QFs, this Commission must consider the effect that its avoided cost analysis and the other PPA terms it mandates have on the ability of QFs to secure regular financing. Avoided cost rates that are artificially low because they do not fully and accurately account for a utility's true generation costs and the benefits that QF purchases bring to ratepayers. Short-term PPAs and contracts that carry unnecessary extra charges are all examples of terms that impede a QF's access to regularly available market rate financing and thus are discriminatory towards QFs. My testimony further makes clear that there is ready financing in the mainstream capital markets available to QF projects that have PPAs with fair terms. Along with the creditworthiness of the offtaker and the freedom of the PPA from punitive terms and conditions, this fairness is represented primarily by the close interplay of the avoided cost rate itself and the PPA length. My testimony addresses the requirements of both PURPA and the Energy Freedom Act that the Commission undertake a nuanced, multi-factored analysis in setting avoided cost rates. Act 62 in particular mandates that the avoided cost analysis must fully and accurately reflect the utility's avoided costs based on a range of inputs, not be limited to one or two cherry-picked factors. Such a comprehensive and balanced analysis should also take into account the perhaps less obvious benefits of fuel price hedging, the ability to work with QFs to site and size them in ever more demand-responsive ways, and their great adaptability to changes in technology. With regard to PPA duration specifically, my testimony highlights that Duke's proposal to limit PPA terms to no longer than 10 years would represent a direct contradiction to the practice of its unregulated affiliate, which has captured solar PPAs from 15 to 20 and even up to 30 or 35 years in other jurisdictions, would dramatically reduce the ability of QFs to access mainstream capital, would deprive South Carolina ratepayers of the protections against fuel price variation and uncertain future capital costs of generation that long-term PPAs bring, and would be inconsistent with the Energy Freedom Act's specific mandate to use such terms as PPA length to promote renewable energy in South Carolina. Finally, my written testimony reasons that a longer PPA contract term, accompanied by appropriately calculated avoided cost-based purchase prices, will result in a greater proportion of QFs accessing mainstream capital than would be the case under the utility's unnecessarily restrictive proposals. This is a marked benefit to South Carolina ratepayers compared to a utility generation model that greatly overemphasizes fossil fuel generation and would bind ratepayers to the risks of multiple gigawatts of gas generation for the next 4 decades and beyond. I conclude my testimony by recommending that the Commission consider various options proposed by interveners for conforming longer-term PPAs to the requirements of Act 62. Once the avoided cost is known, a decrement to that rate or a long-term purchase commitment with a midterm price adjustment are but a few examples of ways to facilitate the opportunity of QFs to obtain financing in South Carolina. Duke filed rebuttals to my testimony, to which I in turn responded in my surrebuttal. To summarize the most important points made in that portion of my testimony, I again emphasized that Congress and the South Carolina legislature have given QFs a unique role in changing the way electricity is produced in this country and in this state. QFs are seen as distinct and important, and while utility programs may be helpful additions to that effort, they are not what is specifically envisioned in both PURPA and Act 62. I also disagreed with Duke Witness Brown's contention that every input into the avoided cost analysis could be objectively verifiable. A good amount of this Commission's work here is predictive, and it's imperative to use the best possible data from reliable sources to form your assumptions about what will happen in the future. Finally, I disagreed with Duke Witness Brown that the NCCPRE is an acceptable alternative to the PURPA PPA structure at issue in this proceeding. The General Assembly considered multiple approaches to enable South Carolina to catch up with other states in renewable energy and expressly adopted the QF PPA model. It is our collective work in this proceeding to inform the Commission on the many inputs to achieve a fair and balanced avoided cost and set of PPA terms so that the decision of the South Carolina legislature to encourage QF development can be successfully implemented. Thank you.
Thank you, Ms. Chilton. Thank you, Mr. Chairman. These witnesses are available for cross and commission questions.
Thank you. Cross, company.
We would request that the company be allowed to ask its cross-examination of the witnesses last. If you'll recall, we did that in the rate case, and we found it very helpful.
Okay. Anybody else got cross? Commissioners. Commissioner Howard. What? Excuse me. What?
I was just talking about it as to the parties, Mr. Chairman.
Okay.
Not that we weren't
trying to accommodate everybody and move it along.
Thank you, Mr.
Y'all all assume I read your minds. And I can't even read mine. Okay, Commissioner Howard, can you hang on for 1 second?
I got it.
Okay.
Mr. Levettis, I'll take
No, Miss Commissioner Howard.
Wait a minute.
Could you hang on for 1 second? Y'all want to go ahead now? Okay. All right. Then we're going to get to you, to commissioners. Sure. I'm sure this time. Mr. Anthony.
Mr. Chairman, members of the commission, I'm sorry, Commissioner Howard, I didn't mean to preempt you or anything, sorry. I'm Ms. Chilton, I'm Lynn Anthony representing DEC and DEP in this proceeding. How are you?
I'm good, how are you doing?
First, I want to make sure we're all clear as to exactly what is the purpose of your testimony, and as I understand it, you're not here to address the actual avoided cost rates that are being proposed or determined.
That is correct.
You are here to share with us your history in the financing of qualifying facility projects.
That is correct.
Is that fair? Okay. Now, are you saying that absent longer-term QF contracts, say 10-year contracts, that QFs cannot obtain financing?
I think what I would say specifically in response to that is that it is a close interplay between the length of a PPA and the price being paid. Obviously, other terms of the contract also come to bear, but those two are the primary drivers. And without a balance between them, PPA length and an acceptable avoided cost, that is what influences the availability of financing.
Okay.
So it's not PPA length standing alone.
Well, let's be clear. When we say PPA length, PURPA does not have an end date as far as how long a utility is obligated to purchase power from a QF, does it?
It is my understanding that PURPA would require at the end of an initial PPA the execution of a subsequent PPA. And so it is indefinite as to the total length, and it provides freedom to contract for as long as the parties determine.
It's really not the length of the term of the contract per se, because PURPA says DEC and DEP have to buy the power, period, for as long as the QF wants to offer it. The issue is how long is the rate to be paid is going to be fixed. Isn't that what we're really talking about?
I think because there is uncertainty always when you look into the future, to have a PPA length independent of the fixed price, a PPA length that provides a commitment to purchase that a financing party who is not as down in the weeds of the conversation between the QF and the utility would be able to feel confident that the purchases would be made. A financing party isn't necessarily very closely looking at PURPA, and so it would give them confidence to see an outright contract of a longer term.
So how would a lending institution look at a 100-year contract with the QF rates changed every 2 years based upon the decisions of this commission in these biennial proceedings?
I can't really speak to that. That seems outside of a possibility that I would be able to speak to.
Well, I'm really trying to get to Commissioner Williams' question from earlier today, and that is how can this commission best protect customers from overpayment? And as we've talked, it seemed to me that the terminology has gotten a little confusing in the sense that it's really not how long is the contract per se, it is how long is there a fixed rate being agreed to by the company and the QF. That is where the risk to the utility customer comes from, isn't it?
I guess I'm not following. I thought the question was, from my perspective as a financing party, would I find that my willingness to provide financing is influenced by the length of the fixed price? Yes, but it would also be influenced by the length of the contract itself, the commitment to purchase outright.
Okay. So there's a little bit of a balance, you're saying, between the rate itself and the length of the contract. The longer the contract, the more variability that the lender might be willing to consider in the rate to be paid. Is that what I'm hearing?
I think there's probably a minimum that would have to be met of certainty, but there would be more flexibility the longer the PPA length. But I can't speak to what that would be for any given lender. Just generally, that interplay is very important.
So back to Commissioner Williams.
And I would say it's less the variability of the rate as it is what the rate is, how much the rate is. For instance, if you have a $50 per megawatt rate at 10 years and you have a $40 per megawatt hour rate at 15 years, those two could be looked at by a lender, and both may ultimately be determined, other factors being included, to be acceptable. So they work together, and a lender would be looking at both.
So what I'm hearing is there is some flexibility in the lender's eyes with regard to the term of the contract and the rate actually being fixed. The lenders are amenable to longer term contracts with what I'll call variable rates. They're asking I'm asking whether that is something you think the lending institutions would find reasonable.
I think it depends.
If I might, Mr. Anthony.
I'm sorry, my questions are directed to
Well, I know, but your witnesses responded where they had an appropriate response to a question that was directed to another witness. And I just want to clarify the term that you're using, because when you use the word variable, that is typically used to mean changing at the time of delivery and uncertain. So I want to point out the difference between a changing rate that is known versus an unknown variable rate, because that's what Ms. Chilton is talking about. It could be 50 and then go to 40. That's different than saying at year 5 you're not going to know what the rate is any longer.
Let me make a more general statement. The financing party is looking at a number of different factors, and at each factor is looking for certainty. Certainty in the price, certainty in the length, and certainty in the other types of terms that are involved in the contract. And so the greater the certainty, the more accessibility of the financing.
Okay, well, let me approach it from this manner. Act 62 expressly provides that in the event a contract longer than 10 years with a fixed rate is approved by the commission, there should be some sort of decrement to the avoided cost rate. You agree with that?
That is the language of the statute, yes.
That's an express recognition that the longer the term of a contract with a fixed rate, the greater the risk exposure to the end-use customer who's the one having to foot the bill for all of this. And as a result, there needs to be some compensation for assuming that risk in the form of a lower avoided cost rate. Isn't that what that means?
I would say it means that it is a reasonable outcome for the ratepayer to have some ability to have the price be adjusted in order to accommodate a longer length.
Well, it's not just reasonable. When you're in your previous life representing lending institutions, the longer the loan, the higher the risk to the lender, right?
Correct.
Okay, and the same thing is true for our customers in this case. The longer the fixed rate, the higher the risk to them.
I don't know that it's always a risk. It could be the higher the benefit to them.
But as we've
Because if avoided costs go up and they have a long-term avoided cost at a currently low rate, then the longer the benefit.
which takes me back to what I was hoping would be some common ground, is that as these contracts get longer, there ought to be some mechanism to reopen the rate to reflect the improved information available to determine whether their avoided cost rates are accurate or not, and we can avoid the overs and unders.
I believe that, and that's what the legislature was aiming for. But I would say from a lending perspective, certainty around how that is done is critical.
How that avoided cost rate is changed during the term of the contract? Is that what you're referring to?
How any part of the contract will change during its term.
But as witness Snyder, I think, described it, there's this cone that gets wider and wider the longer the fixed rate is established, right?
Correct, of uncertainty.
Now, let's talk a little bit about how these QF PPAs are financed. In your testimony, you spoke of, I think you called it tax equity and then regular equity and then debt. Did I do a fair job?
Correct.
Okay. And to the extent a longer term contract with a fixed rate can be obtained, does that usually mean better financing terms, including a better interest rate, meaning a lower interest rate?
I would say there are certainly floors. You might be able to get incrementally better rates, but not dramatically better rates. It's not a one-to-one analysis.
Incremental compared to what? I'm sorry.
Compared to what would be offered at a different contract length. So a lender will provide a proposal with a certain rate. If the contract fixed price is longer, then they might negotiate with their borrower on a incremental reduction in the interest rate. Is that your question?
I'm a little confused now because I thought the whole reason you're here is 5-year contracts, 5-year fixed rate contracts are not adequate for the average QF to obtain financing on what you refer to as reasonable terms.
Correct.
Okay. So as we move out in the length of the fixed rate, I'm assuming, based upon your testimony, that the financing terms get better and better.
I don't understand your question.
Right. At 5 years, the financing terms are not good, right?
At 5 years, it is my position that it would be unusual that financing would be available at all.
Right. And at some point, as the term gets longer, financing becomes available.
Yes.
And as the term gets longer and longer at a fixed rate, don't the terms continue to improve?
Not necessarily. There are lots of other considerations that a lender would have about how long they can go out with a particular borrower, with a particular sector or industry, with a particular project type. And so it's not infinite. There's not an open-ended
Well, where's the magic sweet spot where the contract length with a fixed rate reaches the point where the QF can reasonably obtain financing?
I think it depends a lot on what the avoided cost is or the purchase price is. I can't speak to length alone. It is such an important interplay between those two factors. I did respond to the Commission's questions in prior testimony that it's my feeling that at around 15 years that becomes a very workable model. But again, without knowing what the avoided cost rate is in that analysis, you can't say absolutely. Okay, those two are important factors that work together.
So let's use that 15-year number for the rest of what I'd like to talk with you about. So we're at the 15-year.
Mr. Anthony, make sure you stay close to that microphone. They're having a hard time hearing you over the.
My hands like to talk, and sometimes they get in the way of my mouth, which is oftentimes good. So if 15 years, let's assume, is sort of the sweet spot or a good spot for QF financing that gets them reasonable terms.
If there's a reasonable avoided cost, yes.
We're making that assumption.
Okay.
Okay. So at that point, part of that reasonable term is going to be an advantageous, or however you want to characterize it, lower or good or market interest rate.
A market interest rate, yes.
And the lower the QF can drive that debt cost, the higher the return is going to be for the equity piece, isn't it?
Correct.
That's all I have. Thank you.
Thank you. Commissioners, Commissioner Howard.
Thank you, Mr. Chairman. Mr. Levitas, you offered to discuss, I guess, the 30-month time frame.
Yes, sir.
I'm going to take advantage of your offer and let you discuss it.
Yes, sir. This provision, just to be sure we're all on the same page, is one that's been around in North and South Carolina with Duke for some time. And the specific provision is that in order to qualify for a rate, a tariff that you have approved, the facility has to be placed in service within 30 months of the approval of that rate. And the problem that we've seen for the last 4 years is that Duke is so far behind in its processing of interconnection requests that it has become impossible for any QF to place a project in service in 30 months from the approval of a rate because of the interconnection delays. And so what has happened as a result of that is first by negotiated settlement, then by legislative action in North Carolina, provision was made to extend that 30-month period to account for these significant interconnection delays. And I believe that Duke has made a similar accommodation here in South Carolina in the past with respect to a prior tariff that was about to run. The language that's in the tariff itself is really not adequate to deal with the issue. I mean, it can be used, but what it says is that the utility can give a QF more than 30 months if it's making reasonable progress and is close to getting its facility built. That's not the problem. The problem is that you've got facilities that after 30 months are still at square one because there's been no progress on interconnection study, let alone interconnection construction. And the solution that has been agreed to in the prior situations that I mentioned is to have a PPA begin to go into effect and have the clock begin to run on its term, whether it's 15 years in North Carolina or 10 years here, so that the rate would remain in effect. The period would begin to start, so you wouldn't have as long a term, or you wouldn't have the rate run out as long a period of time. But that's been necessary for the last 4 years to accommodate this situation, and my request is that it be written into the documents at this time in this proceeding.
Thank you, Commissioners. Commissioner Urban.
Thank you, Mr. Chairman. Ms. Chilton, on pages 7 and 8 of your direct testimony, you discuss the issue of the volatility of natural gas prices by illustration as to how a longer-term fixed QF PPA contract protects ratepayers. Can you quantify the benefit of longer-term contracts to QFs in that regard?
On the fuel cost question alone, I think I did look back at the IRP of the utility today, and I believe that they are also reflecting the projections that the Energy Information and Administration is projecting for natural gas prices. And so when you look at that curve, even within a 14-year time frame, say a 15-year PPA, that curve shows a doubling of natural gas prices over what they currently are. So the risk is significant when you are locking in the South Carolina ratepayer into a gas generation facility for decades, when even your near-term, mid-term assumptions are, and the data that's available is that those prices on that particular factor will rise. I feel that when you have contracted for 15, 20 years with a QF at a price that you know, that you've built into your rate model, that you will not change, cannot change, then I think that that's a benefit to the ratepayer.
Looking at the projected increases of natural gas over this 15-year period, is it a gradual increase over the 15-year term, or do you know how it's reflected in the projections?
I did not look at each particular step. My feeling is that it's a fairly steady rise, that there don't seem to be peaks, but I don't quite remember the curve, how it's shaped.
So are you saying that it would be a mistake for a publicly owned utility to commit too much to the natural gas expansion for that reason? Is that a logical conclusion?
I would say that I would say it is a mistake to exclude the benefit that QFs bring of that price certainty in the total context of what the utility is doing.
Thank you.
Thank you.
Thank you. Commissioner Belser.
Thank you, Mr. Chairman. Good afternoon. Thank y'all for being here and for your presentations. Appreciate your work. Ms. Chilton, I want to follow up on the approaches that you've discussed, outlined, that could be used to provide greater revenue certainty to the QFs beyond a 10-year term while seeking to mitigate the risk of the longer term greater than 10 years, mitigate the risk of those longer term contracts to the customers. Could you expand on that a bit?
I think I can do a good job of stating what the intervener has conveyed to me. Not being the intervener, I feel a little limited in how much I can describe the detail of that.
Let me ask you this. Is your response drawing upon your experience in
No. And so I think it is the position of Johnson Development Associates that they would offer a late filed exhibit to the commission where they could describe in more detail the proposals that they would consider workable for that sort of a longer term PPA, but with the ability to look at price in accordance with the Act and for the benefit of the ratepayers.
Commissioner Belser, having negotiated some of these contracts, I might be able to speak to your question.
Okay, thank you, Mr. Levitt.
Just there are a number of mechanisms, but one just to call to your attention is the possibility of having a set of guardrails or a floor and ceiling, if you will. So you would have a longer term contract. It would have the potential for the rate to change from the fixed rate after an initial 10-year period, but the upward and downward adjustment would be fixed or bounded. So there would be the potential for adjustments, but with some limitation on risk to both parties.
They would be bounded irrespective of what that future avoided cost might be?
That's right. You would look at the future avoided costs, and it would provide that the rate could not be adjusted up or down more than a certain amount. So, but it's not unlike a hedge arrangement in that one party is saying, okay, I've got a chance that my price could get worse. I'm going to protect myself against that, but in exchange, I'm going to give up the possibility of getting a much better price. So it's a mutually agreed upon and hopefully mutually beneficial construct.
But if we, as the commission, are having to look after the impact to the ratepayers, and kind of going back to Commissioner Williams' question from earlier, how is that beneficial to the ratepayer if it's wouldn't that be an artificial avoided cost, in that it wouldn't be the true avoided cost at that time?
Well, it would be a contractual arrangement that would be entered into now as an alternative to a longer-term contract at a totally fixed rate. So you're getting the benefit of some adjustments over time. So if this is the alternative to a longer-term fixed-rate contract, would be a partially fixed contract with an adjustment. And as far as the question about ratepayer protection, certainly as you look at avoided costs today and you look at gas price projections today, I think it's hard not to reach the conclusion that the chances are at least as good, if not considerably better, that gas prices are going to be higher in the future rather than lower. What we've experienced to date, when you've heard about this $2 billion impact, is the result of the fact of unprecedented, unexpected, dramatic declines in natural gas pricing due to increased production. And any decision that the utility or this commission made, in hindsight, that you made 10 years ago that wasn't a bet on natural gas, can be said to have had an impact on ratepayers. I think we talked about this last week. So the idea in terms of benefit to ratepayers is you are protecting ratepayers from the potential for substantial increase in their costs by capping the increase at the same time that you would be putting a bound on possible decrease in pricing. So my personal view is that arrangement, given where avoided costs and natural gas prices are today, is more likely to benefit ratepayers than to harm them.
Where have you seen that type of contract? Are you aware of that being done in any state, any other states?
I believe that it has been done. It's been certainly been the subject of negotiations that I've had with a number of utilities as we try to think about these contract tenor issues. Another mechanism that is, arguably even more protective of ratepayers is where you agree to a fixed rate that is based on current calculations or something less than the full 15, 20-year avoided cost calculation. Maybe this is consistent with the Act 62 concept, but it's a lower number. So you don't give the QF the benefit of the full projected avoided cost over the longer term period. And I have been a party, those are some confidential agreements, but the contracts, and actually one that's not confidential is that the Michigan Consumers' new PPA is a 10-year PPA with a 5-year fixed avoided cost rate. So it's a 5-year rate, and then years 6 through 10 are the same rate as year 5. So you don't have any additional increase in the pricing. You don't have additional risk to ratepayers, but you get that longer tenor to make the contract.
Sorry. You said a 5-year rate, and then years 6 through 10 is the same as in year 5. Where's the adjustment coming in?
There isn't. That's what I'm saying. There is no adjustment. So you get the benefit of a longer contract without the rate going up. As you've heard from prior testimony, because of the way avoided cost curves work in the current pricing environment, the longer the PPA is, the higher the avoided cost rate is going to be. The longer the period that you calculate it over, because you've got an upward curve. So it's always going to be higher the longer you go out. So one solution to that and reducing that risk is to compress the pricing so you still have a longer term contract, but you don't allow the rate to escalate as much as it otherwise would.
I'm still not following that, but that's okay. I appreciate your. What's throwing me is when you say you've got the rate, a set rate for years 1 through 5.
Right.
It's a single rate, and then it's the same rate from 6 to 10 as was in years 5.
That's right.
It sounds like the same rate over 10 years.
That's right, but it's lower than the rate would be if you use the 10-year avoided cost rate. That's the point.
It's one single rate for the term of the contract. It's not. The rate is not fluctuating during the contract.
Yeah, actually, in Michigan, it escalates years 1 through 5, and then it stops.
I did not understand the escalation in years 1 through 5.
Well, it escalates in years 1 through 5, and then it stops at the year 5 rate, and that continues through year 6.
All right, I understand that part.
Yeah.
I think the goal, Commissioner Belzer, is that when you are looking at these mechanisms that are potential proposals for this price adjustment moment for the contract, it would not be the case that you could eliminate all risk of uncertainty, up or down for the ratepayer. What you're hopefully doing in developing these mechanisms is reducing the amount of uncertainty so that you are taking away some of the top and taking away some of the bottom and allowing there to be still some risk, because that's inherent when you are looking at anything in the future, but you're also then allowing the degree of certainty that's necessary for a QF to be able to access financing and develop its projects.
Thank you both very much. Appreciate your patience.
Thank you. Commissioner Williams.
Thank you, Mr. Chairman. Ma'am, sir, I definitely don't want to prolong the time. I just want to ask a couple of questions to make sure I understand the testimony the way you intend it to be understood. Obviously, I think you know from the questions that you received from the dais that the commission is concerned about protecting Joe ratepayer. Is that a fair assessment? Okay.
Of course.
And I think understanding the scrutiny that everyone in this industry is under, you could appreciate that if this commission made a decision that resulted in a $2 billion overpayment, that there will probably be new faces on the dais. You appreciate that, right? And so I just want to clearly understand, if you can, explaining to Joe ratepayer why taking such a risk is in his or her benefit.
I would say, Commissioner Williams, that there is risk and there is potential risk and there is potential benefit. And what the commission is doing is balancing the likelihood of both. I think when you look at the the best third-party data we can get our hands on, you are seeing that the potential benefit of locking in lower QF purchases prices now to the ratepayer over time is on balance more likely than the risk. So it is not only a question of risk, although I really do feel for the challenge that the commission faces, because there is that concern for the outcome for the ratepayer front and center for you at every step. But I think one of the things to remember is that the outcome for the ratepayer, if you are locking in low avoided costs now, could be one that is positive. And so that's how I
if I could add a few things. First of all, just to reiterate that point, and to follow up on something I said earlier, I do think that the question that you're asking does need to be put in historical context with respect to energy pricing. So if you ask that question based on a lot of information about where pricing is and how these prices look, I think you might reasonably reach the conclusion that actually locking in today's pricing for a long period of time is a really good opportunity for ratepayers, and that you're running the risk of being here 10 years from now and somebody saying, why in the world didn't you take that deal? Because things are a lot worse. And I think, you know, I can't say for sure, but what I see from dealing with large commercial and industrial customers who are looking at today's pricing and today's avoided cost rates and the rates that we can offer with solar facilities, they're interested in signing up for as long as they can get these rates. So I think that's illustrative. But two other things. One is in terms of protecting ratepayer interests, what we're offering through QF development, as you know, is no risk to the ratepayer with respect to cost overruns, which have been a substantial issue in this state, with delays, with projects that never get built, with projects that don't perform. The ratepayer has zero risk. So one of the huge benefits of independent power production and QFs is you take all those risks off the table for ratepayers, and they are substantial. You know, so I think when you think of, just the last thing I would say is that the alternative to QF development is that the utility comes in here and says, hey, we want to build a $2 billion gas plant, or we want to do something else. And when that decision is put in front of you, you're going to have to make a decision not just for 10 years, but for 20 or 30 or 40 years, that ratepayers are going to pay for that for the rest of the life of that facility, whether it turns out to be a good bet or a good deal or not. So QFs are no different in that regard. Any major infrastructure project that comes before you, you've got to make a decision at that moment in time whether that's the right decision for ratepayers.
Understood. Is there any way to insulate the ratepayer from some of that risk, not just energy prices, but today it was mentioned that there could be new developments in technology that greatly reduces the cost to provide solar energy. I mean, if you think about a 15-year term, the price of a computer 15 years ago was much higher than the price of a computer today. Cell phone technology just keeps improving and obviously drives the price lower. What would you say to that ratepayer if you hit the midpoint and there's just some fantastic technology that comes to market, the QF still would be entitled to their rate per the contract?
When you have built any infrastructure project, the technology that you choose at the time of construction is the technology that you have. Now, Commissioner Irvin did ask some good questions about the adaptability of QFs to, for instance, adding on storage and increasing its dispatchability and other benefits that could come from adopting technological change along with. And certainly the terms of the contract could be made flexible enough to be able to take advantage of technological change. But when you are building any infrastructure project, whether it's a gas generation plant or a solar farm, you are investing in the technology at its best state. Then there are potentially opportunities to replace equipment over time, probably not on a wholesale level, but I think it's more the question of looking, as Commissioner Belzer was asking, for those for a moment within a longer term purchase contract where the price could be examined and you could have it be reflective of the situation, but concern over being able to protect ratepayers from higher avoided costs at that time would be part of that analysis.
Yeah, I think there may be two separate issues. One is how you balance the decision to approve infrastructure at a moment in time, as Ms. Chilton is saying, in the face of the possibility that costs could come down in the future. And that's just something of a balancing act, although in the case of PURPA, Congress has mandated that these facilities be built. Act 62 mandates the facilities be built. So your legislative bodies have sort of made that decision that there is a current obligation on the part of the utilities under your supervision to purchase power from these facilities. But a separate question that's one that I'm quite concerned about is the situation where, and this was discussed by the Duke witnesses, where the avoided costs rates may not have caught up with the technological developments at a moment in time. So that's the situation where, because of where Duke's avoided costs are, that you could have a price that the utility is required to pay to a QF developer that is substantially higher than what that QF developer actually needs to make a reasonable profit. And I would submit that that's not an outcome that we are seeking, given where the avoided costs are at the moment. It's also not one that is a realistic possibility. It has been in the past in some circumstances where the process of approving avoided costs maybe didn't catch up with the technology, and that's a complaint that the utilities have raised, and with some legitimacy. I don't think that's where we are today, as evidenced by the fact that in North Carolina you saw a very competitive process where the average rates in the CPRE program came in substantially above where Duke's proposed avoided cost rates are now. That was the best that we could get anybody to build solar at on a 20-year basis, including Duke itself. So that's an indication to me that where we are at this moment in time is that now they were below the avoided cost cap in North Carolina, considerably below that cap. But I don't think we're at a point in South Carolina right now where the rates that are being proposed would produce anything remotely approaching a windfall to developers. They're going to be hard to finance.
I think rather it's the inverse. In the last several years, the technology has been pushed and pushed and pushed to try to make itself feasible within declining avoided costs. And so I think the QF development community has really looked at every single corner of the development process to try and make it as efficient as possible to bring projects in under what have been declining avoided costs, and I think have successfully done that. So I think that's been more the trend, that the technology has had to follow avoided costs on a lot of the aspects.
I understand. And so it's you all's concern that it shouldn't be a public policy concern that QFs may receive a windfall if a rate is set that some they may consider high, but you may consider appropriate or fair. And then mid-contract, there's some innovation that changes the world of solar energy, and somebody issues a report that shows that a solar CEO is making $20 million. That's just not realistic, right?
If you have a fairly set avoided cost and you have contracted with a QF who is building their facility and adopting that technology, even if technology improves, it would be an expensive proposition for them to go and then adopt that later technology. So they wouldn't be able to, within the confines of the contract they've made, be able to take it. Now, on future QFs, it would be certainly the case that they would look at the new technology and hopefully be able to bring that to bear and to make the QFs even more demand responsive and holistic within the generation landscape within avoided costs at that time. But it's not the case that a new technology leap would be able to be adopted by an existing QF. Just because that's a capital cost that they couldn't do. They're stuck with the PPA they have.
All right. Thank you very much.
Thank you.
Thank you. Commissioners, any other questions? Okay, Mr. Adams, any redirect? Okay, thank you. Okay, thank you, folks, for your testimony today, and you may step down.
Thank you.
Yes, sir.
May the witnesses be excused.
Yes, yes. Okay. Well, it's 5:30. You can't go anywhere anyway. So why not stay here with me? Now, Mr. Adams, I'm sure we got some handing out of stuff for this next panel. Okay, well, why don't we, while I take a 10-minute break, y'all get your papers handed out, and then we'll call the next panel and proceed with that. Thanks.
Yes, sir.
Okay, Mr. Adams.
Yes, sir. SBA calls Ed Burgess, Hamilton Davis, and John Downey to the stand.
If you gentlemen will raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Mr. Chairman, just to be clear about our sort of order of procedure here, Burgess and Davis will be brought back in sir rebuttal. Downey's going to have compressed testimony, so he's going to do his sir rebuttal and direct together, the last one.
Correct. Okay. Got that.
All right. If you're ready, I'll start rolling.
Let her rip.
Yes, sir. All right. Mr. Burgess, please state your name and business address for the record.
My name is Edward Burgess. My business address is 2150 Alston Way, Berkeley, California.
And you work for whom?
Strategy Consulting.
And what do you do for them?
I'm a senior director at Strategy, and I work on our consulting practice in the public and private sector in the power sector.
Are you the same Ed Burgess who caused amended direct testimony to be pre-filed in these proceedings on October the 17th, 2019, consisting of 95 pages?
Correct.
Was your testimony prepared by you and under your direction?
Yes.
Do you have any corrections or changes to that testimony?
Not other than the correction that was already filed.
Well, that it was amended, yes.
Amendment,
That's already been
exactly,
taken care of. That's correct. Mr. Burgess, if I now ask you the same questions that are set forth in your pre-filed amended direct testimony, would your answers from the stand be the same today?
Yes.
Chairman, the Solar Business Alliance would ask that the pre-filed amended direct testimony of Ed Burgess be entered into the record of each docket as if given orally from the stand.
Mr. Burgess's pre-filed amended direct testimony will be entered into the record in each docket as though given orally from the stand.
And Mr. Chairman, we would also ask that his testimony be treated confidentially, which is consistent with our prior motion in that regard.
Okay. Will be treated confidentially.
Yes, sir. Thank you, Mr. Chairman. Mr. Chairman, the Solar Business Alliance would ask that Ed Burgess Exhibit Burgess 1 be identified and marked for each docket.
Mr. Burgess' exhibit will be entered as exhibit number 12.
And Mr. Chairman, just for information, there are two other Burgess exhibits, but they're on sir rebuttal, so I'll save those for later.
Okay.
Yes, sir. Mr. Burgess, have you prepared a summary of your pre-filed direct testimony?
Yes.
Would you please give that now?
Sure. Good afternoon, Commissioners. Thank you for the opportunity to appear here today. My direct testimony is organized into 5 substantive sections. I'll summarize each of these 5 sections, which can be grouped into 2 main parts. First main part deals with certain high-level issues in this case. There are 2 key high-level issues that I address in this first part. Number 1 is the underlying utility incentive structures that may influence Duke's proposed avoided cost rates in this proceeding. In this section, I explain why Duke has an inherent incentive to pursue low avoided cost rates and thus limit the deployment of QF resources. This incentive for low avoided cost rates stems from the fact that QFs have the potential to displace utility-owned generation investments from which Duke has the opportunity to earn a rate of return for its shareholders. Additionally, the incentive for low avoided costs also stems from the fact that Duke has a robust natural gas business in the region, and QF resources would tend to reduce overall demand for natural gas throughput and related commodity sales. Number 2 of the high-level issues is the potential costs and risks to Duke's customers from traditional utility-owned generation resources in contrast to third-party QF resources. The section addresses the fact that QFs present a lower risk profile to Duke's customers since they are not subject to potential cost overruns, not subject to fuel price volatility, provide additional optionality when considering future resource investments, and have compensation that is tied to performance. Regarding cost to Duke's customers, I have also estimated the impact key elements of my proposal would have and found them to be relatively small. For example, adjusting the energy and capacity rates according to my proposal would lead to a change in revenue requirement for QF payments of less than 1% for both DEP and DEC. Meanwhile, this change would be offset by avoided costs elsewhere on Duke's system. The second main part of my direct testimony provides a more detailed analysis and critique of the avoided cost rates that Duke has proposed, and also puts forward a set of alternative rate options for the Commission's consideration. There are 3 main rate components I address. each in a separate section of my testimony. The first two are the avoided energy cost rates and the avoided capacity cost rates. In addition, I also offer testimony regarding Duke's proposed solar integration services charge, and I'm available to answer any questions from the Commission regarding that issue. However, the SBA supports the terms of the stipulation relating to this issue, and I believe the stipulation represents a fair and reasonable resolution of all issues in this proceeding regarding the integration services charge. Moreover, my testimony should not be construed as advocating for any position that is contrary to the terms of the stipulation. The rest of my summary will address the other two rate components, energy and capacity. Regarding Duke's proposed avoided energy cost rates, my direct testimony raises four key issues. Number one is that Duke's modeling results show a significant fraction of hours that have negative avoided costs. Many of these negative values overlap with key solar production hours, such as summer afternoons, which has the effect of reducing the avoided cost rates paid to solar QFs. For example, over 15% of hours from 1 p.m. to 7 p.m. on summer weekdays for both DEC and DEP were negative in Duke's model. While the existence of some negative hours is not impossible or unreasonable, their prevalence raises concerns, in my opinion, about Duke's modeling inputs and assumptions, particularly when it comes to the treatment of elements such as must-run coal resources, which could exacerbate this outcome. I suggest that these issues be further investigated. The second issue is that Duke proposes a single avoided energy cost value for DEP, combining both the DEP East and DEP West systems, despite the fact that the marginal resource is generally different for each system. I suggest that a more location-specific approach be used. The third issue is the selection of 9 pricing periods, which was predetermined by Duke, and which has the potential to skew results for QFs with specific output profiles like solar due to averaging. This contrasts with SBA's proposed 11 periods, which provides a more granular and accurate approach. And fourth is transparency for large QFs. I also raise concerns regarding the differential treatment of large QFs in comparison to the standard offer and the transparency of how avoided cost rates will be calculated for these resources. Regarding Duke's proposed capacity rates, my testimony addresses 3 key issues. First and foremost, I believe that Duke's seasonally weighted allocation of capacity value is overly skewed towards winter mornings versus summer afternoons. This contrasts with the high number of peak load hours Duke has during summer months. I show that a shift in the seasonal allocations can have a disproportionate effect on the capacity revenues for solar QFs. Additionally, I present an alternative seasonal allocation approach for the Commission's consideration. Number 2, under capacity, I believe the assumed capital costs for a new peaker plant selected by Duke were too low, thus reducing overall avoided capacity cost rates. And 3, finally, I present testimony that the timing of the capacity value assumed by Duke may be too narrow, thus reducing overall avoided capacity cost rates. That concludes the summary of my direct testimony.
Thank you, Mr. Burgess. Mr. Chairman, we'll turn to Mr. Davis now. Mr. Davis, please state your name and business address for the record.
Hamilton Davis, 1519 King Street, Charleston, South Carolina.
And for whom do you work?
Southern Current.
And what do you do for them?
I am the Director of Regulatory Affairs, where I oversee our engagements in regulatory proceedings in the states where we're developing projects.
And you're the same Hamilton Davis who caused direct testimony to be pre-filed in these proceedings on September 11, 2019, consisting of 24 pages.
I am.
That testimony was prepared by you or under your direction?
It was.
And do you have any corrections or changes to that testimony?
I do not.
Mr. Davis, if I asked you the same questions that are set forth in your pre-filed direct testimony, would your answers from the stand be the same today?
They would.
Mr. Chairman, the Solar Business Alliance would ask that the pre-filed direct testimony of Hamilton Davis be entered into the record of each docket as if given orally from the stand.
Mr. Davis's pre-filed direct testimony will be entered into the record in each docket as though given orally from the stand.
And Mr. Chairman, I would note that Mr. Davis has no exhibits to that testimony.
Thank you.
Mr. Davis, you have prepared a summary of your pre-filed direct testimony?
I have.
Could you give that now, please?
I will. Mr. Chairman, Commissioners, Commission staff, it's good to be back in front of you again today. We'll be providing an abbreviated summary of my direct testimony so as not to duplicate what this Commission heard from me last week during the Dominion proceeding. My direct testimony begins with an overview of South Carolina Act 62 as it relates to these proceedings, including the Act's goals and the authority and direction given to this commission therein. I illustrate how Act 62 is essentially a reset of utility regulation as it pertains to a range of issues related to the expansion of renewable energy generation and utility resource planning, and how it provides this commission with both increased discretion and direction in determining the most appropriate path forward for energy development in South Carolina. Further, I elaborate on the Act's goals in promoting South Carolina's policy of encouraging renewable energy, including the fact that this commission is directed to address all renewable energy issues in a fair and balanced manner that considers cost and benefits to all customers and establishes just and reasonable rates that reflect changes in the utility industry as a whole, while also recognizing and prioritizing increased competition and consumer choice within the state's electricity marketplace. I then discuss the risks and incentives for utilities, solar developers, and ratepayers inherent in both the traditional cost of service utility business model as well as the solar business model enabled by Act 62 and the Public Utilities Regulatory Act of 1978, or PURPA. My testimony directly acknowledges the financial interest of the SBA in these proceedings and recognizes that it is the Commission's responsibility when evaluating the evidence in this proceeding to consider the financial incentives and biases that influence both solar developers and the utility. I point out that in the entirety of its direct testimony, nowhere does the single Duke witness mention shareholder interest, incentives related to lower avoided cost, or the impact additional competition has on company profits. My testimony also emphasizes the often overlooked risk associated with utility-owned generation that do not exist for third-party owned solar generation because those risks are borne by the small power producer rather than customers. In other words, when generation is owned by small power producers, customers are shielded from these risks. Finally, I provide an overview of PURPA and its implications for energy production in South Carolina. Similar to Act 62, PURPA was established in part to diversify electricity generation resources by encouraging energy production from small power producers. Congress intended PURPA to shift a portion of electric generation away from resources built, owned, and rate-based by vertically integrated monopoly electric utilities that often resulted in cost overruns paid to ratepayers. Among other goals like energy conservation and efficiency, PURPA was intended to inject limited competition into monopsony energy markets where the only legal opportunity for small power producers to sell electricity is to a monopoly utility. That concludes my summary.
Thank you, Mr. Davis. Mr. Chairman, I will turn to Mr. Downey now, if that's all right. And I will just state again that Downey, we're compressing the rebuttal and direct together. Right. Mr. Downey, please state your name and business address for the record.
John Downey, 1519 King Street in Charleston.
And for whom do you work?
Southern Current.
And your responsibilities there?
I am president and CEO. I manage all of the finance and operations of the company.
And you're the same John Downey who caused testimony to be pre-filed in these proceedings on September 11, 2019, consisting of 15 pages?
That is correct.
You're also the same John Downey who caused rebuttal testimony to be pre-filed in these proceedings on October the 11th, 2019, consisting of 5 pages.
That's correct.
Were those testimonies prepared by you or under your direction?
They were.
And do you have any corrections or changes to either set of testimony?
I do not.
Mr. Downey, if I now ask you the same questions that are set forth in your pre-filed direct testimony and in your pre-filed rebuttal, would your answers from the stand be the same today?
Yes, they would.
Mr. Chairman, the Solar Business Alliance would ask that both the pre-filed direct testimony and the pre-filed rebuttal testimony of John Downey be entered into the record of each docket as if given orally from the stand.
Mr. Downey's pre-filed direct testimony and pre-filed rebuttal testimony will be entered into the record in both dockets as though given orally from the stand.
Thank you, Mr. Chairman, and Mr. Downey has no exhibits, so we don't have to deal with that. Mr. Downey, have you prepared a summary of both sets of your testimony?
I have.
Could you please provide that to the Commission?
Sure. Mr. Chairman, Commissioners, and Commission staff, it's good to be back with you today. Because my direct testimony for this proceeding is similar to the direct testimony filed in the Dominion proceeding, which you heard last week, I'll be providing an abbreviated summary of my direct testimony here today, as well as a summary of my sub-rebuttal testimony that is responsive to Duke's rebuttal testimony in this proceeding. As a business owner and the CEO of a successful energy company, my testimony is intended to provide this commission with additional insight into the economic development perspective of companies like Southern Current, including the operational processes, risks, and underlying regulatory and policy frameworks that support increased competition in electric generation. In addition, my testimony explains how businesses like Southern Current help to elevate South Carolina's economic competitiveness and deliver value to ratepayers by reducing risk and increasing stability in electricity rates. As this commission is aware, Southern Current is a South Carolina-based company that employs over 100 full-time employees, and we continue to grow our workforce as state markets like South Carolina begin to foster additional investment opportunities through increased competition. My written testimony provides a more complete overview of Southern Current and a high-level description of the company's investment portfolio of solar assets, as well as an outline of the steps and investments necessary to bring a solar project to the point of executing a power purchase agreement, including the financial risks assumed by solar developers. My testimony then contrasts the risks from third-party-owned solar assets with the risk borne by ratepayers under the traditional cost-of-service utility business model. All project revenue paid to a solar developer is determined by the avoided cost rates approved by this commission, which are fixed in the PPA and are not subject to upward adjustment for unforeseen costs. By having a solar developer bear cost risks throughout the project development process, ratepayers are shielded from escalating project costs that can accompany utility-owned generation resources. Ultimately, solar developers like Southern Current knowingly take on these risks so that we have an opportunity to compete for electricity sales in this type of market. Finally, my testimony explains the importance of state and federal policies like Act 62 and PURPA for enabling effective competition in monopsony energy markets like South Carolina, as well as the spectrum of benefits that flow from that competition to the state's businesses and citizens. Act 62 was passed unanimously by the General Assembly with the benefits of competition and consumer choice in mind. Proper implementation of Act 62 will do many things, but most importantly, it will continue to expand a marketplace that historically has been limiting for small power producers. My sub-rebuttal testimony focuses on the rebuttal testimony of Duke Witness Brown, which makes a number of erroneous claims related to the benefits that accrue to ratepayers from QF solar development and the nature of competition in monopsony markets like South Carolina. My sub-rebuttal testimony notes that PURPA's principal goals include controlling power generation costs and ensuring long-term economic growth by reducing the nation's reliance on oil and gas. Similar to Act 62, PURPA was designed to diversify electric generation resources by encouraging energy production from small power producers and to shift a portion of electric generation away from resources built, owned, and rate-based by vertically integrated monopoly electric utilities, which often result in cost overruns paid by ratepayers. In contrast to Witness Brown's claims to the contrary, ratepayers do benefit from proper PURPA implementation, just as the General Assembly expects customers to benefit from the proper implementation of Act 62. In his rebuttal testimony, Witness Brown also misconstrues the ways in which PURPA functions as a substitute, albeit an imperfect one, for the free market. It's important to remember that when the South Carolina General Assembly passed Act 62 in an effort to promote the state's policy of encouraging renewable energy, it chose PURPA as one of the primary mechanisms for bringing the benefits of solar to utility customers. In a PURPA-driven market like South Carolina, small power producers are competing at multiple levels to successfully develop projects. Identifying and purchasing the rights to viable land with access to adequate electricity infrastructure places small power producers in competition not only with each other, but also with other land use alternatives like farming, timbering, and development. Assuming development rights are acquired for a viable site, the small power producer is then competing against the utility's cost of energy and capacity. That means a small power producer must be able to compete on price with a monopoly that enjoys a guaranteed rate of return on its capital investment, which it receives from a captive rate base. The small power producer is also competing against the price of fuel purchased by the utility from the marketplace. For example, small power producers are now primarily competing against historically low natural gas prices for the value of energy. Developers in South Carolina also directly compete with developers in other states for a limited pool of private investment. As Duke has made QF solar development in South Carolina more difficult, while other states and utilities have made solar development more inviting, attracting capital is becoming increasingly difficult. It's important to note that this often outside investment in our state produces tax revenues that are important to many of the counties in which we operate and also serves to upgrade the grid at no cost to the ratepayer. Ultimately, the price signal sent to the small power producers in vertically integrated markets like South Carolina is set based on the utilities cost. And if small power producers can't meet or beat that cost, then they can't sell their product in South Carolina. Every aspect of the solar industry is competitive, as evidenced by the constant innovation and price declines that have driven increasing solar development for over a decade across the country. Small power producers that can't manage cost and risk in this dynamic business environment simply fail. There is no cost recovery for abandoned solar projects that couldn't make the cut. This concludes my summary.
Thank you, Mr. Downey. Mr. Chairman, these witnesses are available for cross and commission questions.
Thank you. Is there any cross-examination from the parties? Okay, then from company.
Mr. Chairman, recognizing it's after 6 o'clock, I guess I'll start with the good news that I don't have any questions for Mr. Downey or Mr. Davis. The bad news is I do have a good number of questions for Mr. Burgess, so it's probably going to go at least 30, 45 minutes. I'll do my best to be expeditious, but these are important issues that I want to make sure the Commission hears. So just wanted to advise you of that up front.
I'm going to be here till you finish, so.
Understood. All right. Mr. Davis, or excuse me, Mr. Burgess, good evening. My name is Brett Breichwert on behalf of Duke Energy Carolinas, Duke Energy Progress. How are you this evening? Doing all right. So just a little bit about your background. You testify on page 5 of your testimony that Strategen, the company where you're a director, was selected by the Solar Business Alliance to support these proceedings. And this was to implement PURPA here in the state of South Carolina. When were you retained by the Solar Business Alliance?
I don't recall the exact date, but I believe it was in the July-August timeframe.
So after Act 62 was enacted?
Correct.
And so you were not involved in any way in the development of Act 62 or its passage, is that correct?
That's correct.
All right, thank you. And just reviewing your bio and your background, it looks like you've done a lot of work for the solar industry in the southwestern United States. Is that fair?
Yeah, that's fair.
And have you been retained by the solar industry in other states to testify about PURPA implementation?
In other states, I've testified on solar issues and a range of issues relating to value of solar and have relevance to PURPA. Yeah.
Let me ask it a different way. Is this the first time that you've critiqued a utility's avoided capacity and energy costs in a proceeding such as this where you filed testimony?
Not on avoided cost per se, but I guess in the exact context of South Carolina's implementation of PURPA, yes.
So let me ask it more precisely. The avoided costs paid to qualifying facility generators under PURPA, is this the first testimony where you've submitted testimony critiquing a utility's avoided costs?
Personally, yes.
Thank you. So I want to talk about your testimony and this concept of methodological bias. Would you agree with me, or subject to check, accept that your direct testimony uses the words bias or biased 24 times to characterize Duke's development of avoided costs?
That may be true. I haven't counted.
It seems like a lot to use a word like bias over 20 times in testimony. Would you agree?
I mean, it was a long testimony, so.
That it was. So if you turn to page 10 of your testimony, please. So one of the earliest points where you take on this, or present this theme of bias, you assert at lines 15 through 17 that Duke has made many small but meaningful methodological choices that each drive down the avoided cost rates and in the aggregate are significantly biased against solar QFs. Is that your testimony?
Yes.
And so you were retained in the June-July timeframe to review the company's application. And since you reviewed it, you've made the determination based on your investigation that it was many methodological choices were made significantly to drive down rates in a manner that's significantly biased against solar QFs. That's your testimony.
Yes, and I addressed this also in my SIR rebuttal as well, the critique on that point, yeah.
So I'd like to ask you some questions about that, but I have to wait. But I think the point I'm trying to make is, at the same time that you, on behalf of the Solar Business Alliance, in your first time testifying, critiquing the avoided cost rates of a utility, were investigating Duke Energy's avoided cost, there was another party who had hired an independent expert with a lot of experience in avoided costs who was similarly analyzing those avoided costs and the recommendations Duke put forward to say, are these reasonable? Are they just and reasonable and fair to QFs and the utility? And that was E3 on behalf of the ORS. Would you agree with that?
Are you asking me to characterize E3's testimony on this? Or?
I think we'll get to that, but I'm just establishing the point that in parallel with you reviewing the company's application, E3 was doing the same thing. They were looking at that application and saying, is this reasonable? Does it meet the requirements of Act 62? Does it meet the requirements of PURPA?
Well, I wouldn't say they did the exact same thing or had the exact same client, but yeah, generally they were doing a similar thing.
I agree they didn't have the exact same client, and I think that's why they didn't do the exact same thing. But that's part of what I'm trying to establish here. So is it fair to say, sir, this is not your witness.
Wait, direct up here.
Excuse me, you're right. Thank you, Mr. Chairman. That, one, it's not his witness, and two, I will do my best to focus my questions as questions, but it is cross-examination.
Get to the microphone, please.
It's appropriate for any party to object to that line of testifying, Mr. Chairman, and I would ask that you please instruct the lawyer not to testify from the well.
Okay, I'm going to sustain. Please be just a little more judicious in not testifying, but asking the questions.
Yes, sir. So continuing with this theme of bias, as you've alleged in your testimony, do you think E3, the ORS consultant, is less qualified than your firm to analyze Duke's avoided costs?
I haven't passed any judgment on E3's qualifications in my testimony. I think they're a perfectly well qualified firm to evaluate, these issues, and, they've done so on behalf of ORS in this case.
And isn't it true there are a number of areas where ORS finds Duke's avoided cost rate calculations reasonable that you allege are significantly biased against solar QFs?
I haven't really done a direct comparison of, my testimony versus
Fair enough.
ORS's. So
turn to page 11 of your testimony, please. And so page 11, maybe if we could just briefly start on page 10, lines 19 going forward. This is where you provide a list of factors that appear to be biased against solar QFs. Is that correct?
That's correct, yes.
So turning over to the bullets on page 11, the first bullet, the selection of time periods used to calculate the avoided energy cost rates. Would you agree with me that while you allege that to be biased against solar QFs, that ORS's expert in his testimony generally found that to be reasonable and didn't propose any modifications to Duke's avoided energy cost rates?
Again, I don't know exactly what, testimony of E3s you're referring to, but I don't know if they, how thoroughly they've examined this issue or not. But yeah, I think that sounds reasonable of what they said, yeah.
And similarly, the second issue you raised, isn't it fair to say that the testimony from E3's witness, Mr. Horry, similarly did not identify that there was any inappropriate modeling or inaccuracy in the modeling related to the negative energy hours that were put forward by Mr. Snyder in calculating Duke's avoided energy cost rates?
Sorry, could you repeat the question?
Sure. So the second bullet is your premise that Duke's quantification or modeling of its avoided energy cost is biased against QFs because there are a number of avoided cost hours that are negative, leading to lower final avoided cost rates. And I'm making the point that ORS's expert, Mr. Horry, in his review, did not come to the same conclusion. There was no determination that those were inappropriate or biased. Is that correct?
It may be, but experts come to different conclusions all the time.
Based on, I think as you said earlier, who the client is that they're representing.
Not necessarily. It could be different expert opinions.
And I'll just briefly go through the rest of it. Subject to check, would you agree that ORS's expert did not disagree with the company's quantification of avoided energy costs based on segregating out DEP East and DEP West, third bullet? Similarly, they didn't take issue with the capital cost of the CT unit that Duke Energy put forward to calculate avoided capacity rates. Is that correct?
Yeah, I mean, I get where you're going with this.
Thank you. So in all of these instances, with the exception of seasonal allocation, which there is one difference of opinion between Duke's testimony and the ORS's testimony.
Mr. Chairman, I understand this isn't my witness. I do feel compelled to jump up. Mr. White, I apologize if I mispronounced that, has characterized ORS's testimony over and over again, and I just feel compelled, at least in this instance, it seems like a mischaracterization of one instance in which we disagree. Well, there are numerous instances in which we agree. There are also other instances in which we disagree.
That's fair enough, and I'll move on. I think I've made this point pretty good.
Okay. I agree.
So if you could turn to page 13 of your testimony, you introduce this concept of a zone of reasonableness. Is that true?
Yes.
And on line 1, you talk about QF rates must be developed based on a credible analysis of the utilities avoided costs within the bounds of uncertain inputs and methods, which you then generally characterize as the zone of reasonableness.
Correct.
And I want to explore with you whether this concept of a zone of reasonableness is something that, to your knowledge, has ever been applied in the context of quantifying utility avoided costs under PURPA before. It's true, is it not, that you are not aware of any decision by the Federal Energy Regulatory that's applied this zone of reasonableness concept in the orders of the FERC to calculate avoided costs or otherwise implement PURPA? Would you agree with that?
I would say that the concept has been applied by FERC before on several issues. I think I don't know specifically about whether it's been applied in a PURPA case or not, but it is a general concept that has been applied by FERC in other cases.
So I think your testimony, and this may be beyond, what other cases has it been applied?
I referred to some of those in my rebuttal.
Okay, we might get there. But the key point that I'm establishing, would you agree that, as far as you're aware, in quantifying avoided costs, FERC in its original Order 69 rulemaking order and any orders subsequent to that implementing PURPA and the recent Notice of Proposed Rulemaking, they've never applied this zone of reasonableness concept that you're asking the South Carolina Commission to adopt in this proceeding to lean towards the higher end of avoided cost rates. Is that accurate?
I'd say that's a mischaracterization of what I said. I was simply pointing out the fact that there is a range of possible outcomes here, and that's the concept of the zone of reasonableness. So I think that, that's sort of just inherent in the nature of how avoided costs are determined, and I think it's reasonable to consider that concept in any avoided cost case, whether it's PURPA or not.
Just to close this out, it's also true that you're not aware of any state commissions like this commission responsible for implementing PURPA that have written an order that said we are taking into consideration a zone of reasonableness in applying PURPA to set a utility's avoided costs.
I mean, using those specific words, I don't know, but I mean, I think it's just a general concept that I think, I haven't done an exhaustive legal analysis to determine that, and I'm not a lawyer, so, there may be other instances where that concept is applied, even if it's not those words.
But to the best of your knowledge,
that's my knowledge.
Precedent.
Right.
Thank you. Have you had a chance to review George Brown's rebuttal testimony?
I did briefly review it, although I may not recall specific details from that.
Are you familiar with his testimony on the indifference principle that he set forward?
You might have to refresh my memory on that.
Mr. Chairman, I would like to use the Elmo briefly. I'm not exactly sure what magic button I need to hit, or y'all. Thank you, sir.
It's on.
I appreciate it. And it perfectly was set up, too. So, Mr. Brown speaks to this Southern California Edison case from FERC, 1995, and move this down a little bit just so we can.
Make sure you speak up real good, because you're fading out here and there. Yeah. Well,
All right. So, in this decision, maybe just to cut to the end, I'll read the beginning. So the FERC said when they were reviewing the California Commission's implementation of PURPA that in promoting the goals of greater fuel diversity, however, Congress was not asking utilities and utility ratepayers to pay more than they otherwise would have paid for power. PURPA requires an electric utility to purchase power from a QF, but only if the QF sells at a price no higher than the cost the utility would have incurred for the power if it had purchased the QF's energy and/or capacity, i.e. would have generated itself or purchased from another source. The intention was to make ratepayers indifferent as to whether the utility used more traditional sources of power or the newly encouraged alternatives. I hope you were able to see all that. Did I read that correctly?
Yes.
Okay. And you heard Mr. Snyder this morning speak to the indifference principle of PURPA?
Yes.
And so your testimony doesn't reference that foundational indifference principle in the 198 pages of direct testimony and another 20 pages of rebuttal testimony in any way. Is that accurate?
I think it was less than 198, but...
I'm sorry. I think it was 119 in total. Just
okay. Well, right. I mean, I think that the concept of indifference, presupposes that we know exactly what that avoided cost will be. How can you be indifferent to something if you don't, if you're trying to set a rate that's completely indifferent, but you don't know exactly what the avoided cost will be in 5-10 years? That's the notion that I was trying to get across. And, no, I didn't mention indifference specifically, but, I think that there's that underlying concept there.
If you could turn to page 39 of your testimony, please. In this section, you are addressing the avoided energy rate design.
Page 39, you said?
Yes, sir.
Okay.
And on starting on line 5, you explained that the arbitrary selection of time periods undervalues the true daytime avoided cost, thereby biasing against daytime QF production such as solar power. Different selection of pricing periods would be more accurately reflect avoided costs can have significantly affect solar compensation. Did I read that testimony correctly? So is it fair to say that when you say that the company's avoided energy rate design is biased against daytime QF production, that's because the energy rate design, as you testify, significantly affects the compensation for solar QFs? That's the focus of how you're proposing to modify the rate design. Is that accurate?
Well, I would perhaps this wording isn't quite right, but I think that the point is that the effect of the rate design that's been put forward by Duke has that outcome of reducing the revenue for a solar QF project, whereas it's not based on what the underlying avoided cost is. It's just simply what the selection of the pricing periods was. So that causes a difference in what the outcome is for the solar QF in terms of the revenue they receive. And so whether it was intentional or not, there is that effect.
And isn't it true that the revenue they receive is dictated by when they are able to generate, deliver power, and the fact that solar is fuel source limited, meaning it can't dispatch its power to meet the utility's peak needs, is why their compensation is, to your client's view, negatively affected by the rate design?
If it's a standalone solar project, yeah, without any storage coupled with it, then that would be true, yeah.
And are you aware how many solar plus storage projects are installed in the Carolinas today?
I understand that it may be very few or maybe none yet, but there are solar plus storage projects being developed all around the country now, and it's coming.
Fair enough. All right, I want to turn to your testimony starting at page 54, focused on the combustion turbine cost, or CT costs, used in calculating avoided costs. You make a number of adjustments in this section. You argue that Duke's proposed avoided CT unit used in calculating avoided cost, this is on page 54, is potentially biased against QFs. And you recommend a number of adjustments to the avoided CT costs that would, and this, sorry, I've lost my place here, I apologize. Would you turn to page 60, line 10 of your testimony?
Okay. I have, this is a redacted version, so I may not be able to read every word.
Okay. Would you agree with me that your proposed adjusted CT cost is 104% higher than the CT costs that Duke has put forward in this proceeding?
I think that could be true.
All right. And returning to your specific recommendation back on 54, we're talking about the CT that Duke has proposed to use. It is an F-frame CT, is that correct?
You need to get to a microphone.
Mr. Chair and Mr. Bridgeford, I apologize for interrupting the question. I just wondered if I could provide the witness with an unredacted version of his testimony so that he could have that to review.
Please.
Okay. Certainly.
Sorry, the question again?
So the specific CT technology that Duke has put forward in this proceeding is an F-frame CT, correct?
That's my understanding, yeah.
It's based on Energy Information Administration publicly available data, as you heard Mr. Snyder say this morning.
Yeah, I believe that the EIA characterizes it as an advanced CT, and which I understand to be a frame as you're describing.
And your alternative proposal in your test, Mr. Snowden, does he have testimony that he needs? That's all right.
Okay, let's make sure too, we're in some of this is confidential, so let's tread lightly there.
And Mr. Chairman, I think one of the issues is that I will tread lightly. Some of the information that SBA designated as confidential is perhaps broader than what the company's designated as needing to be confidential. So I'm going to try to be cautious as well.
Yeah, it was based on everything that was confidential in ours was what was marked confidential by Duke or derived from that. So that's why there's a lot in there.
Very broadly derived from even the footnotes referencing what was confidential. But let's keep moving here. So on page 54 of your testimony, line 19, you argue that using a higher cost aeroderivative CT should be considered instead of Duke's F-frame CT. And you say that this is because the F-frame unit does not necessarily correspond to the cost of the peaking unit that Duke would ultimately select to meet future peak demand or provide other services. Is that accurate?
Yes.
And did you investigate whether Duke has F-class CTs installed on its system today?
I didn't do a thorough review, but I imagine it's likely, yeah.
And did you have a chance to review Mr. Snyder's rebuttal testimony on this topic?
I did take a look at that, yes.
Okay. So I'm presenting you with page 41 of his rebuttal testimony at lines 12 through 18. Visible there. So he specifically answers the question that I was just asking of you of do the companies have any F-class CTs currently in service? And the answer based on the real world here in the Carolinas is that yes, they have multiple F-class CTs in simple cycle mode at Rockingham, Asheville, Smith, and the Wayne sites. And they also have multiple F-class CTs in combined cycle mode at Buck, Dan River, Lee, Smith, and Sutton. Yeah. And you didn't investigate whether the companies have F-frame CTs installed on the system when you were considering what would be the appropriate avoided unit in quantifying avoided costs.
So these are all existing units, correct?
That's correct.
Right, and so avoided cost is on a forward-going basis. So I don't really see the relevance of looking at existing CT units. And so really, what I was trying to do is understand what would be, on a forward-going basis, the type of investment that would be, sorry, Siri is right here with me. In any case, on a forward-going basis, based on what the trends in the market have been recently in terms of new peaker plants being built around the country, not just here in the Carolinas, but, all around the country, and we're seeing a greater trend towards not just frame CTs, but also a lot of aeroderivatives. And so, based on observing those trends in places like PJM and elsewhere, that, in my determination, it may not be appropriate to consider only what's existing on Duke's system now on a going forward basis.
So we should look at what Duke is going to install on its system in the future to make a determination of what's the avoidable CT unit. Is that your testimony?
Well, I think we can look at what Duke is claiming now, but I've also observed that there's many utilities who have put forward resource plans that they've made investment decisions later that diverge from those plans too. So that's something else to consider.
Mr. Chairman, this is not in the record at this point. It's the company's public integrated resource plan recently filed with the Commission in early September. I don't think it needs to be made into an exhibit. I'll just briefly ask some questions about it, and I've got a full copy here if the witness would like to see it.
Mr. Chairman, may I ask for some clarification, please?
Yes, ma'am.
I understand that Mr. Burgess is put up his direct testimony, and he will be coming back up for rebuttal. Is that correct?
That was my understanding, yeah.
And we're reaching in, his surrebuttal, and we're reaching into somebody's rebuttal testimony for cross on direct. That seems to be a bit out of whack. It seems that cross ought to be on his direct, and if you're going to question about rebuttal, that ought to be when he's back up here on his rebuttal. Is that not correct?
Well, I am establishing the point that on Duke's system, there are F-frame CTs, and that is based on Mr. Snyder's rebuttal testimony. That is a fair point, but it's based on statements that Mr. Burgess made in his direct testimony that we're referencing, which is what is the appropriate avoided CT unit, a F-frame CT unit as Duke has put forward, or an alternative proposal of an aeroderivative CT unit as Mr. Burgess has.
I'm just getting confused when Duke asked to be able to put up direct and then rebuttal separately, and so I'm getting a bit confused when we're delving into rebuttal, asking questions. But I see the point on
Yes,
this
ma'am.
one.
I had not fully thought that through, and I apologize, but I'll move on from that point.
I have to keep things in order. I'm sorry.
It's been a long day, and I am doing my
I
best
appreciate it. Thank you very much.
fly through this. Apologies. So specific to the conversation we were having, I think my question to you was, should we focus on the, you said the CT units on Duke's system are not determinative of what the avoided unit will be. That was your testimony a few moments ago?
Right.
And so then we were talking through, isn't it correct that we should take into consideration what Duke actually plans to build on its system in the future in determining what that avoided CT unit is going to be? Would you agree with me there?
Yes, with the caveat that, as I mentioned, sometimes future investment decisions do diverge from what's planned, and we've actually seen that in some of these types of planning processes where, what we think is going to be built maybe 5-10 years down the road is not exactly what is decided, to be procured at that time.
But would you agree with me that DEC's 2019 IRP, as recently filed with the Commission, identifies that the F-frame CT unit is the planned unit subject to check, and that G and H-frame CTs were not considered in the updated IRP?
Subject to check, yeah, that sounds reasonable.
And is it fair to say that you went and found Dominion Energy Virginia's cost of an aeroderivative CT unit because Duke doesn't put forward an aeroderivative CT cost in their IRP because they're not planning to build them?
No, I believe Duke does have an aeroderivative cost in its plan. In fact, in my figure 4 there, I put the figure that includes that. Now, I don't believe it was selected in the plan, but it is one that's considered by Duke in their planning process, I believe.
Generally considered, but it's not selected in the plan. There was no cost input that you could then use to make your recommendation. Is that accurate?
I didn't have access to the underlying data when I was preparing my testimony from this chart, but as I mentioned in my rebuttal testimony, you could easily use that.
Well, I'm going to stay away from your rebuttal just to keep myself at this late hour out of trouble. So just briefly on Dominion Energy Virginia's use of an aeroderivative CT, you pointed to their 2018 IRP. I'll withdraw the question because I'm venturing into Mr. Snyder's rebuttal again where he rebuts this point. We'll come back to it at a later time. I'll move on. So on page 58 of your testimony, could you turn there, please? You argue that Duke inappropriately did not consider network upgrades on the transmission system as an avoided cost from purchasing power from QFs. Is that your testimony?
Which line are you referring to?
Starting on line 15, what other factors may be underestimated in the peaker plant capital costs in Duke's proposal? You say on line 19, as Duke acknowledged, the EIA estimate of assumed peaker plant capital costs does not include significant transmission upgrades.
Right.
That's your testimony?
Yep.
And then on line 59, on page 59, starting at line 4, you come up with an alternative transmission upgrade related cost that you assert should be included in quantifying the avoided CT cost. Is that accurate?
Sure.
And you put forward that is based on Xcel Energy's 2016 to 2030 Upper Midwest Resource Plan. Is that true?
Right.
And what is that resource plan? Is that the equivalent of their integrated resource plan as it would be filed here in South Carolina?
Essentially, it is, yeah.
Okay. And the dollar cost figure that you put forward for that transmission associated with the transmission upgrades from Minnesota Xcel's IRP was $152 per kW. Is that correct?
Yeah, that's correct.
And then you say to be more conservative, you're just going to put forward $120 per kW to be included in Duke's avoided cost calculation. Is that correct?
That's correct.
And what analysis did you do to determine that $120 was reasonable, appropriate, or is it just less than $152?
Well, as Duke has testified many times in this proceeding, I think there's a general concern about wanting to protect ratepayers from, costs of high avoided costs. So, this was an attempt to try to address that issue and, be a little bit more conservative on what the avoided cost might be, because I think, $152 for Minnesota, I think that if you were to look at an avoided cost of transmission in South Carolina, it might be a little bit different. And I was trying to err on the side of being a little more conservative there.
So there was no analysis underlying that $120 per kW. It was a judgment call on your part that was less than the $152 in the Xcel's IRP.
Yes, it was a judgment call that I wanted to reduce that value by a certain percentage, and that's where the 120 came from.
And are you aware? So just to make sure we're all clear on what we're talking about here, these are network upgrades. This is not. So there's the combustion turbine, then there's the interconnection facilities, and then there's the network upgrades out on the transmission system. Do you agree with that?
Yes, I understand all those components.
And is it fair to say that Duke Energy did include interconnection facilities in quantifying its avoided cost, but your critique is that they did not include network upgrades? Is that accurate?
So I don't know if I don't recall if Duke specified whether it was what was an interconnection cost or what was a network upgrade cost, but I think that was and I don't think in the case of this Xcel number, I mean this was included in their essentially the generation cost that they have in their IRP. They have an added cost to the base cost of the CT unit, and so again, I don't know if they differentiate whether that's an interconnection or a network upgrade cost, but that's additive to essentially the cost of the generation unit. So applying the same principle here, that was an attempt to take the same approach. And I believe that in the case of Dominion, there was also a transmission added on top of the EIA number that was used in their case, the assumed cost of the generation and then additional transmission component that was added.
So I want to stick with Minnesota and then we can move to Dominion. But isn't it true, to the best of your knowledge, that when Minnesota Xcel Energy calculates avoided costs, they are not including transmission upgrades out on or network upgrades out on the transmission system? Do you have any basis?
Well, in this case, in this resource planning process, they do include these transmission costs as part of the overall cost of that generator when they're looking to see what, the potential cost of generation addition on their system is, which is, the equivalent, for avoided cost, and they do include that.
But you don't have any basis to say that the avoided cost rates approved by the Minnesota Public Utilities Commission for Xcel Minnesota include an assumed network upgrade cost in quantifying those avoided cost rates, do you?
I'm not sure I understand the question. You're saying that.
Let me ask a different
again?
question.
Yeah.
Would you agree with me that network upgrades are different from interconnection facilities in terms of whether they're, what side of the point of interconnection they're on? They're either on the generator side or on the bulk electric system transmission side. Is that fair?
Yeah, that's a fair point.
Okay. And so when a generator interconnects to the transmission system, they will fund their interconnection facilities, and so those are included in the cost of the generator, and those are always required. Is that fair? Interconnection facilities, for any generator, you must build the facilities needed to interconnect them, whether it's solar, CT, what have you.
Right.
Okay. But transmission upgrades out on the bulk electric system, this significant costs you're identifying here, those are not always required. Is that correct?
Not always, but there are cases where they may be, and then there need to be some sort of cost allocation determination for that. Yeah.
Are you aware? So, wouldn't you agree with me that the Minnesota Commission, or let me just ask it this way: are you aware whether the Minnesota Commission, in setting the avoided cost rates, considered a network upgrade adder to those avoided cost rates as included in the avoided capacity cost?
I don't know.
Okay. You also mentioned Dominion Energy in South Carolina's application and suggested that they include a transmission cost in their quantification of avoided capacity. You recall that?
Correct, yeah.
Do you know what the dollar per kW is that they include?
Not off the top of my head, no.
Would you accept, subject to check, that it's $10.75?
It could be, although I think they apply that on an annualized basis too.
Would you agree with me that Dominion at $10.75 for a generic transmission plant included in their quantification of avoided capacity costs is significantly lower than your conservative value of $120 per kW? So it's 11 times lower. Is that fair to say?
Right, but if this were on an annualized basis, it would be different. It would be, depends on the life of the asset. So
I think they're both on apples to apples basis, is my understanding.
I'm not sure I agree with that.
Do you have any basis to support your position that Dominion's transmission costs are network upgrades and not the interconnection facilities that they've characterized as transmission, that they're actually upgrades to the bulk electric system in excess of what their interconnection facilities cost that are includable in the cost of the CT?
Sorry, you have to repeat that.
Sure. So do you have any basis to support your contention that Dominion, when they have a transmission cost, that they're talking about bulk electric system transmission upgrades, not interconnection facilities? So they've put forward $10.75 as generic transmission, which is, in my understanding, equivalent to what Duke put forward as interconnection facilities, which is significantly different than what you've presented as the network upgrade cost that should be included in calculating the avoided CT cost.
So you're saying, are you asking if there's just different approaches between the three cases?
I'm asking, yes, I'm asking, do you have any basis to know that the much lower value that Dominion puts forward is not really, while it's called transmission generically, it's not just the same interconnection facilities that Duke includes in its avoided CT unit?
I don't know. It's hard to say. There was very little detail provided in Dominion's filing, so it's hard to say for sure.
Okay. Mr. Chairman, in the interest of time, I think I'm going to wrap up. It sounds like I've got a good number of things to talk about on Sir rebuttal potentially.
Okay, thank you. Commissioners. One more chance. Okay, any redirect?
I will try to be very brief. Mr. Burgess, want to reference the FERC decision that Mr. Breitschwert left up on the Elmo here for a good period of time. I think it's down now. Were you familiar with that case? I believe it was cited in regard to the zone of reasonableness.
Sorry, which case?
And I'm sure the California Edison case.
Mr. Chairman, respectfully, if Mr. Snowden did not sponsor this witness, I guess I'm just curious why he's now doing the redirect. I'm new to the commission here, but it's always been the practice, at least my understanding, that if you're sponsoring a witness, then you are also the person to put forward the redirect of that witness. But
Mr. Chairman, I would just ask for a little latitude on this. It is almost 7 o'clock at night. This is going to take about 5 minutes. Let's just let him do what he needs to do. Rather than have me get up there and read the notes that he prepared, I would rather just let Ben do his job. We think it would be quicker for Mr. Adams. Mr. Ellaby, I like you, but you're wrong about that.
Let's just.
This was done in the merger case, by the way, Mr. Chairman. So this is not. There is precedent for this.
Understand. Okay, let's just continue on, Mr. Snowden. Let's get this done.
Okay, I'll be very, very brief. Okay. With regard to the California Edison case, I believe it was cited in one of the Duke witnesses' testimony with regard to the show that avoided costs rates should not exceed avoided costs calculations. You recall that? Mm-hmm. Okay, and you were aware that in that case, that FERC was considering a pricing scheme for PURPA projects that was not intended to match avoided costs, but actually resulted in in rates for PURPA projects that were well in excess of anything close to the avoided cost rate. Do you recall that?
That sounds familiar, yeah.
Okay, all right, thank you. This is in regard to the discussion of error derivative CTs and F-frame CTs. So I heard you to testify that it's your opinion that in looking at what the avoided units are going to be, that we should be looking to the future, to what will realistically be installed in the system in the future rather than what's on the system now. Is that right?
That's correct.
Okay, and did you do you recall earlier today Mr. Snyder said that the company's plan for dealing with the capacity gap that would be caused by those accelerated retirements of coal units? Do you recall what he said about what the company would do to make up that capacity gap?
Yeah, I believe he mentioned something about installing new generation or replacement generation that was more efficient, or yeah.
Did he say high efficiency
high
gas
efficiency
turbines?
Yeah, yeah, which I presume would be some kind of a combined cycle gas or something like that.
Okay, but probably not one of the like one of the units that's already on the system.
Right.
Okay, thank you. No further questions.
Mm-hmm.
Thank you. Any recross? Okay, thank you. Okay, so I think we're finished with you, this panel. Thank you for your testimony, and you may step down, and you may be excused, Mr. Downey. Okay, everybody standing up. Microphone. That's a good plan. Okay. We'll,
I thought he had something he was going to go quickly. I would just say, because we have some sworn witnesses today who are testifying tomorrow, that perhaps an admonition from the commission not to consult with attorneys overnight.
everybody that's under oath still, please don't consult with your attorneys overnight. There's your admonition. Okay. Anything else we need to do? Okay, we will begin with the next group tomorrow morning, and we are adjourned till 9 o'clock.